A cop shot inside her home. Her baby ripped from her arms. 2 different stories, 1 judge to decide it all. It starts today, everybody. It's the Commonwealth versus Kelsey Fitzsimmons. So let's get started. Well, good morning, everybody. It's Monday, March 23rd, and as we all know, is the start of the bench trial in the Kelsey Fitzsimmons case. I'm trying to decide because it's just me this morning, no husband of mine. Well, which station to stream this on? I mean, is Court TV not an option? It's like the fatal friendship. There's like nothing here. All right, I'm coming back to look at the chat because morning, guys. Hi, everybody. Wow. CP T Jaxie's real worried about there being no Bob. Real worried. Well, isn't professional curiosity lucky? It's lunchtime in the UK. I'm exhausted. Can't tell by my face, which I'm sure you can. But I did get up early, and then of course Scarlett missed the bus, and the dog needed this, and all of a sudden I had 1 minute left, so that's what happened. Welcome to new members. L. Sully and Allie B from Tennessee. I've heard that name before, Allie B from Tennessee. All right, so yeah, I don't know. Oh, Boston. Okay. Thanks, Mastad. Starting to get nervous. Okay. All right. Okay. Here it is then. All right, NBC 10 does have it. All right, so what I'm gonna do first, because somebody asked on X, I've gotten used to calling X X. Oh, that was my phone. I said to remind me, "Hey Siri, set an alarm for 7:25," and it thought I said
it's turned on.
and it thought I said 7:45. All right. Well, Tracy's like, it's right here on Court TV. So what's your issue? And then Sleuthy's like, here it is on NBC 10. Thank you guys. I do have NBC 10s up, so I'm gonna just start with that one. But I don't know because they don't have like let's not look at whatever. Okay, because somebody asked what she has to be, what elements we need for her to be found guilty. And I'm going to try to pull up Massachusetts statute here, but I mean, I'm pretty sure it's just pointing a gun at a human being. So, and putting that person in imminent fear of serious injury. But I'm going to pull it up, the statute. All right. No, this can't be right. Well, this is one of the things I wanted to have ready to pull up. So I think I remember Bob telling me this, that all he could find was their statute that's called assault and battery by means of a deadly weapon. And I meant to text Tracy, who I know is listening and out there, if she could send me the indictment or the charge. But then, like I said, life happened and Scarlett missed the bus and I started running late. Not so Zen Jen, member for 14 months. Congratulations to me for having you for 14 months. Good morning, Allie. Let's go. Happy 14 months. Yes. And thank you for your continued support. So, Traits, if you're out there, can you send me the indictment, or does anyone out there know specifically which statute she's charged under? Because what I'm seeing is the Massachusetts assault and battery with a deadly, oh, look, she did it already. Damn, she's the greatest. Um, what? What do you mean? And I'm saying what to my computer because it's acting like, oh, what? How did I have a retry this? What is happening here? Um, all right, let me just, I can't open my Adobe. Well, I can't fix it now. Apparently, I had an old card that expires in there, which I don't even know how that's possible. I guess if it's yearly. Um, let me open it up on my phone. All right. Indictment. The jurors, upon their fair oath, find that Kelsey Fitzsimmons of North Andover in the county of Essex, and on the 13th day of June of this year of our Lord 2025 at North Andover in the county of Essex, thanks for all the duplicative stuff, did, by means of a dangerous weapon, assault. What the hell? They don't put the statute number in their stuff? Assault by means of a deadly weapon. Let me try it again. Assault. Yeah, I don't know. All right, so assault with a dangerous, that's over 60. Let's just try next. Whoever assaults with the intent. No, this isn't the right one. Hmm. Because that's assault with an intent to murder. Assault and battery with a deadly weapon. Victim 60 or older. Assault with a dangerous weapon. Huh. Well, I can tell you that, let's just read this one. Whoever by means of a dangerous weapon commits an assault upon a person shall be punished by imprisonment. Okay, so that essentially all it is that you scare somebody with a deadly weapon so that they feel that they're an imminent threat. So that's what it is. Um, NBC 10. That's what we got up here. So, maybe I started a little too early since I have nothing more to say about that. Violent CAV became a YouTube member. Well, thank you. That's, you know what we gotta do is get, like, the membership super high today and be like, "Babe, so many people became a member because it was just me. No, I'm just kidding. I'm not gonna tease Bob like that. Plus, he'd be like, "That's so amazing." So, um, but what actually is pretty amazing is I'd love to hear what some of y'all did on your weekend, but I had, like, the best weekend of my entire life. One of them for sure. Well, actually, one of the best Saturdays of my entire life, because I went to the zoo with my granddaughter, who is almost 1, and it was the most adorable thing that has ever happened. She is just like, we hate the zoo at our family as a general rule just because it's so sad. The animals are trapped. You've got, like, big, beautiful animals that deserve to roam. But when you have, like, a young child or a baby, then you go because it is so amazing for them, even though we're, like, secretly like, "Oh my god, the sad, sad animals." But she is the most adorable thing. We all went, the whole family, except Bob, who didn't get to go because he was on the road, and Scarlett, who just decided that her social life, like, um, from we're getting a real behind the scenes look is what we're doing right now. And of course, now Nanook is like, "Why aren't you playing with me?" My dog. "Why aren't you playing with me?" You win. Poor doggy, he misses his daddy. But anyway, we haven't been in years either because like I said, we feel like it's just a sad, sad place to be. Unless, of course, you are with the most adorable, almost 1-year-old in the world. Robin G gifted 5 memberships. Thank you. Thank you. Oh, sorry. Thank you. Running banner. Wrong. All right. I have to create a new banner. Thanks, whoever just told me that.
Okay, great. And
It takes a village. You ready? All right. We got only wall. Oh, no. All right. Let's see. Let's see. Wow. Woman moving chair. This camera guy is like, I'm going to do this so cool. I'm going to be the best trial camera guy. I see. Let's see. So usually the dog can hang out with Bob upstairs on like where he's usually lounging anyway. But since he's not here, he's down here with me, and he's really trying. Oh, there he is. Good morning, babe. I miss you. The dog misses you. There you go. Good morning, Bob. Yes, Laura, the cameraman, is putting in the work. What about Bob? Oh, you miss me too? Thanks, babe. Thanks. So, oh, my sound went back on. All right. So while I've got this on, does anybody? I'm going to turn the boost off while we're just watching people. I wonder if I should try doing court TV just because. Where's Tracy's text? Oh. Whoop.
No acting out, objectives off the bench, free for all, start talking.
All right, well, court TV hasn't even started yet. They're starting in 2 minutes. No knock. I don't know if I should run and get rid of the dog. Just mute myself. If they have closed captioning on court TV, I'll switch over. The bailiff is warning everybody not to start acting a fool. Essentially. Bob is in like almost St. Louis, but still in Illinois, doing interviews and researching for season 2 of Murder on Songbird Road, the podcast. That's where he is. He's got one more interview today, so then he's got a 6-hour drive back. Oh, all right, I'm getting rid of the dog.
Yes, thank you. Maybe just a little bit more right over there so they don't trip. Just feel on the inside there. Appreciate that. Thank you. Does anybody have any questions before we get going for us? Anything we can help you out with? All right.
Wow. What is this camera guy doing? Just eavesdropping on people's shit like this. I put doggy TV on for the dog, so hopefully that works. Gave him a treat. Oh my gosh. So Tracy just sent me a text, and this is my perimenopause brain in the morning, that my granddaughter is almost 2, which is absolutely accurate. I don't know why. I just wanted to make her younger. It's just a lot of talking for almost 1. Tracy says, Bob wants me to let you know your granddaughter's almost 2. Oh my gosh. Why though? Why is she almost 2? Why can't she just be a really good walking and talking almost 1? I wish you could like slow it down, rewind and fast forward. Almost 2. Thanks, Tracy. Thanks, babe. Oh God. It's too early in the morning. Thanks, Sleuth.
Right, folks, like Officer Report mentioned earlier, no phones allowed to be used, okay? We have distinguished media members from public members. So that announcement is your one and final warning.
One warning.
Things are going to be tight. Witnesses are going to be coming in throughout the hallways, okay? If you're having be wandering outside. Anybody involved with litigation going on today should not be talked to, interrupted, or condemned for any reason. Okay? If we get a win for that, you guys should be moved, removed, and will not be part of this trial any longer. Okay? We want to make sure that everything goes smooth within the courthouse. Everybody out there. It's a public building. That is until you violate policy or become disruptive, but do anything else like that. Right? You're all more than welcome to be here. But if any of those things happen, you will be kicked out. All right? Or further action will be taken.
Ooh, or further action will be taken. If they harass a witness, hunt them down, do all the things, use their phones. I still can't get over that. I kept saying that my granddaughter's almost one. So, I'm gonna take the boost off again. Leave the background noise. So, I know most of you know my position on the bench trial, but since Deneen asked, I think it was a very hard choice. I honestly do, and I think that it's a he said, she said. So it's really should be a safe bet that a judge is going to find that they cannot find that, beyond a reasonable doubt to believe Officer Noonan over Kelsey Fitzsimmons. But they are both police officers, and it's going to come down to how they're able to at least cast some, shade, some doubt on Officer Noonan's account. And I think with a bench, you've got to lean away from he's just lying to cover his ass, although you have to say that just I think you also have to give I'm just gonna mute them for a sec. That you also have to give another reason why Officer Noonan might be telling this judge, Your Honor, I was staring down the barrel. She pulled the trigger. It didn't fire. And then I was still staring down the barrel. Like, if that's what he's going to get on the stand and say, which is assuming that is exactly what he's going to get on the stand and say, and then you've got the other officer, Kelsey Fitzsimmons, the dog's scratching at the door, saying, no, I was pointing the gun at myself. But only one of those officers was in the midst of a mental health crisis. And how is the judge going to balance that? Well, you've got this other officer who, apparently both of these officers had in the past been at a scene with a mother and child where was it a suicide situation, guys? Because I don't even know, but I know that you guys in the chat have told me, so I'm going to keep an eye out for your answer. But there's some post-traumatic, stress from that situation. He overreacted, and when he recreated the scene in his mind, that's the way he recreated it. That's what he thought was about to happen, and he responded too quickly, and he acted too quickly, and he's recreated the memory in that way to protect himself, And plus, Your Honor, he's got a lot of motivation to lie. But I just think that with a judge, it's gonna be, the more you lean into he's lying to cover his ass, you risk the judge feeling like if I say the words not guilty, I'm saying I believe that these police are corrupt. So I just think it needs to be a soft pedal on the he's lying, but you also have to get in all his motivations to lie, which are also maybe motivations to convince himself that this is what happened, and that now his mind is convinced that that's what's happened. I don't know. Some kind of balance of those two things. But I think that when you have a he said, she said like this, that the judge can, if he's concerned about we did I was on a panel that was doing a fundraiser for Kelsey on Friday, and, um, you know, I can't remember if it was Nurse Kim or who it was who pointed out that, well, what about the risk that the cop says, "I don't wanna lay out a huge lawsuit, but this is, like, gonna be a huge lawsuit because this cop shot Kelsey Fitzsimmons in the chest in her house, and she was in the hospital for a long time, and she's seriously injured, and, finding her not guilty opens the doorway to that, but there's words that he can say, the burden is very different. So, getting a not guilty in criminal court, sure, that's helpful because you get it guilty, then, well, you're shit out of luck. You've got no avenue to sue, period. But you get a not guilty, you do have an avenue to sue. But if the judge uses harsh words like, although I found Officer Noonan credible, and more credible than Kelsey Fitzsimmons, and I'm just making this up as a way that the judge could accomplish this. I still cannot say beyond a reasonable doubt that Officer Noonan's account, beyond a reasonable doubt, is an accurate account. Um, Not in this situation, and say enough words where he's kinda covering his own ass and the county's ass, but still making the right decision. So, that's what I'm thinking. Alright, well, we still don't have
family members that are part of the litigation. And I'm gonna be quite frank with you guys that are visitors who are just viewing, those people will get priority. All right, so I don't have any issues with that as well. All right.
alright, family members are getting priority. Look at this guy. He's using the window as a mirror to get some shit for us to see more shit. Is that what he's doing? This cameraman is like, "I'm gonna do all the angles and all the things." Court TV is still not up and running. Not up and running. See what else we got. We've got Majin Kazu says, "My first daddy-son trial watch." Oh boy, daddy and son watching together. 8 days old. Okay. Oh, that is so cute. 8 days old, and it's time to learn about justice with top-tier legal commentary. Thanks for covering this trial. Well, thank you, and congratulations, new daddy. Daddy-son time. Rosie Overruled, who's been a member for 10 months. Thank you for your continued support. Good morning. Love you all. Good morning to you, too. And All Animals Matter says, will defense have gun tested for the jam? I don't know, just a thought. Well, I think they might have, I don't think that is something they need to worry about here because she's charged with the statute that is just the assault with the by means of a deadly weapon, which carries 5 years. If this was like the assault with intent to murder, because look, you point a gun at someone the way he described. She pointed the gun at me and pulled the trigger. You can get charged with assault with intent to kill. Like you pointed the gun at someone and by chance it didn't go off. But thankfully that's not what she's charged with here. So I don't know. I don't think that they would, but there could be something that I'm not thinking of. All Animals. So, and thank you for your generosity. Wow. Only reflection.
Peggy, we're gonna need more stickers.
They're gonna need more stickers.
No, I got 20. We just gotta.
I don't know. So, what are you guys' thoughts out there? What do you think about what's going on? Do you think that Noonan, this is just all him covering his ass, or are there people out there who think it's something more nefarious? And
I have to text him
because I think I've heard whispers of that, but I just don't know how I feel about it. But the one thing I can say for sure is this entire thing could have been avoided. She was in the police department earlier that day with her child. They could have just called her back, made up some excuse that they needed her to come back, and and then this would have been avoided. They could have slowly broken to her what was going on, given her time to digest it. This is one of their own. So the whatever is really going on in the police department about why they didn't want Kelsey around, I mean, that seems like legitimate concerns, because I find it very odd that they wouldn't call their officer in and then do this in a completely different way. And the fact that they did not have like someone from DCFS, like a social worker, something like that there when they're taking a baby from their mom. I mean, anytime a child's being taken from a home, and there should be some sort of social worker there, some sort of medical person there. They knew she was in the midst of a mental health crisis. Ridiculous. And hopefully this brings about change in Massachusetts, because that's some bullshit right there. That is some absolute bullshit. And Pinky's sending out family hugs. Member for 3 months. And thanks for your continued support. She's catching up. I almost forgot. Well, family hug back at you. But somebody asked, and I just saw it, about openings. I would suspect. So you've got like two things going on, right? There's like a bench trial, but then it's publicized. So I don't know. We'll have to see, because typically I would expect it to be a much, and I mean much, shorter opening statement. Much shorter. So we'll see. We'll see how they handle it. I mean, I know Bradl's on TV enough. He doesn't need to put on a song and dance for the cameras, but there is a lot of public interest in this case. So because of that, they may want to say a little more than they usually would, because they want to make sure the public knows what's going on. But I don't know. We shall see. Oh, yeah. So Matthew points out that that's a good thing. There was a motion for a view of the scene. Does anyone know? I'm assuming there has been no ruling on that, because I think it happened like late on Friday or over the weekend. I don't know. And that would be a view of the house, because there's a lot of... All right, Court TV also doesn't have closed captioning. So we'll stay here unless... Let me see. What did I do here? Why did it do that? Oh, it's the wrong screen. All right. We'll close these other. I got like multiple screens open now. I'm leaving the boost off. Oh, it is open. Okay. Sorry, guys. Until we're up and moving. What was I just saying? The audio, I have the boost not on, because so that's gonna be pretty good. Like, wow, we're just eavesdropping. What did one of you just say that I was starting to talk about? Oh, the view. Okay. Oh, see, look, cigarettes. Thanks. So the view of the house. So For any of you that don't know, they want to go into Kelsey's house so that they can see the way the bedroom is set up. Because Noonan says that she grabbed the gun from behind the door in a room that apparently has no door. And at least that's the information that we have. I think it was Attorney Melanie Little had pulled up the like the listing of the house on like a realtor listing or something. I don't know if there's been any information about whether that's changed or something else, but last I heard from basically all y'all, is that the information we have is that there was no door there. So they want to see like the setup of the room so they can get like the views, the angles, and they can also contradict anything that oh, right, she had to sell the house. Okay. So yeah, it would have been recent pictures. Good Praxis became a member. Welcome, family hug. So, and I don't think we've had a ruling on that yet, but now that it's not a jury, wait, when did they file that? Before it went to bench? I wonder if they're trying to take the judge down there to see the room. That I don't know if I've ever even seen that, like where there's a view with a judge. Now I'm forgetting when. Wait, I know Tracy sent it to me. Let's just go back and look. Let's see. And see when that was filed. Let's see, here we go. All right, so March 20th. Oh, I forgot. I gotta update my payment method on Adobe. It's weird because it must be a yearly thing. All right, let me open it up on my phone. But yeah, she sent it to me March 20th. Yeah. All right, Fitzsimmons. It doesn't have the date that this was drafted, but respectfully praise that this court allow a view of the property in question. As grounds, the defendant states that the layout of the property is highly relevant to the court's credibility determination to be made in this case. Wherefore, the defendant respectfully requests the court enter the foregoing ruling and grant such relief as it deems proper. So yeah, they're asking for the judge to view it for sure, because it says it's to the court's credibility determination. So we'll have to hear about what the judge says about that. It's very interesting. Very interesting. And dog grooming Danny, I couldn't tell if that was an O or an A because I'm old. So thankful you guys are covering this one. Side note, I was thrilled to pick up my work phone and see the Garcia pod dropped. Yes, Bob always feels so much relief. Like he had to get out of town and do all this stuff. So I wanted to make sure he got a Garcia episode dropped. So for those of you that don't know, that is on the the standard podcast, audio only podcast. Get it on where you get your pods, under Defense Diaries. And then we also have Buried Inside the John Wayne Gacy Investigation. If you haven't listened to that, you are missing out big time. Big time. And all of you in chat were telling me, yes, she filed it after. On the 20th. So, I didn't even have to go back and look because you guys are all telling me anyway. I wish I had my coffee. Amy has her coffee. I need my man home to make me coffee. I guess when it starts, I'll go up and make coffee. I'm not crazy, right? This was set to start at 9 a.m. True? Oh boy. I'm laughing because Violet says the Stephen Avery podcast episodes were fantastic. Don't get us started. To start that, we should have never started that. I kept telling Bob, this is like a 3-year endeavor. You want to go through every page of every record, every police report, everything that happened. I'm like, this is a lifetime. And thanks, See You Buff's mom.
Like,
Was it set for 9:30? No, somebody says 9, someone says 9:30. We're waiting on the judge.
2 or 3. Chief, he said 9:30.
He's off.
Brian, not even gonna put it up there. I also agree. Daisy, the quirkiest mom. Someone's in there making phone calls. My man's out there. He's traveling in southern Illinois. What time's your interview?
Calling, maybe they're looking for you.
Are you done it already?
I don't know.
I'm like half in mind to
They didn't say.
DoorDash some Starbucks.
Call here, so.
What? DB, are you making shit up? Please explain. Are you just guessing something? Oh, not really. Okay. My God, that'd be shocking.
9:30. Yeah.
All right, everybody give DB a hard time for thinking he's funny. Lisa MD says, just another brick in the wall. Has anyone counted the bricks yet? Just another brick in the wall. Sorry, I'm clearing my throat and my mic. Real professional, Allison. MBW asks, is Bob working on Songbird stuff? He is.
Get going in about 5 minutes, folks.
Up 5 minutes.
You need to use the restroom right about when you show out.
5 minutes.
I don't know where he is.
Maybe I should go make coffee while we have this 5 minutes. Let you guys count the bricks in the wall. I will, because the dog's going crazy anyway. I'll be right back.
That's like the first punch of the fire. Somebody comes in that you're not supposed to. All the butterflies. No, it's just that's so nice. Oh. He's on the just give him a
Ready, and Katie, to just go for it? Okay. Just have it ready, Peggy.
Hey, it says district again.
All right, switch it over.
What is that? I think it's the same.
I made that for you.
All right. Well, we had no coffee, but I have tea. Dog's been let out and back in. So, and I gotta pull this tea out and not too long so it doesn't get tart. No, not tart. What's the word again, guys? I asked this last time. Oh, Lord. Polly was reminding me that Austin Drummond has a hearing tomorrow. I'll have to figure out. We might have to do like a second live stream.
You can take this one because it was making noise.
Or just play it later. Maybe we play it later and do it afterwards. we can find it. I think that's what we'll do. We have to do that on Tuesday. We have the double ups. On Tuesday, we've got Afro Man's lawyer and some jurors. At least one juror, might be more than one juror. No, on Tuesday. This is Monday. Today is Monday. But if you're not following the Austin Drummond case out of Tennessee, you got to go back and watch some of our coverage on that because that one's insane. Insane. I don't know what's going on up there in Tennessee, but shit ain't right. That's all I can say. Shit ain't right. We got some more new members. Oh man, babe, new membership off the charts. All because of me and my amazingness. Tanya Garrett, welcome. Welcome. Donnie Not Wahlberg, member for 1 month. Thank you for your continued support. Aw, Boris for the Starbucks DoorDash. So sweet. And Renee, but it's got, so maybe it's like Renee. I don't know. New member. Thank you. Thank you for your support. All right. Tea bags removed. Ah, forgot to bring down a packet of stevia. Damn it. Mhm. All right. Well, Renee is of French origin. So it's just the normal Renee. Thank you, Renee. All the eavesdropping on all the people. I really need to run up and get a packet of stevia. Maybe not. Defense Diaries email is a true crime pod at Gmail. A true crime pod at Gmail. We do have another email, but we've got people that help us monitor that one. So it's the best one. I'm not even on the regular Defense Diaries email because I was not a part of this project in the beginning. Only Bob gets it. Mermaid Mary RN, new member. Thank you. Okay, so Colton Briggs says that the Jury Duty show on Amazon Prime is a must watch. I watched the original Jury Duty show and I 100% agree, but our Cameron and I started watching the new jury show season, which is Corporate Retreat, something like that, brought to you by Jury Duty. And so far, we have not found it as entertaining. But the guy that they found for it is just amazing. So if anyone hasn't seen it, it's like an entire trial where everyone's actors, everyone except one who thinks he's on the jury and just thinks all this weird shit is happening. And they're doing the same thing on this office retreat. And they hired like a temp to be the assistant on this retreat. So everyone is an actor except this guy who is just an amazing guy. He is awesome. That part is really kind of cool. Sometimes he gets into stuff that I'm like, I'm so surprised that he's really interested in this aspect. And like going in. But I think after these 2 shows, like, anytime that anyone's, like, new to anything and there's a documentary going on at the same time, they're gonna be like, "Alright, this is a joke. I'm on candid camera. Dog scratching at door again." See, I wanna open the door and let him in because I think he just wants company, and he's just gonna lay here next to me, which he does a lot of the time. But then he'll just sit here and bark, and I'll be like, "What in the hell? I gotta go let this little guy in." Big guy, but my little guy.
No stress. If worst case scenario, you can take this. Oh, yeah.
Alright, we'll see how he does. This sweet guy. Wow, Mermaid RM gifted, became a member and gifted 5 memberships. So thoughtful, thank you. And Cigarette Hush says, "Company retreat." Yes, that's what it is called. Oh, Thunder is gonna send us another case from Tennessee where a dad red rum's a pedophile. Wow.
What's coming in?
I don't know yet. I'm just saying because we didn't watch that many episodes. I mean, we were laughing, like, but we just were like, "Is this as interesting as Jury Duty was?" And but we didn't invest enough time. So, because I saw in the previews at some point, like, the guy who's the subject is like, "This is the craziest shit." Like, I would almost think that this is not real and, like, that this is scripted, but you can't even make up this shit. So something must happen that hasn't happened in the first 2.5 episodes. So, like, oh, no, the first maybe we did watch the first 4. It's not fully released. It's not fully released. So, I think that the second half's gonna make it something must happen. So yes, we are Peaky Blinders fans. I have seen that there's a movie out. We're gonna have to watch that with Cameron because she loves Peaky Blinders, our daughter. Yeah, Hibiscus, that's how I'm feeling right now, but it's not all released. Well, their 5 minutes was not 5 minutes. So there's that. Aw. He's being so good. We did a little tug of war over his little toy, and now he's just playing peacefully. Thanks, S. Walter. I mean, with this being a bench trial, it's gonna be so much faster, and it was already gonna be, um, a fast case. Does anyone know, is this like what they call the big courtroom? So in theory, if it is, we should be seeing where witnesses would have been seated had there been a jury and they couldn't, where like not all, because that was the issue in the Karen Reed case, that Karen's lawyers said, they get in the courtroom and they're like, you cannot see, not every juror has a direct view of the witness box. How in the hell can they judge the credibility of a witness they cannot see? So they moved to a smaller courtroom. Now that it's benched, maybe we're in the bigger one. I don't know.
Hear ye, hear ye, hear ye. All persons have been introduced for the Honorable Jeff Karp, Justice of the Superior Court, now sitting in Lawrence, and before the County of
Yeah,
Essex.
that'd be nuts.
You are near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, His most honorable court. Court is now open. Please be seated.
Good morning, Your Honor. May I call the case?
Yes.
This is March 23rd, 2026, Courtroom 2, Lawrence Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for jury waive trial. Could counsel please identify themselves for the record?
Good morning, Your Honor. James Gubitose on behalf of the Commonwealth.
Good morning.
Good morning, Your Honor. Marina Moriarty, also for the Commonwealth.
Good morning.
Good morning, Your Honor. Martha Coakley for defendant Kelsey Fitzsimmons.
Good morning.
Good morning, Your Honor. Timothy Bradl for Kelsey Fitzsimmons, and with me is my paralegal, Courtney, which I thank you for allowing me to be at council table, and my client, Ms. Kelsey Fitzsimmons.
Good morning, and good morning, Ms. Fitzsimmons. You may have a seat. Folks, before we formally start the trial, I just want to tell our media members and our audience a couple things. First, you probably all know that I issued an order early this morning about what is expected of our audience members and our media here in the courtroom. And I'd like to just emphasize 4 aspects of it. First, I've ordered that people attending the trial may not display any words or images on their clothing or elsewhere that advocate for or against either side. And the reason why I've done that is I'd like this courtroom to remain as neutral and impartial as possible. All right, so don't take offense at that, just cover it up. Second, consistent with our rules of the Supreme Judicial Court, I'm allowing authorized members of the media to use a total of 3 cameras, 2 video cameras, so to speak, and a still camera. And my understanding is that the content will be shared among the media. Next, other than these 3 cameras, no one else is allowed to use a cell phone camera or any electronic device to photograph, record, or transmit any aspect of these proceedings while inside this courtroom, or while listening remotely via the court's live audio feed without prior court approval. And fourth, no one at all, including our members of the media, may photograph or video anyone or anything at any location inside this courthouse other than this courtroom pursuant to the rules. So in other words, out in the hallway and other public areas of the courthouse, do not photograph anyone, videotape, etc., or any of the places. You should treat any orders or requests of our court officers as if they're coming from me or came from me. Everyone should at this time check their cell phones, make sure they're on silent mode. And finally, just remember, this is a courtroom. I'd like you folks to be as silent as possible, and I'd like you to do that even during recesses. There's business going on in this courthouse, so if you can please, at recess, try to keep your voices down. That would be terrific. All right. Now, counsel, just wanted to go over a couple of procedural things, expectations, I guess. So with a few exceptions, I think I mentioned this at the last hearing, with a few exceptions other than a pre-charge, I'd like to treat this trial as I would a jury trial. So in other words, using the same process, which would include openings, closings, obviously, but also a charge conference before I deliberate. If you folks have pre-marked exhibits, I thank you for that. Anytime you do that, that's great. It speeds things up. I'd like to have an opportunity to quickly look at the exhibit before it's either displayed in open court or handed to the witness, just so I can familiarize myself. Don't assume I've seen anything because I haven't. Let's try to keep our sidebars to a minimum if we can. I'd like to have Ms. Fitzsimmons at each sidebar. Would be great. And also you should know that at the end of the trial, after I deliberate, I intend to announce a public verdict. I intend to explain my reasons for the verdict. I intend to have a transcript of my reasons generated and filed in our public record. All right. With that, any preliminary matters that you folks want to go over? No?
I have some preliminary matters.
Okay. Oh, and you know what? And there's
Review.
one of them may be paper. There was a motion for review, and
There we go.
if I still have it, but paper 88 maybe.
Yeah, I was confused about the courtroom.
On the
House.
motion for review, I'm going to take no action for now. I want to hear the evidence. I want to see the evidence. The Commonwealth didn't request one. I don't know if the Commonwealth will be objecting, but let me just see as the evidence comes in and whether I think it's necessary. All right.
That's exactly my suggestion. That's
Okay.
what I was going to say, Your Honor. So that's fine. Thank you.
Okay. And what else, Mr. Bradl?
Yes, Your Honor. The sequestration order.
Yes.
It's my understanding that there's several folks in here that are on the witness list. And there's also something I took note of, which is that there's several close family members of witnesses in the room that will be under the temptation to speak with their loved ones about what's going on in here. So I would ask the court to issue a order in open court to those people. You don't need to single anyone out, of course, but I'd ask the court to specifically address the notion that you cannot be a conduit to a witness and deliver information to them, even though you're not on the witness list. You're here and you're advised that you may not do so. You can't be a conduit to a violation of the sequestration order.
I mean, it's
Commonwealth,
all
any
on
thoughts
TV.
that?
No, I have no problem.
Okay. All right. As I told you folks at a prior hearing, I typically do not issue formal sequestration orders, but why don't I do this, given that it's been raised by the defense? I'll let the folks know, folks that are here and maybe folks that are listening remotely as well, that if you are on the witness list and you've been told that you may end up being called to testify, you should know that I have issued what's called the sequestration order. And what's most, I guess, pertinent for you to know is that you may not discuss any of your testimony or any testimony that you hear in court from another witness with anyone else on the witness list at all. All right. So get to know who's on the witness list, and you should know that you should not share that information. And I guess I can already see from Attorney Coakley that that wasn't perhaps broad enough because it didn't address one thing that Mr. Bradl heard. So all persons watching and listening to this trial should not share the testimony that they hear or see with folks that are on the witness list, folks that may be expected to be called as witnesses.
No.
Is that sufficient, Mr. Bradl?
Thank you, Your Honor.
I'm just
All right,
saying,
and
like,
that is an order that I've entered, okay? Please obey it.
if they want to
Anything
watch
else,
it,
Mr. Bradl?
they can watch it. They're not allowed to watch it, but
Your Honor, there's one issue that I'd like to put on the record regarding important statements that we don't have. And I will say that we're not requesting a continuance for it because we need to get this trial done. However, we've been trying to get some statements from the North Andover Police Department. And they're this. There was an outside agency that was employed called CIC
ooh,
that was run by Attorney Daniel Bennett. And Attorney Bennett did an investigation into the propriety of the actions of Officer Noonan, a witness in the case, and the person that shot Ms. Fitzsimmons. And we have a 80-something page report from them that has all sorts of excerpts of verbatim statements from several of the witnesses that are going to be called. And I did ask counsel for the Commonwealth to produce those statements of witnesses that were the product of the Bennett report, the Bennett investigation, the CIC investigation. And counsel, as he should have and did, asked the police department for those statements. The police department is apparently taking the position that they don't have custody of these statements that were retained by them and produced and paid for by them. And so they're telling the Commonwealth that they don't have them. I reached out to Mr. Bennett over the weekend, and he informed me that he would check with the police, and I haven't heard back from him just as of yet. So I wanted to just point up this issue on the record, Judge, that we don't have those statements. We are not asking for a continuance. We will forge ahead, but we want those statements. And
So can I just make sure that I understand? Are you saying, so this outside entity, private entity, CIC,
CIC, yes, sir.
Conducted some kind of an internal investigation of the shooting?
Yes, they were retained by the NAPD.
Okay. And you're saying that during CIC's investigation, first of all, CIC issued, you said, an 80-page report.
Yes,
You have that.
I do. And it has excerpts from what's clearly a transcript or a recording of several witnesses' statements,
Okay.
which I don't have.
All right. So that's the issue. You're saying
Right.
that folks that CIC interviewed, you don't have those statements. That's what you're looking for.
Correct. The actual real statements. And there's only excerpts of those statements in a report that essentially takes Noonan's side in the matter and exonerates him, I guess you could call it. But we don't have the full interviews.
Were the statements, those statements, again, generated by CIC, turned over to the North Andover Police Department?
Well, I've been informed by counsel for the Commonwealth that the police don't have them.
Okay.
And, I don't think that's an adequate answer.
Right.
That he's getting from the police, because they bought the statements. They own the statements.
Well-
They have custody and control of the statements. So to pretend that they don't have access to them, I think is disingenuous.
That's a true point.
Prejudices us, and it is something that needs to be remedied by the court if it's not handled by the end of the day.
All right. So, Mr. Bradl, you said, so what is it exactly that you're requesting me to do?
I'm requesting you to order the North Andover Police Department to produce forthwith all of the recorded statements from the CIC investigation.
You said recorded.
Request.
So you believe that these-
I assume they were recorded, Judge, right? And they were probably reduced to a transcript is my guess, but they're statements that they bought and paid for, and they need to produce them. And it's completely inadequate and disingenuous for them to say they don't have them. They do have them.
All right.
Thank you.
Commonwealth, are these statements that were generated by CIC in the possession, custody, and control of the prosecution team, as those terms are
Broadly
are
defined?
defined in our rules?
No.
Yes.
And,
Bullshit. They have a duty to request it.
So at this point, Mr. Bradl, it seems to me that this is a Rule 17 issue. I can't, I can't just order a third party, which this would be, because again, the Commonwealth is required to turn over statements and information.
And they're required
that's
to
in their
seek it out.
Possession, custody, control. We all know what that means.
This
Members
is.
of the prosecution team.
And the
North
cops.
Andover Police Department doing some kind of external investigation does not make them members of the prosecution team under our law.
What?
So for you to get those, you would need to follow the Rule 17 requirements.
What?
It just seems to me, Judge, that the chief of police who retains and controls the investigation, he was literally present at the scene of this incident. He's a part of the prosecution team.
Yes.
And so he's the one that controls the report. And for him to put on blinders and say, oh, we don't have that. No, that's not the standard. Is do you have it or not? The standard is it in your possession, custody, or control? And it is.
It's in their
And so
control.
He was literally at the scene. So he's the guy who's the decision maker. So I don't see how this is a third party issue. It's really just something that is so germane to the right to a fair trial that the police department in the very case, and the guy that makes the decision is the one who's a recipient witness, is saying, putting on both hats, and now he's saying, oh, administratively, oh, I don't have that.
When were you provided the 80?
That's what I want to know.
When was it produced?
I don't recall, Judge.
Oh,
At some point in
come on,
discovery,
Bradl.
I don't
When
recall.
was it produced?
Not like last week or anything.
Months ago.
Why are
Months
you
ago.
waiting so long?
Okay. Why are you waiting until 9 o'clock?
On
the
trial,
morning of
yeah.
trial to
Why,
raise
Bradl?
this? You folks were
the fuck?
before me for the very purpose of me weighing in on Rule 17 motions, not a peep from you. Why now?
Because I thought we were going to get it. I asked for it last week, and maybe even before that. And, I got the answer that, oh, they don't have it. So.
Commonwealth?
The defense sat on their
The
hands.
independent report, I called the chief at counsel's request and asked them what they got from Attorney Bennett. They said they got the report. I asked if they had any reporting statements, transcripts, and the chief told me no.
Okay. So what I would suggest at this point, Mr. Bradl, is you issue a summons under Rule 17. I mean, it really, at this point, I don't know.
I think it's a
Too late.
trial. I'm sorry to talk over you.
No, just hold on one second. Let me just finish my thought. Maybe Rule 17 isn't the right vehicle. Maybe just a summons,
Right.
a subpoena.
Kinda late,
Which
though.
then the police department can, report whether they, if they don't have them, they could seek to quash or something. But because it seems to me that we're beyond Rule 17.
Yes.
So that's what I would suggest doing. I'd suggest getting that out ASAP. As I said, I'd like this trial, in a perfect world, the trial and the verdict to be done this week. We don't live in a perfect world. I'm aware of that. So if things come up, we'll do the best that we can. All right. Anything else, Mr. Bradl?
That's all I have, Your Honor. Thank you very much.
Okay, so like any trial, we're gonna start with opening statements.
All right. So we're about to start with opening statements. So I'll, if you guys have questions, I'll try to flag them about what just happened and discuss it on a break. But they took too long. Why did they wait? Why the fuck did they wait? They've had this for months. But yeah, the judge was pretty understanding. He's like, all right, well, stuff happens. That's him saying mistakes get made, which Bradl made.
Can I send the defendant to the bar, Your Honor?
Oh, I'm sorry, I missed that part,
That's
yes.
okay. Simmons, docket 2000. On behalf of the on behalf of the defense, could you please stand? Honorable Justice Jeff Karp, Justice of.
I'm just muting it while he screams. I also found it very strange that they're going to have sidebars. There's no jury there. That's the only reason you have a sidebar.
Opening statements, the Commonwealth will go first because they have the burden. Thank you.
Your Honor, may the witnesses
Bizarre.
be ordered to exit the room for the opening statements, please.
Okay, yes, I thought that the sequestration order was that part of the sequestration order was that witnesses wouldn't be in the
Get the
present
out.
during court
out of the room, witnesses.
proceedings. Is that not the case? Is that not what I ordered?
That's what I asked for, and that's what you ordered, and that's what I expect, and I don't know why these people are sitting here.
Okay, so any objection?
No?
Okay, so members of the audience,
Get
if
up
you are
and
on
get
the
out.
witness list, if you have been told that you've been identified as a possible witness at this trial, you must leave the courtroom. And remember my order about what I called a sequestration order. Thank you very much.
Listen, the people are
There may
still
come a
getting up and
time where
getting out.
where I need to make exceptions to that rule, counsel. And you'll let me know when those exceptions are needed.
Thank you.
And yes, Corina, openings are not evidence, but still
Just
witnesses,
give everyone a
if
moment.
they're going to discuss the
filter in and
evidence,
out.
they're out. From openings, they're out. I can't believe there's that many people still in there. What's wrong with them?
Mr. Bradl, are you content? Do you want to take a
Yes.
look around?
I believe
More,
that.
more people came in, so.
Yes, no, I know those folks, that's no problem.
So I'll just say it again, folks that just came into the courtroom, if you've been told that you were on the witness list, you should not be in the courtroom during these proceedings. All right? Unless you're told otherwise.
Even though it's
All
not
right,
evidence,
thank you. With that, Commonwealth, I'll hear from you.
the opening lays out their case. It discusses the evidence. It puts the whole case and their whole theory out there. So
The defendant raised her gun, leveled it at Pat Noonan's face, and pulled the trigger. There are two reasons that Pat Noonan is alive today. The first being that Ms. Fitzsimmons' gun, while it had a full magazine, it did not have a round in the chamber. The second reason is that Pat Noonan, based on his years and decades of training and experience, reacted in a calm, professional way when he protected both himself and everyone else in that house. Pat Noonan is 50 years old. He is married to his wife Angie for 25 years. He has a son, Jonathan, who goes to school locally, college. He grew up in New York State at first and moved to Massachusetts to North Andover when he was 4 years old. He moved here with his father, his mother, his older sister. He went through the North Andover public school systems and eventually went to St. John's Prep, where he graduated from. He eventually spent a bit of time in college, but his real goal was to join the military, which he did. He joined the Air Force and went to boot camp out west. He eventually joined the security forces of the Air Force, where he was trained to secure nuclear weapons. He did that pretty much his whole time while he was in the Air Force. It was specialized training, weapons training, stress shooting training, defensive tactics training. His first assignment was on the ground in a Humvee. Later on, he joined another squadron and patrolled in a helicopter. He was honorably discharged from the Air Force, and he came back to North Andover. There, he worked security, armed security, at the Sidebar nuclear power plant. All the while, his goal being become a police officer, which he eventually did in North Andover. He worked in the North Andover police for years. It was his hometown police force. He joined the SWAT team, which is a specialized unit that deals with emergent violent situations, barricaded people, hostage situations, serving armed warrants and the like. It was during that time that they trained twice a month and 40 hours in a separate block a year. He did that for years at North Andover. He eventually transferred to the Lawrence Police Department. And he did that because he wanted to have a busier atmosphere. Lawrence is a lot busier than North Andover. He worked there for a number of years. Again, the SWAT team, he was a detective, had his specialized training. And back in 2024, he decided to make a switch and come full circle. He moved back to North Andover PD, both because he wanted to end his career there where he started, but he also wanted to bring his training and experience to his hometown police force. That was one of the reasons that Lieutenant Daley, on June 30th of 2025, asked Pat Noonan to accompany him and Timothy Houston, another officer who was a military vet, to serve a restraining order on Kelsey Fitzsimmons. He knew Pat had the experience, the temperament, and was cool, calm, and collected no matter what happened. Kelsey Fitzsimmons was a police officer. She had been on leave, but she was a police officer on June 30th of 2025. Also on that day, her partner, her boyfriend, her fiance, Justin Aylaian,
Aylaian, right.
Justin Aylaian, was concerned for his safety, for his 4-month-old child's safety that he shared with the defendant, and for Ms. Fitzsimmons' safety, specifically after events happened that weekend. And so we went to court, and he applied for and was granted a restraining order. The restraining order granted him custody of his 4-month-old son, ordered the defendant not to have any contact and to stay away from him, and also that she would be relieved of her weapons. She was a police officer, and she had a service weapon and 2 other guns that she had legally. Lieutenant Daley was at the PD when Mr. Aylaian came in. The restraining order was faxed in the court. Lieutenant Daley called Officer Houston, and they got in touch with Officer Noonan to serve that restraining order. They had gone by the defendant's home, Officer Houston did, to see if she was there. Unusually, her car was not in her parking space. It wasn't at her home. Officer Houston, who had seen it there thousands of times as he had driven by, noticed that it was parked down the street at a school, about 100 yards away or so. So they knew she was in the area. The 3 met at the school, decided on a plan, and went to the defendant's home. They met her at the door, and you'll see surveillance video from the home of that encounter as they come to the door. Ms. Fitzsimmons comes to the door holding her 4-month-old child. They go into the house. There's no surveillance system in the house other than in the basement. They explained to her what was happening, that there was a restraining order, that there's going to be a hearing on July 14th where she'd be able to tell her side of the story. And she tells the officer, I know how this all works. They ask her where her firearms are, and she lies to them, and she tells them they're in the basement. She's sitting down on a couch, the baby is next to her. She calls her mother, who will soon come over, and they tell her that Justin's coming also, because he's going to get custody of the baby. Officer Houston, who is also in the living room, sees a gun case on the sofa, and he opens it. Ms. Fitzsimmons lies to him again. I told you the guns are in the basement. The defendant's mother comes, takes custody of the child while they're waiting for Justin. The police have called Mr. Aylaian at the PD, so he's coming over with his sister, Courtney. The officers allow the defendant to walk around the house gathering baby stuff, equipment, clothing, and things like that. So the child will have what it needs when it's taken by Mr. Aylaian. They follow her around to make sure that she is safe, that they are safe, that everybody in the house is safe. They go upstairs, they come downstairs. They go upstairs again, and you'll see photos of this, Your Honor. It's a staircase. At the top of the staircase is a landing. where there's shelving and some of her police gear. If you look to the left, is the baby room. If you look to the right, it's the bedroom. There's no door in the bedroom. So she goes in the baby's room and she's gathering things, and she's handing it to the officers who aren't going to take possession of it. They put it down. They're following the protocol. They're trying to keep everyone safe. At some point, she's in the bedroom, and Mr. Aylaian comes in the house, and she hears him. Now it's Officer Noonan and Officer Houston in the bedroom with the defendant. She tells Officer Houston, I don't want him here. I don't want to see him. Don't let him near me. Because she's upset with Mr. Aylaian.
Yeah.
Officer Houston goes downstairs to make sure that doesn't happen. Mr. Aylaian, who had left the house with some baby stuff, came back and asked the officers for permission just to go down to the basement, because he wanted a suitcase and he wanted some of the other baby stuff because he was taking the baby home. He was in Stone, Massachusetts. So he did this. He was down in the basement. Lieutenant Daley is down on the first floor. Officer Houston is at the top of the stairs in the basement. And the defendant's mother is downstairs also. The baby is already gone because Courtney, Mr. Aylaian's sister, had come with them, taken the baby, and left the house. Officer Noonan is standing on the landing watching the defendant in the bedroom. She's on her knees. She's gathering things. He notices at some point that her demeanor changes. She gets upset. At that point, she lunges to her right, forward and to her right. And he can't see what she grabs, but she grabs a firearm. Turns out to be her service weapon. She comes back. She raises it. Before Officer Noonan can do anything, she pulls the trigger as it's leveled at his face, and it goes click.
I'm sorry.
It goes click, excuse me. It does not fire. Officer Noonan takes out his gun, is yelling at her at this point. Kelsey, don't do it. Drop it. Kelsey, don't do it. She is stepping backwards now. The gun hadn't fired, and so she was doing what the officers will describe to you as a tack rack. She has the gun in her hand. She bangs the magazine and attempts to rack it. She's unsuccessful the first time. Officer Noonan is still telling her, pleading with her, trying to de-escalate it. Kelsey, don't do it. She does it again, racks around. As she's picking up the gun, raising the gun, Officer Noonan fires. He fires twice. She is now moving. He misses and then strikes her.
As she's
She
raising.
immediately goes down. Lieutenant Daley runs up. Officer Houston runs up. And they treat her. They call for an ambulance in the fire department, and she's eventually taken to the hospital. The gun that she used on Officer Noonan was underneath her. Lieutenant Daley grabs it, puts it on the bed. Officer Noonan, still focused on procedure and what to do, picks it up and moves it farther away from her so it's not a threat. That is eventually collected by Officer Karp, who shows up later. The credible evidence in this case, the only credible evidence in this case, I would suggest to you, Your Honor, will be that Kelsey Fitzsimmons raised the gun and pointed it at Officer Noonan. She pulled the trigger when she did this. the credible evidence in this case, Your Honor, will prove beyond a reasonable doubt that the defendant is guilty.
Thank you. Mr. Bradl, would you like to make an opening statement at this time?
I would, Your Honor, thank you.
And feel free to stay there, or you can go to the podium, whatever you're more comfortable with.
Thank you, Your Honor. May it please the court.
Yes, please.
Counsel, ladies and gentlemen. Kelsey, no. Kelsey, no. You don't say that when you're staring at the muzzle of a gun pointed at you. You say that to a person who has a gun to their head. And you don't shoot someone in the chest when they are seeking clearly to only harm themselves. And when you do that, you quickly realize, Your Honor, that you need to adjust the narrative to save yourself. That's what this case is about, Your Honor. On June 30th, 2025, Ms. Fitzsimmons' entire world imploded, was destroyed when her fiancé, Justin Aylaian, obtained a restraining order behind her back with unchallenged, untested allegations at the Essex Probate Court. And he took away, at 4:30 in the afternoon, took away custody of her 4-month-old Caden in an ex parte fashion. The North Andover police had to serve that order. And in the late afternoon of the 30th, 3 male officers, Lieutenant Daley, Officers Noonan and Houston, they went to go serve the order. Their job was to take away the baby from Kelsey, a new mother with a 4-month-old named Caden, take her firearms, and give the baby to Mr. Aylaian. And that day, Your Honor, Kelsey stood in her house in humiliation in front of her police colleagues and friends. And she immediately processed all of the implications of this order, Your Honor. Everything that this fiancé had accomplished for himself without any chance for Kelsey to defend herself. He took away her baby. He likely cost her her career. He publicly betrayed her as her fiancé. He walked away from their impending marriage. She realized she couldn't any longer afford her house alone, so that was going as well. Her gun rights are stripped, and again, the humiliation that she's being served by people who she is friends and colleagues with from the North Andover Police Department. At that point, Your Honor, as she had this evolving set of revelations about how her life was in complete destruction, she made a decision for herself. And it's a decision that takes your breath away. It's a young mother who just minutes before they got there thought she had everything going for her, going back to work. She's on the schedule for July 3rd to go back to work. She decides to end her life with her firearm in her bedroom. She knows her firearm is in her bedroom.
What?
And she tells the police something else. She tells them the guns are in the basement because she doesn't want to involve them. The idea of harming them, the evidence will show, is ludicrous. The evidence will show that she's trying to get them away from her, Your Honor. She tells them the guns are completely in another location in the home. She's told that she needs to pack a bag for the person that's taking her baby away. So she has to walk around the house, pack a bag for Caden. She has it in her mind, the evidence will show, that she doesn't want them around for this event, this horrible thing she's going
Then
to
why
do.
wouldn't she wait till they left?
She goes upstairs to pack the bag, Your Honor. Officers Houston and Noonan accompany her upstairs. She keeps, several times, she gives them items to have them go back downstairs with. She hands them baby seats and clothes and books and thereabouts and says, take these downstairs, please. You'll see that evidence, and as a fact finder, you will see that that's evidence of her state of mind, that she has no desire to harm any of her colleagues and friends. She's got no motive, she's got no reason to, and her actions are completely inconsistent with that.
Thanks, people.
She's trying to get rid of them so she can have a minute in her room, not to do things that every young mother might want to do, but to get her gun and kill herself because her life's over in her mind. So at that point, Your Honor, her apparently what was later learned to be her mom comes in the house, and she's understandably upset. She's saying, how can you take away a baby from their mother? That's when Houston goes downstairs. So part one is accomplished, that Houston is downstairs. Houston's a friend. Houston was invited to her wedding. He goes downstairs. Noonan is still upstairs on the landing. You'll see from all the visual evidence, Judge, it's a stairway that goes up the small landing. Kelsey's bedroom's on the right, the baby's room's on the left. It's a pretty simple layout. Noonan stays up there. At this point, Kelsey makes it from the baby's room where she got some stuff across the landing to her bedroom, and she's in her bedroom when I don't want to say disturbance, but when Mrs. Page, her mom, gets here. What we later learn is that she gets here, and Houston goes downstairs. Noonan, in a moment after Houston went downstairs, Noonan starts to go downstairs, and that was Kelsey's moment. Why? Because she wanted to do this herself, and she didn't want to involve Noonan. I told you about Houston. Noonan, she had been on extremely difficult calls with. She considered him a friend. She knew he had a wife and a child. Zero motive, the evidence will show, for her to ever want to harm this gentleman. She's alone in the room. Noonan's down the stairs. She reaches into the corner and picks up one of her handguns. She'll tell you that she is acutely aware as a police officer that she doesn't want them involved. She doesn't want them to be a part of this in any way. She keeps the gun close to her stomach area and walks over to an open spot in the room. She raises the gun to her head. Noonan is not even back in the room yet, Your Honor. So I don't want you as the fact finder to be looking for evidence that, well, maybe she swung it in his direction when he was coming in. Maybe she was pointing it at him at some quick transient time. That's not the case at all, Your Honor. That will not be the evidence. The evidence will be that Ms. Fitzsimmons had the gun to her temple, and then Noonan walks in, and he sees someone who is exhibiting only harm to herself and to no other. And we've discussed this pre-trial, and there'll be some evidence and discussion and cross-examination, Your Honor, about the Code of Mass Regulations that we discussed as it relates to, or doesn't relate to, Noonan's state of mind, Your Honor, that he's, as a firearms instructor and a SWAT team member and a former Lawrence police officer, as well as North Andover, he knew or should have known that he was in trouble, that he was in violation of that CMR, the Code of Mass Regulation that I just mentioned. And he knows he has to adjust the narrative, Your Honor. getting back to the incident, Your Honor. Kelsey has the gun to her head. She's trying to steel herself. Noonan comes around the corner and sees it, and the evidence will show that he is not some super cool James Bond type law enforcement officer, that he has a look of panic on his face, and that he's flustered. And certainly no one's faulting him for that. But that's what he looked like, and that's what the evidence will show. And that's when the words, Kelsey, no, are uttered. No law enforcement officer, Judge, the evidence will show, in his right mind would bargain with someone who has their hand on the trigger and the muzzle in your face. The evidence here, Judge, will show that he was trying to tell her not to kill herself. The evidence will show that Kelsey never pointed a gun at him, and that this was a mistake. It was a brain freeze. It was a mechanical thing. It was someone seeing a gun and shooting. How do we know this even more so? Besides the lack of motive and the utterances that he made. We know because of the location of the firearm, Your Honor. The firearm, when Kelsey was shot in the chest and went flying backwards and landed on her back, and Daley will tell you that she's on her back. The gun was under her leg. If Ms. Fitzsimmons is pointing the gun at Noonan, and falls backwards, how does that gun swing around to get under her leg if she's pointing it the way Noonan says? The evidence will show that's not consistent with the laws of physics.
An expert, I hope.
It is, however, consistent with somebody holding the gun to their temple, so it's already to the side of your body, if not behind you when you go flying. So the location of the firearm, the evidence will show, is also consistent with what Kelsey says happened. Finally, in terms of the panic, the flustered look on his face, Ms. Fitzsimmons was only anywhere from 3 feet to then maybe 7 feet away from him in this entire incident. And that might be where the view comes in, Your Honor, the room. And he missed her in the first shot. He's a firearms instructor. He's a SWAT guy. 25 years, he misses someone from 3 to 7 feet away. Hits the air conditioner. That's panic, Your Honor. That's not cool, calculated action. That's panic. So Daley comes in. He goes over to Kelsey. He administers first aid. He rolls her to her side, sees the gun under her leg, behind her and under her. Your Honor is going to be the fact finder. You're going to consider all these things, the physical location of everything, the way things unfolded, the lack of a motive, what makes sense, what doesn't, what's doubtful. Anything that's doubtful is obviously not consistent with what the Commonwealth wants to have happen here. It's consistent with maintaining her presumption of innocence. Only 2 people were in that room. There were no body cameras. The police never interviewed Kelsey Fitzsimmons. They circled the wagons immediately, right at the scene. You'll see everybody treating Noonan like he's the victim. They circled the wagons immediately around Noonan. And everybody wants to defend Noonan in this situation. And no one even took a minute to think about whether Kelsey may have a different take on things, may have something different to say. Why? Why did they ignore Kelsey and circle around Noonan? Probably millions of reasons for the town. Millions of reasons.
Millions of dollars, he's saying. That was his way of saying that.
Ms. Fitzsimmons will tell you, Judge, she served orders herself. She served restraining orders. She's a delivery person. No one's going to be going after a police officer no less someone that she knows, cares for, and has made repeated actions to get them out of the room. She will tell you with some indignation, I suspect, that she would never
She will tell
point
you.
a firearm at a fellow law enforcement officer. So for all these reasons, Judge, as the fact finder, I request, I ask you, and I trust you to well and truly try the case. And I am confident that after the evidence is in, Your Honor will find Ms. Fitzsimmons not guilty. Thank you.
She is definitely testifying.
You ready to proceed?
She
Sean
has to
Daley,
testify.
please. Sean Daley.
I mean, there's so much I want to say while this is still fresh in my mind, but I know we don't want to miss anything. I just want to say there's a lot of what was said in that opening that makes my theory before about finding a way to balance between he's straight up lying to cover his ass and he recreated this memory in his mind because they can't. I mean, he even said it's not like he saw this on the way up. He's saying this guy saw it pointed at her head and just flat out lied. And we'll break all of this down later. I took some notes, but you know, this is why it's scary going to a bench trial in a case like this when the juries, the people, the community in Massachusetts is primed to see corruption and know it exists and know it's real, where a judge might be, nervous about a ruling like that. So you just have to hope that reasonable doubt, the possibility that someone's story is not what it seems to be is enough for reasonable doubt here, and it should be. I'm blooping us so we're not missing anything.
So first things first, why don't you swear the witness? We may need to,
Swear that the testimony you're about to give in this cause now and hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning, sir. How are you this morning?
Excellent.
Good. Folks, can you, I just need to speak with our assistant chief for a moment.
All right, well, we're live. Who is this, guys? I mean, I'm sure they'll say it again, but I missed it. All right, so this gives us a chance to talk about the openings a little bit more. I don't know why they need to have sidebars, just to why are they closing the public out. But there was a couple things that could be issues. Like, for example, Kelsey saying he was flustered. She could see this look in his eyes. It's hard to balance. Like, she was about to shoot herself, but she's taking notice of, the look on his face at the time. I don't know, but I still think that's possible. The issue of him missing the first shot, that is a problem for the state, in my opinion. And it's a point that Meza pointed out on when we were doing the fundraiser live on Friday, that you can't have it both ways. Like, he's calm, cool, and collected. He's even keeled, and he's missing the shot. I mean, that shows someone who is, in fact, flustered. And, that's an issue as well. Also, if she's sitting there and he's watching her multiple times in this tiny little room, banging and trying to get the gun to unjam, that's when you jump at the gun. That's a question too. But the state can't have it both ways. That this guy is, he did all this combat work, and he's, the cool, ration head guy, and then he just misses the shot. And then he says that she will tell you she would never shoot at a fellow officer. Now, this was the fear with the whole postpartum depression or mental health issue and building up the mental health on her side to say that a jury might have said, well, then she could have very well done something that she would never do, something well outside of what she could ever see herself doing or anyone else could see herself doing. And there is some fear when you have a judge taking the word, balancing the word of two officers. Only one of those officers was in the midst of a mental health crisis. And is that going to sway him to say, I find nothing credible about what she had to say because she wasn't in her right mind? And, where there's no evidence that he was panicked other than the missing of the shot, but that he could have misinterpreted the situation because the way the defense is putting it forth, there is no room for misinterpretation of the situation. There is just a bad decision to shoot at someone who was going to hurt themselves. I don't know. What do you guys think? What do you guys think? Like Crackpot says, I'm guessing he was trying to help her and it got turned around when he realized he could be in trouble. I think that that's probably true. He was just trying to stop her from shooting herself. And now he had to tell a complete and total lie because he knew, like, oh shit, my career is over now. She might die. They didn't know. That was another point that someone on the panel made during the fundraiser on Friday. At the time he makes the statement, she might die. He's got to say whatever it takes. And that's where I kept saying that I struggle with the bench versus a jury trial, that I think it's easier for a jury, especially one primed. You've got Massachusetts community on full alert of the deep corruption in the police force, in the prosecution's office. Like, they know it's real. They've lived it. They've seen it. They're hyper aware of it. And that's where I kept saying, like, that's why the struggle is so real. And I hoped that there would be a way to say it was just the way he interpreted it at the time. And he's convinced himself this was the story. Just, like some way to argue out of both sides of your mouth on that issue. But the way the defense has laid it out, there isn't. It's black and it's white. He had no room for misinterpretation. It was pointed at her head, and he knew damn well that's where it was pointed, and he lied to cover his ass. And
Folks in our audience, folks that are listening on our live feed, it's come to my attention, and I'm not accusing anyone of anything because we're all making our way through this.
What?
Trying to figure out the rules of the trial. My understanding is that these proceedings are being so-called live streamed, and obviously, or maybe not obvious, we also have a public phone line open that's court sanctioned that is broadcasting the audio of the trial. I want folks to know that those folks that are on the witness list may not watch the live stream, listen to the live stream, or listen to
I'd hope they know that.
Open telephone line of any of the court proceedings. The whole point of removing those folks from the courtroom is so that their testimony will be their own testimony, their own memory, and not that of other witnesses. All right. So I've instructed both sides to tell the folks that are here on their side of the witness list that they are not to watch the live stream, listen to the live stream while it is going on, listen to our open phone line. That also means that at the end of the day today, they're also, until they testify, they're also not to listen or watch any rebroadcast of those things. Again, we want a transparent, impartial, open trial that where folks are testifying based on their own memories. Okay? Thank you. And Commonwealth, you may proceed.
I wonder if they had some suspicion. Witnesses should know that. That's like, come on. He was being generous there.
Sir, in a loud, clear voice, can you please introduce yourself? Spell your first name and your last name.
My name's Sean Daley, Seandaley.
And sir, what do you do for a living?
I'm a lieutenant with the North Andover Police Department.
How long have you been North Andover Police Department?
20 years.
Officer? 20 years?
Yeah.
Can you tell us, bring us from the beginning of your career to present day? And you started as a patrolman?
Yes, I started in 2003. I attended the police academy in 2003 with Boston College. I worked there till 2007. I was hired as a reserve in North Andover in 2005, so I was doing both jobs at that point in time. And then I left BC when I got the full-time job in North Andover.
Okay, can you take us to your career path at North Andover?
Yep, I was on patrol for maybe 6 months, and then I filled in as the SRO at the school for about 1.5 years. Then I was in detectives for about 9 years, 7.5 or so, I was assigned to a drug task force with the Drug Enforcement Administration. I got promoted to sergeant in 2016 and then lieutenant 2 years ago.
So what is your role as a lieutenant now?
I oversee the early night shift, the 4 to 12 shift.
4 to 12 shift, okay. Now I'm going to turn your attention to June 30th of last year. Were you working on that day?
I was.
Okay. And at some point after your shift started, did you find yourself in the lobby?
Yes.
Okay. And did you meet anybody there?
Yes.
Okay. Can you tell us about that?
Justin Aylaian and his sister came into the station, into the lobby. He had a copy of his restraining order.
Okay. And did you know who he was in connection to the North Andover Police Department?
Yes.
Who was that?
He's a firefighter in town. He was also Kelsey Fitzsimmons' fiance at the time.
Okay. Kelsey Fitzsimmons, do you see her in the courtroom today?
I do.
Can you just point to her and describe something she's wearing, please?
She's wearing a pink jacket.
May the record reflect he has identified the defendant. Okay. And so what was her role as as far as the town goes?
She was a police officer with North Andover.
Do you know when she started?
In 2024, not exactly sure when, but yes.
And what was her role when she started in the police department?
She was a patrol officer.
Was she a patrol officer back in June of 2025?
Yes.
Now, do you know if on June 30th of 2025, she was issued a service weapon?
On June 30th?
Yeah, did she have one?
She did.
Okay. Do you know if she had any other firearms that were registered to her?
Yeah, I believe so, yes.
Okay.
According to the CJIS printout when we ran her prior to going over to serving it, I believe there were 2 other firearms that showed up.
Okay, can you tell us a little bit about the basic procedure of what a restraining order is and what you do as a police officer?
Wow, buddy.
You get a copy
Wow.
to serve?
A 209A order is a court order issued by a judge. If somebody's, in imminent fear of harm, their safety, or there's been a pattern of abuse or whatever, they would go in front of a judge. They write out an affidavit describing what has taken place, where they would potentially be granted an order, and they go in front of a judge, and I believe there's questions asked. I've never actually been in the courtroom when they go to get it, but that's my belief. And a judge either grants it or denies it.
So on June 30th of 2025, a judge ordered a restraining order to be served on Ms. Fitzsimmons, correct?
Yes.
Did you know, how did you guys get it? How did the PD get it? Do you remember?
It comes through our email to the oic@napd.us.
I'm sorry, I didn't hear that. Comes through.
Our email system through the court. The court sends it to, I believe, every police department's like that now.
Okay.
You use some letters through the.
OIC@napd.us. Short for officer in charge.
Officer in charge?
Yeah.
Okay.
And all the supervisors get it.
Okay. So you got it?
Yes.
Okay. Did you know that Ms. Fitzsimmons had a small child?
Yes.
Were you able to review the contents of the restraining order itself? Not the affidavit, but what the court ordered?
Yes.
Okay, so what was the court ordering?
She was to have no contact with Justin Aylaian or the child. She couldn't go within 100 yards of the residence in another town, I believe where his parents live. She had to surrender her firearms license to carry. Could have no contact with him.
As a result of getting that order, were you yourself going to serve it?
Yes.
Were you going to bring anybody else?
Yes.
Okay, did you make a decision as to who to bring?
Yes.
Why?
Based on their experiences, the way they've performed in the past, they're both calm, cool, and collected. And they've demonstrated that throughout their careers.
Okay, and who are we talking about?
Patrick Noonan and Timothy Houston.
So what did you do to get in contact with them?
I called Tim Houston on the phone. I asked him to drive by Kelsey Fitzsimmons' residence to see if the vehicle was there. He drove by, the vehicle was parked away from the house by the Atkinson School over in the corner of the parking lot. He saw the car, and then I asked him to call Pat Noonan or get in touch with Pat Noonan, and I would meet them over at the Early Childhood Center. From that point, you could still see her car where he was situated, but she wouldn't have been able to see the cruisers.
Okay, and so you did that.
Yes,
Did you make your way over to the meetup spot?
I did.
And who was there when you got there?
Patrick Noonan and Timothy Houston.
Did you formulate a plan as to how you were going to serve the order?
Yes.
Okay, and what was that?
So I explained the order to both of them, let them know exactly what we were there to do. Explained that we had to deal with the custody of the child or the exchange also, and that she had firearms in the house. We were going to have to seize those.
Did you make a plan with Justin Aylaian concerning the child?
Yes.
What was that?
I took his phone number before I left. I told him to stay in the lobby of the police department until I called him. When I called him, he'd come over to pick up the child.
Did you make your way over to the residence?
Yes.
And what was that address? Do you remember?
No.
No problem. How did you get there?
It's Phillips Brooks Road. I'm not sure of the number.
Was it 125 maybe?
That sounds familiar, yes.
I'm sorry, what road?
Phillips Brooks.
Is that 2 words?
Yes.
Well, the judge is really concerned about what road they were on.
Thank you.
How did you get there from where you originally met up with Noonan and Houston?
We drove.
Okay. Where'd you park?
We parked in the school parking lot, which if you were looking at her house, it would be over on like the right side of the house. There's some trees and fencing there. We parked right over there.
And did you walk over?
We did.
All 3 of you?
Yes.
Tell us what happened when you got to the house.
We walked up to the house. I believe I rang the bell and I knocked on the door, and she came out holding the baby.
And when you say she,
Kelsey Fitzsimmons came out holding the baby.
and so can you tell us about your initial interaction with her?
Kelsey opened the door. I told her that we had paid like documentation for her, and if we could come in, and she let us come in.
Did you tell her what the documentation was originally?
At the door?
Yes.
No.
Okay. So where did you go in the house?
So when you walk in that door, it's like an enclosed front porch area. We walked into there, then the front door, the main part of the house is there. We entered that, like if you go to the left there, it's like a living room. We went into that room.
Okay. Did you direct her to go anywhere when you got into that room?
Yes. So I asked her to put the baby in, there was like a little bouncy rocker next to the couch, and I asked her to have a seat on the couch.
Why did you ask her to put the child down?
Justin had told us that he had concerns. Justin Aylaian told us that he had concerns that she would potentially harm the baby, us, or anyone else. I didn't want her to do anything or be able to do anything with the child.
Did she sit down?
She did.
Did you then have a conversation with her about why you were there?
Yes.
Can you tell us what you said and what she said?
I handed her the restraining order and explained it to her. That Justin had gotten a 2198 order against her.
Okay, and did you explain the orders that were contained in the restraining order itself?
Yes.
What did you say?
Well, I told her she wasn't allowed to have contact with him. Couldn't go near the residence. She was going to have to turn her firearms over, and Justin had custody of the baby until the hearing.
When you say the residence, it wasn't the residence where she was living. It was in.
Yeah, whatever. Justin and the alien listed an address, I believe, on the document.
Okay. When you mentioned that you were going to need to seize her guns, did she respond to that at all?
When I said we were taking your guns?
Yep.
No, I then asked her, where are your guns?
And what did she say?
She said they were in the basement in a safe.
In a safe in the basement?
Yes.
Did you say anything about a return court date that she would be able to attend?
Yeah, the hearing?
Yes. What did you say?
Whatever the date was I believe it was like 12 or so days later.
Okay. Did she respond to that at all when you said that?
No.
Do you know, as part of being a lieutenant at the North Andover Police Department and being a superior officer to Ms. Fitzsimmons, has she had occasion, if you know, to serve restraining orders herself in the past?
Yes.
She has?
Yes.
Well, what happened after you explained it to her and she told you her guns were in the basement?
Well, then I explained that I was going to contact Justin to come over to pick up the baby.
Okay. Did she say anything, if you remember, in response to that?
To what? I'm sorry. Repeat it.
Sure. You had told her that Justin was coming to the house to get the baby, correct?
Yes.
Did she say anything in response to that?
No, she didn't have any. She said like she was agreeable to it.
Okay. Did she use her phone at all?
She called her mother on her cell phone.
What happened next?
Sorry to interrupt, no, excuse me, just, Ms. Fitzsimmons is the defendant here, and she cannot see the witness.
Oh.
Can she kind of move her over here, Judge?
Yeah, absolutely, yeah.
I want her to be able to see.
Yeah, of course, no, absolutely. We can move, and if maybe you folks slide down a little bit. Is it because of the angle or is it because of the screen?
The computers.
Oh, the computers, okay. So Ms. Fitzsimmons, it's important that you and all counsel are able to see everything, okay? Thank you. Can you see?
Right, I can.
Can't see, you may have to sit 2 rows back there. I don't think that there's much that we can do about it. Maybe you can move the table up or something. Okay, counsel, you all set? Everyone set in the back row? Hold on one second. Ms. Moriarty, can you see?
Yes, thank you.
Okay. All right, thank you.
All right.
So what
going
happened
to
next?
see.
She called her mother.
She called her mother.
Okay.
Yep.
Did she ask if she could gather anything for the baby?
Yes.
Okay. And so tell us about that.
She asked if she could get some items for the baby. So the baby started getting fussy in like the bouncy chair. Officer Noonan ended up holding the baby for a little bit. And Tim Houston and I went around with Ms. Fitzsimmons into the kitchen first. She opened some drawers. There were some like jars and formula bottles, whatnot, that she was grabbing and putting in a bag. And then we came around, she went upstairs to the bedroom where the shooting occurred. I was with her. She walked in, looked around, we walked back out, went back down the stairs, and then she went into the room. If you're looking at the house, it'd be the room on the right that had like storage shelves along the wall. There were some diapers and other things like that that she grabbed.
Okay. Why did you escort her around?
Because it's serving an order like that, you don't let anyone, I mean, we control the house, we control movements.
Okay, so you wouldn't let her be in a room by herself
No,
or out of your sight?
correct.
Okay. What were you looking for as she was walking around the house?
Any potential weapons.
So now she's back downstairs in the room to the right, if you come in the door, correct?
Yep.
She's gathering belongings. What happens after that?
She started getting a little bit emotional for a second, saying she was going to lose her job, etc. And I told her, you just relax, take a deep breath. You got to let the process play out. Maybe cooler heads prevail. And she actually kind of settled down a little bit.
So what happened after you had that conversation?
I called Justin to come to the house, and her mother showed up right around that point.
Who had the baby when her mother showed up? Do you remember?
Officer Houston had the baby when her mother showed up.
Was there a handoff at that point?
When her mother showed up?
Yep.
Yeah, the mother took the baby from Officer Houston.
So what happened next?
Her and her mother were in the family room. She showed her mother the 209A order. And the statement was made that we were taking her baby. And I told her, we're not taking your baby, Justin is. And she ended up going back upstairs with Officer Noonan and Officer Houston.
Okay, and you stayed downstairs?
I did.
Okay. At some point, did Mr. Aylaian arrive?
Yes.
Okay, can you tell us about that?
So Mr. Aylaian arrived with his sister. They came in the house. Kelsey was upstairs in the bedroom with Officer Noonan and Officer Houston. I had the sister take the baby out to the vehicle. And Justin grabbed some things and went out. He came back into like the porch area, the enclosed porch area, asked if he could go grab his suitcase and some items. And there was also, he had asked also, because she had his wallet and some other items from the weekend. He had asked if he could get those too, and Kelsey had agreed to give those back to him,
Okay.
or give them to him.
So he had left the house. Excuse me. Do you know her name to be Courtney Aylaian?
Yes,
Aylaian, excuse me. And she took the baby outside.
yes.
Justin went out initially, but then came back and asked permission to come back in the house?
He went out carrying some items, and then he came back up and asked if he could retrieve some things,
Okay.
including a suitcase in the basement.
Okay, and did he go down the basement?
He did.
After he went down in the basement, who was upstairs?
Both Officer Houston, Officer Noonan, and Kelsey Fitzsimmons.
Okay, at some point, did Officer Houston come down?
He did.
And where did he go? Do you remember?
Officer Houston came down the stairs and told me that Ms. Fitzsimmons didn't want Justin in the house, so I told him to go around to the basement to basically hold him there because we didn't want them interacting. So Officer Houston was going to hold Justin the Aylaian at the door over there, which is around the backside off the kitchen. And
Okay, and Officer Noonan is still upstairs overseeing the defendant?
yes,
What happened next?
maybe a minute later, I'm down in the family room with Kelsey's mother and the child. They're over by the couch. She's holding the baby. I'm standing right basically on the wall of where if you pivoted around the stairs would be to go upstairs, and the front door opens kind of funny. So I was just standing there waiting, and then I heard Officer Noonan.
Was the baby still in the house, or did the
I'm sorry, the baby was gone at that point.
The baby was
Yes.
gone at that point. Okay, so how close are you?
So Kelsey's mother's still downstairs in the living room or family room with me. She's over by the couch, and I was standing by the wall.
By the wall near the
Closest to the staircase to go up the stairs.
Okay, did you ever hear Officer Noonan or anybody else start to come down the stairs at all?
After Officer Houston came down?
Yes.
No.
What happened next?
What happened, I heard Officer Noonan call out in like a loud authoritative voice, Kelsey, don't do it, Kelsey.
Okay, and what happened after?
Hold on one sec, so I can catch up, please. All set, thank you.
Did you hear anything after that?
Gunshots,
How many of you remember?
2,
Coming from upstairs?
yes.
So where did you go after that, when you heard that?
So when I heard Officer Noonan call out, Kelsey, don't do it, Kelsey, I pivoted, looked up the stairs and started running up the stairs.
When did you hear the gunshots?
While I was moving up the stairs.
Officer Noonan, was he at the top of the landing?
He was at the top of the landing in the frame of basically standing at the frame of the bedroom door.
Okay. What did you do when you got to the top of the stairs?
I looked in the room.
And what did you see?
Miss Fitzsimmons was laying down. She was on the floor. If you look at the room, she was from the doorway. She was on the opposite side of the room, head closest to the wall, feet closest to us.
And she appeared to be injured?
Yes.
So what did you do as a result of that?
I immediately went into the room, got up there. When I got up to her, I could see the gun was, she had a firearm down by her left leg. So I picked the gun up, put it on the bed. I'm between her and the bed, and then we started dealing with it, like rendering it.
Where was Officer Noonan at this point?
In the bedroom.
Did you have your gun out?
No.
Did he have his gun out?
Yes.
Okay. Do you know what happened to the gun on the bed?
The gun on the bed, at some point when I was trying to wrap gauze around her, Officer Noonan picked it up and I believe he handed it to Officer Core.
Okay.
Sorry, Officer who?
Noonan handed it to Officer Core, C-O-R-R.
Did you, can you describe the injuries that you saw?
Yeah, so she had a gunshot wound to her chest or lower, between the abdomen and the chest, like right below like the breastplate. And when I rolled her over to her side, I could see in the back, it would appear to be an exit wound.
Were the other first responders called?
Yes.
Who called them? Do you remember?
I got on the radio basically pretty fast saying that we had shots fired, female down, and we need medics or something to that effect. And I believe other people also were on the air.
Was the defendant saying anything when you got in the room?
When I got into the room originally, when she's on the ground?
Yes.
Yeah, she kept saying, "I'm sorry and I want to die."
What? Wait.
Yeah, she kept saying, "I'm sorry and I want to die."
That's helpful. They're throwing in the "I'm sorry," thinking that's not helpful, and I want to die. You can still be saying "I'm sorry," like to
Fire personnel arrive?
everyone that you
Yes.
tried to
They
kill
take her
yourself.
away?
They did.
Okay. What did you do with the scene, if anything, at that point?
At that point, we were calling people to come to the scene.
Okay. Did you secure it?
Yeah.
What happened with the gun? If you know, what happened with
Wait, did I mishear that? I thought he said, "I'm sorry, I want to die." Did you guys hear "I don't want to die"? I heard "I want to die." But we can go back. If there's an issue, we can go back on the break and listen again. But
the gun that Ms. Fitzsimmons had next to her when you walked into the room? Do you know where that ended up?
Yeah, so if you came up the stairs, at the top of the stairs, there was some shelving with some police equipment. There was a gun safe on the floor right there. And Officer Core made the weapon safe, put it in the gun safe, and basically stood over it till he was relieved.
Judge, I just want to lodge an objection to whether or not that testimony is based on personal knowledge or not. I don't want the witnesses testifying to, things that they've learned in the investigation. There's been no preface for the question, did he see that? How does he know that? So I just want to take the opportunity right here to object to anything that's just sort of global testimony versus something the witness perceived.
All right, so.
You could rephrase it, I guess.
Mr. Bradl, the most efficient way for me to handle objections is, object, and I certainly understand what your reasoning is, but you have to object at the time, and I'll make a decision. Are you moving to strike
I
anything?
am moving to strike and asking for rephrase to whether or not the question is based on personal knowledge.
Okay, and not your fault, my fault, but what are you moving to strike?
The entire answer,
Of,
and
We didn't hear
ask
it.
that the question be asked again, and the answer be, make it clear that whether the witness is testifying on his own personal perception, his own personal knowledge, or whether he's just globally testifying, which I would object to.
All right, so are you talking about the testimony related to the securing of the scene?
What Core did, yes, Your Honor.
What court?
What Officer Core did, correct.
Mr. Gubitose?
Well, he can ask all the questions he wants on cross-examination. The testimony is what the testimony is.
Well, it shouldn't come in at first, Your Honor, at the first instance if it's not based on personal
All right,
knowledge.
I'm going to overrule the objection, but I certainly understand your point, Mr. Bradl. I'll look out for it.
Thank you very much, Your Honor.
Now, Judge, I have a number of pictures that I'm going to be displaying, and you said
Okay.
earlier that you wanted to see them first.
So they've been,
Pre-marked.
pre-marked? Okay. Well, no, you're going to display them there? Yeah, that's fine.
Yes.
Just, but let's just make a record of what's been pre-marked, if you could, Mr. Ruane.
Yes, Your Honor. The parties agreed to pre-mark exhibits 1 through 72, which are all photographs, and then exhibit 73, which is a thumb drive in an envelope. So the
I'm sorry,
next-
I didn't hear you. 73 was what?
A thumb drive in an envelope.
In an envelope?
Yeah.
Okay.
The next numbered exhibit would be 74.
Okay. And counsel, I want to commend you folks for getting together and having those pre-marked. It definitely speeds things up.
Those are agreed to.
Okay. All right. So, no, that's fine. I know what I said, but you can ignore it for now.
That's
Thank you.
fine.
if it doesn't get fleshed out, we'll go back. Right now, he's just giving numbers, so I muted it, but here we go.
Can you see that?
Yes,
What's that?
that's the residence.
Aye,
That's the
aye, aye.
residence that Ms. Fitzsimmons was living in there at the time?
Yes.
It should be what's been marked as exhibit number 2. Do you recognize, there's some glare, what that is?
So that would be if you're looking at the house, I think that's the school in the background there.
So is this the school over here that you were talking about?
Yeah, it's tough to see, but I believe that's the school.
Any way to do something about is that the way the photo is?
It's like that too. I'll pass it up to your honor.
That looks like the fencing that runs between the school and the house.
May I approach you?
Mr. Roy, can I just see that real quick? Thank you.
Hey, buddy.
Okay, I get it. So do you want to take another look?
Oh, actually, I can see it better with this one. Yeah, that's the, basically to the right of the house.
And that's the school that you were talking about?
Yes,
That's where her car was parked, back that way?
yes.
Was there anything in the driveway at the time that you got there that would have prevented someone from parking in the driveway of the house?
Not that I recall, no.
I'll show you what's been marked as exhibit number 4. Do you recognize that?
Yes, that's the residence.
Number 7.
That's the main, the door to come in the house.
It is Massachusetts.
Number 8. That's the
Same.
stairs going up?
Yeah, stairs in, yeah.
Can I'm sorry, can I see exhibit 8? There was some glare and it's just difficult. Thank you, Mr. Roy. So were these photos taken that night? I guess I'll ask you, do you know, were these photos taken that night?
Not by me, but yes, I believe they were taken that night.
Okay. Thank you.
I'm showing you what's been marked as exhibit number 9. Do you recognize?
That's
that?
when you walk in that first door, it's like a enclosed porch.
Exhibit number 10.
The main, to get the door to get into the main house.
So when you walk in, that from the porch, you see some stairs on the right side of the doorway.
Yes,
What stairs are those?
those are the stairs to get up to the second floor.
I'll show you exhibit number 13. You recognize what that is?
Yes, that's the living room.
So as you walk in the front door that we were just looking at, to the left,
Yes,
do you see where Ms. Fitzsimmons was sitting when you asked her to take a seat when you first got in there?
yeah, so where that blanket, the red and black checkered blanket is on the couch, she was just to the left of it.
So right here?
Let me just excuse for one moment. Can you folks in the back row see the photos?
Yes, Your Honor. I'm okay with where it's at. If I could just inquire.
Sure.
We can see it. Thank you.
Okay, I just want to make sure, thank you. Yeah, go ahead.
I'm going to show you what's been marked as exhibit number 14. Do you recognize what that is?
Same room.
This is a different angle.
Yep.
Show you what's been marked as exhibit number 22. Do you recognize what that is? Is that if you walk into the living room and you take a right, there's another room there that then leads to the kitchen? Does that make sense?
Yes. Yeah.
Is that room that we were just looking in?
Correct, same.
I'm sorry, what number was that you
I'm
just?
sorry, that's 23.
Thank you.
I'm showing you what's been previously marked as exhibit number 25. Do you recognize what that is?
That is the kitchen.
Okay, so right now we've started going in the front door, gone to the left through 2 rooms. Now this is the kitchen.
Yes.
And is this where you said Ms. Fitzsimmons was gathering bottles and?
So just past the refrigerator, you can't see it in this photo, but there was some drawers in like a cabinet that she'd opened. There were some jars and things in there.
Do you recognize what that is?
Yes, that same room, that's the cabinet where she retrieved some jars and maybe
And
formula.
that's exhibit number 30.
So that, when you say the same room, you mean the
As the
kitchen?
kitchen, yeah, part of the kitchen. Just different angle.
I'm gonna display, maybe to clarify, number 29. That's as you walk into the kitchen and to the, in the photo, to the left of the photo is that, the drawers that we were just talking about?
Next to the refrigerator, yes, yes.
Do you recognize what that is in exhibit number 31?
No,
Would that be the stairs down, going down to the basement?
potentially, yeah.
Okay, well, I'll get that.
Sorry.
And do you recognize this room?
Yes.
What room is that?
It's
I'm sorry, what exhibit number are you displaying?
32.
Thank you.
it's off of the kitchen.
Okay. So and now we almost went around the whole house. in a circle.
Yeah.
Now I'm showing you what the mark is exhibit number 33. You recognize what that is?
Yes.
Okay, what is that?
That'd be a photo from the bottom of the staircase looking into the room where we were at first.
Okay, so the picture taker would have just walked through exhibit number 32, that last room, and came full circle.
Yes.
show you what's been marked as exhibit number 35. You recognize what that is?
Yes.
What is that?
It's the staircase to go to the second floor.
Number 36. You recognize what that is?
Same staircase.
Mr. Gubitose, can I see that before you, because there's some, it's hard to see. Thank you.
Exhibit 37. Can you describe what we're seeing there?
That's if you were at the top of the stairs, looking straight on.
And here said there's a room to the right. Which room would that be?
That's the bedroom where the shooting occurred.
Exhibit number 38.
That's a photo from the top of the stairs also.
Okay, that's in the, you see a room on the left side of the photo. Is that what we call the baby's room?
Yes.
Mr. Gubitose, may I see exhibits 37 and 38? I'm just getting some glare. Thank you. Thank you. I'm sorry, Mr. Gubitose, do you mind, on exhibit 38, I had trouble picking up what that was.
Sure.
Could you just ask him again?
So I'm going to show you exhibit number 38. Can you describe what we're seeing here?
That's if you were at the top of the staircase. I guess you'd call it a hallway in between the two bedrooms.
Thank you.
Exhibit number 40.
That's the baby's room.
Exhibit number 42.
Same thing, the baby's room.
Different angle.
Different angle.
And
I'm sorry, that was 42? That you just showed? Okay, thank you.
45. Can you describe what that is?
That's the baby's room also.
Exhibit number 46. You recognize what that is? Is that the baby's room looking out the door towards the landing?
Yes.
And exhibit number 49. You recognize what that is?
That's a picture from the hallway into the room where the shooting occurred.
Into the bedroom?
Correct.
Now, you see a chair there inside the room. Do you remember, was that chair placed in that position when you first saw it, or was that moved at all by fire personnel, if you remember?
I don't recall.
Silly question, but I'm having trouble seeing the glare. Is that police tape?
Yes.
Okay.
I'm just having trouble seeing it too. Maybe if we could just angle that this way
Sure.
just a little bit. It's hard to see it.
Sure, no, you folks should see everything.
That's fine. Thank you.
And can you still see?
Yes.
Okay.
Exhibit number 50.
It's a photo of the bedroom from the doorway.
Exhibit number 51.
Same. It's a photo of the bedroom from a different angle.
So it shows the left as you walk into the room.
Yes. It showed like the hard corner if you came in the room.
Exhibit number 52.
Same, it's the bedroom where the shooting occurred.
Exhibit number 53.
Same.
Okay, now in this photo, you can see an air conditioner. You can see the bed on the right, correct? A bassinet on the left.
Yes.
When you came into the room, where was Ms. Fitzsimmons?
So she was just past the bed, like her head had pretty much, her head was by the wall where the air conditioning unit was, and her feet were angled out just to the left of the bed.
Okay, so her head was
Furthest from the door, so
over here?
probably a little to the left of that.
Okay, and her feet were facing this way?
Yes.
So can I ask, so when you say that they were angled, the feet were angled out to the left, that you mean our left as we're looking at the photograph or her left?
No, I'm sorry, our left is, we're looking at the photograph. So it would be her right if her head was towards the air conditioner.
May I ask the witness to get that down in the person's screen? Just to-
Yes.
Could you just describe the positioning of Ms. Fitzsimmons when you first walked into the room?
Yep, she's basically here. Like if my hand was the body, it was kind of laid like this. Her head was right over in here, and her feet were over here.
And where was the gun?
The gun was by her left leg. She was laying on her back. It was somewhere right in here. But I couldn't see the gun until I got up to her.
And then you moved her, and then you saw the gun, or did you see it?
I saw when I got up on where she was.
Show you what's been marked as exhibit number 55. Do you recognize what that is?
Yes. It's the bed, same bedroom, and that's the area she was laying in, right? It'd be like the bottom of the screen,
Okay.
or the bottom of the photo.
That's the opposite side of the bed.
Yes.
Now, when you went up there and you were attending to Ms. Fitzsimmons and after, did Officer Noonan say anything?
Well, well, she was still there? No.
Did he say anything?
Well, actually, yeah. I mean, we were both
Whoop.
telling her to,
Sorry,
like, just
Jack.
breathe, calm down and breathe.
Okay. Did he say anything after she was taken away?
Yes.
What did he say?
When we were basically in the hallway towards the baby's room when they'd taken Kelsey down the stairs, and I heard him say that she pointed a gun at him.
Objection, motion to strike.
Why'd you wait so long? Hearsay. Sustained. Stricken.
What was his demeanor at that point?
Officer Noonan's?
Yes.
I think he was sort of in shock a bit, like everybody. I mean, I think we were all clearly taken by surprise by what happened.
And how long after you, after the shots were fired, did you have a conversation, without saying what it was, with Officer Noonan about what happened?
Maybe 5 minutes, just based on however long it took the the medical staff to get her packaged up to get her to a hospital.
Your Honor, I would ask for a ruling on an excited utterance at this point.
An excited utterance from Officer Noonan?
Yes.
And Officer Noonan's going to testify?
Yes.
Then no.
And counsel?
I would object her.
Well, I think I need more of a foundation, but if it qualifies, I'll.
Let
Can
it
you
in.
say that it was?
All right. So right now, an excited utterance is an exception to hearsay. I don't know why the defense didn't argue that, it's cumulative. It doesn't need to be admitted twice, Your Honor. This officer is going to testify, but also what he saying what he said out of court is also hearsay, I guess. So now the state's going to try and lay a foundation for an excited utterance, which requires that you be under the excitement, emotionally affected at the time. So a lot of times it's like while somebody's still crying from the incident, while they're like, oh, hyperventilating and talking, stuff like that. But it's an excited utterance. You're under the heat of the moment. You're feeling the effect of it. You don't have time to lie. Is the theory for an excited utterance?
It was about five minutes after you heard the gunshots, right? That you had a conversation with him and he said something to you, correct?
Yes,
In the meantime, you both had been tending to her wounds, true?
yes,
And you said he was, seemed to be in shock, which is different than he normally was. When you talked to him at the station.
yeah, definitely.
And how so?
I think, like everybody else, I think he was overwhelmed, a little bit, trying to process what just happened, bewildered.
Sustained. As to what, like everyone else, I just need to know what the officer appeared to you. What his demeanor, what was his emotional state, etc.
I wouldn't say he wasn't emotional. He appeared shaken a bit.
All right, so no
Redo my,
excited utterance. Move on.
Request, Your Honor.
No.
Lack of foundation.
Yes.
And this was 5 minutes after what? After the shooting, 5 minutes after, I'm sorry,
Medics
this
came.
is to you.
5 minutes after the shooting.
Oh, he's
So
making
how
it
long
close to
did it
bullshit.
take for the fire department to remove Miss Fitzsimmons?
I'm guessing around 5 minutes. It may have been quicker.
To get
Fire
there,
department was there that quickly?
The
come
fire department
on.
was there very quickly. Yes.
All right. I'll tell you what, this
Call him
sounds like
bullshit.
seems like a good time to take a break,
There you
our
go.
morning break. So, and I will rule on the objection when we get back. All right, so we will stand in recess safe for 15 minutes. Will that work for everyone?
Thank you.
Okay. All right, thank you.
All rise, please. We're standing in a 15-minute recess. Please exit quietly. Be seated.
All right. So I'm looking at the hearsay exception to Massachusetts specifically. They almost, let me make sure that I'm not muted. No, I'm not. Okay. All follow the federal rule. A spontaneous utterance, if A, there is an utterance or event sufficiently startling to render inoperative the normal reflective thought process of the observer. Come on. I thought you said this is the guy who's the calmest, the coolest under pressure. And B, the declarant statement was a spontaneous reaction to the occurrence or event and not the result of reflective thought. So I assume right now what the judge is doing is going to look up some excited utterance stuff. And I let the dog out and now he's barking to get back in. So stand by. happening here? Did I pause it or I just muted it? This is what they're showing during it? Wow. I'm gonna let it run muted. We are live. Just took up the last of our blooping time. I'm gonna go over some of your guys' questions that I have flagged. But yeah, you know, they're saying like he's got emotions, so he was so startled and that he is so startled by it that it rendered his normal reflective process, inoperative. Inoperative. But this is a line that now the state has to decide how they're going to walk. How they're going to walk it. So people in court had mentioned, because at first I was like, well, why didn't she just wait till they were gone? Like if she was so worried about not having anyone around while she shot herself, I was not thinking because they're about to take all of her guns. So that story now, makes sense that she's trying to get a minute away so that she can unalive herself. And then DB says, and this was like in response, I guess, something that Cop's daughter had said, that unless she was trying to unalive by self-deletion by Cop, that means she brandished it menacingly. I didn't read the rest of your comment, which would be true. So that's not what they want to argue, because that is precisely the same, the crime that she is charged with. If you pointing it at him, trying to make him think you're going to use it, that's assault. An assault is that you were put in imminent fear of somebody using a dangerous weapon on you. So that wouldn't be helpful. Now, I think what DB is talking about here when he says, unless the judge just takes his word for it, is my number one concern with this. You can have a he say, she said, he said, she said, where you decide that one person is 100% credible, that you haven't impeached their credibility to me. And you have another person, because here it goes in line with this comment here that Polly said. Polly said she remembers extremely clearly, and I believe her 100%. And I think that's in response to me saying, well, that they were arguing that she could, like, in the heat of all of this, took note of the flustered appearance of Noonan. Now, I'm not saying that I don't believe that she took note of that. I'm trying to give the perspective of like the judge looking at it. Like, well, how much do I believe she's taking note of his flustered look on his face while this is all happening, but if the judge were to say she was the one in the midst of a mental health crisis, he was not. She was the one not thinking clearly, he was not. I'm not saying he's going to. I'm just saying that's why I had so much pull and push with a potential bench trial. Now, Bradl knows this judge. This is stuff that he's reflected on in making this very difficult decision, that he thinks this judge is going to say, and I think I might have starred, Cop's daughter's comment here. I think there's reasonable doubt in favor of both Noonan and Kelsey. And that's all we need. We don't even need reasonable doubt in favor of them. We just need some, well, yes, but like something to say that both people had a motive to lie. And I think that that's very easily argued here when you're talking about from both parties' perspective. Clearly, Noonan had motive to lie. And the judge can say, although even if in my personal opinion, I don't think he lied, I have to balance that motive to lie when I am coming up with reasonable doubt in this type of scenario. And that leaves my hands tied to find reasonable doubt. There is an avenue for that, but there's just this fear that what if he somehow says these stories are so completely contrary that one of you is lying to me, and I believe it's you, Kelsey. Now, obviously that would be the worst case scenario, but Bradl knows the judge, and I think that Bradl is clearly of the opinion that this judge is never going to take a he said she said and say I find beyond a reasonable doubt that what Noonan said is right on where the gun was pointed at the time, you know. And then Amy had said, if he's so much of PTSD, why would they let him still in the police department? I think that's going back to me saying, well, maybe they could have argued that he was suffering like that situation brought back sort of, I'm calling it PTSD, but brought back the fear of whatever situation they had been in before where something happened. And then, but I don't know if that kind of argument holds water anymore because the state's the defense's theory that there was no room for him to be overly reactive, think a gun might come towards him, so he rushed and pulled the trigger and shot her because the defense is very clearly saying no. He knew damn well she only had that gun pointed at herself. It didn't move. He even went through that. That was like my whole thought. I was like, well, if on its way up, he thought it was pointed at her, not her pointing it at him, because she needs to take a knowing and intentional, action to assault him. That it was already pointed at her head. And that might be because of Bradl's concern that even if they say that on the way up, if it pointed at him, that's assault. That put a reasonable person in fear that they're going to get shot. That's why they took this kind of route. But I don't know. And then I'm just saying, says, and he missed the first pew pew. We keep talking about that. That doesn't say calm, clear, and collective. That doesn't say someone who is, making a rational decision in the moment. It says chaos in his mind and in his movements. So that kind of goes against him along the same lines that this excited utterance argument, it goes against the Commonwealth. Now, a lot of you brought this up. I flagged Cop's daughter's comment about it. What's their point about the car parked away? Now, it was seeming to me, I don't know where they're really going with this, but like, are y'all trying to say she knew it was coming? She parked the car away to make you think she wasn't there? Or because she planned on doing this and she wanted like that somehow that was like part of the scheme, the overall scheme that she was getting at. I don't know what they were trying to get at. But I guess we'll hear it in closing arguments for sure if it doesn't come back around and questioning again. Okay, and now obviously a lot of us were talking about what we heard. Did this witness testify that Kelsey said, "I'm sorry and I want to be unalived," or "I'm sorry, I don't want to unalive"? If we're still up in the air about that, this might be a perfectly good time to try and rewind it and listen again. So, and bear in mind, when I'm over there reading those comments, I am not looking at your comments. So I could be missing some, but I'm looking at them now. And Brian's deviated septum says she said she wanted that. Okay, she went back and listened. I thought that's what I heard as well. I rewound it in the time. We're all thinking that it was I want to. So that issue is resolved. I'm going to unstar all these comments since we have discussed them. There was another super. Bob's going to hurt me. Not really, obviously, that I have not created a goal. I know there's a little button down here that I could press it and do it with. I just haven't. I don't even know what I'd be offering. in Goal World. Mary Holt became a YouTube member. Well, welcome, Mary. Name sounds familiar. I don't know if we've seen you in chat before or what, but welcome. Family hug. Keg 0830 became a member. Welcome. Family hug. Thank you. Now, Allie, this is another comment I had flagged. It reminds me to talk about it later instead of me writing it all down. Why was this not covered before trial started? And that was what we dealt with in the morning. That was Bradl's whole motion about they need to turn over these statements to us. I'm shocked that he waited that long. I mean, I understand like things get busy. There's a lot going on. Like it happens, right? It happens. That's not a good thing. No, you should have this question while trial is pending. However, I think the judge was 100% wrong in saying that the prosecution doesn't have control. Control means the ability to get it. It's within someone within your control's ability to get. You have to make an attempt to reach out and get it. Try to get it. And the judge said, under our laws, that's not in the possession, custody, and control of the prosecution team. But under the U.S. Constitution, as I know it, what is in the possession of the police department is considered in the possession of the prosecutor. And I would think that would extend to in the control of the police department, because those three words are all the same, and they consider the police the same as the prosecution. That's so that the prosecution can't hide behind. I mean, that's where our Brady and Giglio or Giglio or Gigio, if you're the judge in look, my brain's so dead. In what's her name's case, Richens, are there. You don't pretend you don't have it because the cops have it, not you. If it's in your knowledge or the cops' knowledge, it's in the prosecution's knowledge. If it's in their possession, custody, and control, it's in your possession, custody, and control. And I think the police had an obligation to request it. So the prosecutor directs the police, request from the company you employed. Clearly, it is in your control to turn over these statements that were made during the independent investigation into this shooting. The independent investigation that supposedly found that Noonan was 100% in the right. And he wants to get their statements, and he should have their statements. And the only reason that the police don't have them is because somebody was concerned that they shouldn't have them. Like we want less, so we don't have to turn it over to the defense at some point. No, you've got to turn it over, and the judge is giving grace. Bradl, he's like, look, I know you, I know you need this, or you have a right to it, or you should be able to ask for it, and give him some avenues for doing that. But yeah, so I where we ended, for anybody that's wasn't paying attention, they're trying to get in, the Commonwealth is trying to get in the statement of Officer Noonan as they were leaving or walking down the stairs or whatever. When somebody I think this witness or someone asks what happened, she tried to shoot me or she shot at me. And the defense argued that that's hearsay. And the judge sustained that objection. Then the Commonwealth started to go through the foundation to establish that it was an excited utterance, which requires that he be so startled that and like emotional about it under the startledness of it, that it renders inoperable his normal reflective thought process of the observer, so that his statement was so spontaneous that there was no ability for him to have sat and thought about it and come up with a lie. And that's why they've come up over time, and these are old as hell, okay? Old as hell, that they've decided that somebody still so startled, like as soon as you almost see something, right, is a spontaneous utterance where you're just saying something while you're still under the emotion of it, that you don't have time to lie. Oh, that can't be a lie. This guy was still under the emotion of the whole thing. No time to lie, no time to think of a lie, no time to feign emotion. So the judge said, well, it's a good time for a 15-minute break. It could have just been that there was already a break in the flow and he wanted to take a 15-minute break, or he's looking into excited utterance. And I am sharing mozzarella sticks with the dog. Because that's what we do. That's what we do, don't we, buddy? Yeah. All right, let me come back in here to your comments, see if everybody's saying anything. All right, so I'm wondering if this is still Bailey's comment after I just said this again. Went over it a little bit more. So yeah, I don't know. When I hit now I'm logged in as Bob under Defense Diaries whenever we're sharing streams. So I guess when I clicked this up, like, I don't think that this means Bob was watching any of this stuff. I think this is just things that get suggested based on the video that we're in. Because, well, he could have been, I guess, but I've never seen him watch the Howard Stern show ever. So I don't think that's what was going on. But if you saw that earlier and haven't figured it out, like that was some kind of up thing with the mouse that made those other suggested videos come out. I don't like these 15-minute breaks. It's so much easier when Bob's here and we can talk to each other. I just want to sit here like this. Hi guys. What should I say next? Let's talk more about this camera guy. Why is it all fuzzy? What's happening? Oh, there's a leg. Oh, there's an arm. No, I mean, I can do better than that, but it's hard talking to a screen. It's hard talking to a screen. All right, Bailey says, okay, she's got it now, the whole excited utterance thing. Thanks, Intuitive. They are just suggestions. Yeah. All right. I saw somebody, I don't know, messing around like, oh, now we've seen Allie's playlist. I'm like, the hell you have? Because this ain't even mine. And now I'm giving the dog all of my cheese sticks because the trial's not on, so I can't just turn off my camera and eat my little cheese stick. He wants them all. He wants it all. So Kyle asks, with the police reports, interviews not handed over, would you have asked personally for a continuance? Well, I don't see how I could, because he waited how many ever months to even request it. But I think he could have said that anybody that like, here's what I propose, Your Honor. If this guy, Lieutenant Sean Daley, is one of the people who was interviewed and we don't have it come his cross-examination, because I think it'd be relatively quick, like pretty damn easy for the police who hired a company to do an investigation, to turn over they probably told him destroy it. If they really didn't want it, they probably told them destroy it. But then you would want that. When did they tell you to destroy it? But assuming they didn't, the police department did not instruct the company they hired to do this independent investigation of the shooting to destroy stuff, then they can just easily, gosh, Nook. Now he's like, but you stopped sharing your cheese with me because I'm not eating it. We share when I'm eating. You get to share some with me. You don't just get to eat all of it. Now you sit and relax down. I'll give you a little bit every so now and then. For them to just call over and say, send me immediately, these interviews or transcripts of the interviews, whatever the case may be. So then I'd say to the judge, if this was one of the witnesses that was interviewed, then we'd ask that he be recalled and subject to further cross-examination whenever we get this, because it's a judge. So just like do it do it whenever. It doesn't matter. Got to call him back. You know, and I put a different doggy TV daycare thing on upstairs that I don't know if he's just not interested. Oh, we're back now because I've got the cheese or what? Oh, I got to turn the sound back on.
Your Honor, we're back on record on the Kelsey Fitzsimmons matter. All counsel and the defendant are present.
All right, so we left off, and the Commonwealth seeks to admit a statement made by Officer Noonan at the scene as a spontaneous utterance. The defense has objected. Does either side want to be heard more?
I would, Judge.
Please.
I would like to be heard. So the government wants to have it both ways here. You know, they want you to think that this guy is cool, calm, and collected, you know, and then they want to get some statements in a completely different aspect. So, you know, statements that are excited utterances are, you know, they can't be made after there's been time for reflection, you know, time for possible fabrication. Here it's 5 minutes goes by, and, you know, this is not, you know, I know probably all of us attorneys in this room, and Your Honor certainly, are used to thinking about excited utterances maybe in a little more of a liberal fashion, like a domestic violence victim, someone who is completely upset and the upset continues. You know, they've gone on record saying how professional and cool and calculated this guy is. So that plus the 5 minutes, plus the time for fabrication here, plus the motive for fabrication, I think makes it fatal to the government's efforts, and I think you should deny it.
Anything in addition, Commonwealth?
Your Honor, the declarant himself need not be excited. It is the fact of the matter that the declarant is still under the stress of an exciting event. And the court should consider the factors such as whether it's made in the same location as the precipitating event, temporal proximity, age, spontaneity, and degree of excitement. Your Honor, the Commonwealth is not claiming that, you know, Officer Noonan was in shambles after the shooting. Certainly not, but he was still under the pressure of the event. It was within minutes. It was in the same location. Officer Noonan is present, is willing to testify, available for cross-examination, no confrontation issue. So I would suggest that in the court's discretion, you allow the spontaneous utterance for whatever degree of value you see fit.
Okay.
The last thing, Judge, if I may respond, is sorry. It's just that, you know, this is the exact time you would fabricate when your colleagues are starting to form opinions about what happened. It's the exact incentive. It's the exact time to fabricate. Thank you.
Okay. All right. I think Attorney Moriarty was referring to the factors in Commonwealth versus Baldwin. At least I think that's a more recent case that has them, which is at 476 Mass. Strike that. 476 Mass 1041 at page 1042, a 2017 case. So I can say that a lot of the factors, you're right, do gravitate towards admission, them being admissible, but I am going to sustain the objection. This will be somewhat of a double negative, but I'm strike that. I am unable to find by a preponderance of the evidence that the statement was not the product of reflective thought.
There you go.
So the objection sustained. All right, you may continue, Mr. Gubitose.
Thank you. Just one other question. You were on scene at the time of the shooting, correct?
Yes.
Was your gun checked after the shooting before you left the scene?
Yes.
At this time, Your Honor, I would be playing exhibit number 73.
Okay, which is what?
A video compilation of surveillance outside of the house.
Outside of the house?
Well, outside of the house, including the basement.
Okay. And this has been jointly admitted, right?
Yes, Your Honor.
Okay. Yes, you may play it. Is there sound too, or is it?
No.
Can you folks in the back row see all right?
Yes, thank you. Oh, sorry. Just, you can see when it's on the screen.
That's okay.
Well, Your Honor, I wasn't going to ask any questions of this witness during the video itself anyway, so I think I can, in my questioning, I can play it after when we have it all set.
Okay, well, Mr. Wayne, you think you can just in a couple minutes, or you're not sure?
I'm not sure.
Okay, all right. All right, so, yeah, why don't we maybe try to fix it at the lunch break? Would that
Tech
work?
wizardry.
Would that work for the Commonwealth?
Sure.
I'm going to take a lunch break now.
All right, but if we're going to do that, Mr. Wayne, is that? That's okay.
I have IT here. I can have them come up at the break.
Okay, that's fine. Thank you.
Guys, give me ideas for what to do for a goal. Oh, now my dog leaves when he knows I've got no food left. Wow.
All right, so do you have questions? Do you have additional questions?
No.
Oh, I'm sorry. I thought that you had additional questions.
No,
Oh,
that's what I said. I wasn't asking any additional questions, so I
weren't
can.
that. Okay.
I can sit down.
So I guess, Mr. Bradl,
Yes.
we started to watch Exhibit 73 at cutoff. We're having some audio visual difficulties, which is my signal for our IT folks that may be in the building
Right.
to come on up and help us. But while I'm stalling doing that, are you okay with marching forward with your cross?
I can-
Without-
I can
without it-
start, But it is my problem now, Judge, I guess, and I just
It is,
would like
okay.
it to work at
So
some point.
So to be clear, you want to use this video in your cross?
Yes.
All right, well, in fairness, if that's the case, then I should allow the Commonwealth an opportunity to play it. So where's our IT?
so are we about to go to lunch?
Okay, excellent.
They're on the way.
My name is Khan.
What?
What
What kind of torture is that? A Philly cheesesteak? You know I'm in Illinois. Don't tease me with a Philly cheesesteak. Although I prefer the chicken cheesesteak. But, you know. That's not right. I love me a chicken cheesesteak. We do have the Jersey Mike's out here, which is really good as far as like getting close to a Philly cheesesteak. And Bob and I get those without the bread. They do like a bowl, but they do their bowl over lettuce. I'm like, no, I don't want lettuce touching my cheesesteak. So, I'm just like, no lettuce. Just stick it in a bowl. It's not the same, but it's pretty damn close. Virtual drawer. I'll tell you from one Philly girl out here in the Midwest, it's pretty damn good. The bread is key, and I think they have that shipped in from the East Coast because it's the water and it's the elevation and I don't know what, but you can't just make it here. Can't make the bagels aren't gonna be the same, the bread's not gonna be the same. So well, Milk Us Headphones says they have the worst veggie options. Also, the cold sandwiches suck. I stand there watching people order cold sandwiches. And I'm like, why aren't you just going to Subway? Get yourself a hot sub or go home. But the bread is better, so I guess I can't blame them. What the heck is Highway 55? Where is that? By the way, I am not a sandwich person. I will not eat a sandwich. I do not want a sandwich, but I just don't think you can consider a cheesesteak a sandwich. I mean, clearly it's a sandwich, but like I have never had like I'll eat lunch meat like without the bread. But I don't know why. Just don't like sandwiches. But I mean, I'll eat a meatball sub. You know, when we get our hoagies on the East Coast sitting on the beach, I'll find something. But yeah, I don't like cold sandwiches. No, I know. Well, I mean, so on the decision on hearsay, I just want to say, I mean, that is the whole overarching decision. What is their time for reflective thought? Because that's key. So the judge just cut through all of the nonsense and said, at the end of the day, I cannot say it was not a result of reflective thought. And it's rulings like that, when you think through his logic, that make you say, all right, this was the perfect judge to go to a bench trial with. However, on the other hand, now the judge, I don't believe he's made up his decision yet. So I'm not trying to suggest this right now. But the more times you win arguments at a bench trial, judge is letting shit in, letting everything in. You're like, oh, wow, he's really letting all. That's about when you're about to get screwed.
Mr. Gubitose,
You're about to get
if this
screwed.
were to play to its conclusion, you would have no questions? Correct. Okay. So then, why don't we do this? Let's march forward with the cross. And obviously, Commonwealth can follow up on redirect. And maybe by then we'll get it working. All right. Unless you were going to start with that.
I'm trying to be flexible, Judge, but I do want to set the stage with how Kelsey came home and how they came to the house.
No, that's fine. You should be able to try your case.
Judge, just an idea is we have the actual
Oh,
DVR
sorry.
from the house, and so we have the same stuff. We may be able to play it from ours. Actually, it's even better. We do have their compilation.
Okay.
Play from here, maybe.
Right. You have the exhibit. You're just putting it in a different computer.
Okay.
Right. Is that right? Can you just confirm that that's right? That
Yes.
It's the same exhibit? Okay.
Yes, sir. It's what we received.
All right. So let's see if we can get it moving, and if so.
We have enough number.
Well, looks like the defense is going to be able to figure it out. I'm going to finish that statement so people know where I was going. But, sometimes you learn when you're dealing with the judge, he's letting all of your shit come in and giving you the benefit of all the rulings. That's because you're about to be the losing party. So there's no, no appellate issues. I'm going to give you everything you ask for because I'm about to hand it to you. Now, again, I do not think this judge has made up his mind yet. So don't think that that's what I'm saying, but I'm just saying that's a thing. That's a thing. So we'll see how things start to play out as the case progresses more and the judge has heard some more evidence. But the logic that he went through there is the perfect logic, and it's what says, all right, this was the great judge to go do a bench trial with, if there ever was a judge to do a bench trial with for this case. But all right.
All right, so why don't we do this? Let's start from the top. Can you just replay, just start it from the beginning? We're still going to consider that this is during the direct by the Commonwealth of the lieutenant, and this is Exhibit 73. And now, of course, it won't work because I've said too much.
There it is.
Okay, thank you.
See, the camera even picks up when cars drive by, it looks like. So, oh, that's her coming in. My bad. All right. What are those little drinks out there? Is that Aylaian's little drinking stoop? They have straws, though. That makes you think woman. But, all right, Bob told me what to do for a goal. See if I can remember how to do it. Oh, I have to do it in YouTube. That's confusing and difficult. Babe, can't you do that? Oh, that is actually pretty sweet. At least the baby's not crying yet. So is that the sister? Oh, no, that's the mom. Okay. That's Justin and his little sister? That's not the sister who was on the phone, right? Is it? She looks young. Your little scheme worked. It's shocking we couldn't hear him. We could hear like other noises. See what he starts looking for down there. Where are you headed? What you looking for? Oh. I mean, he knows he's on camera now. Now what's he doing? What you up to? Oh yeah, what do you need now? What was? Did he hear gunshots? Is that what happened? I keep thinking we're hearing sounds, but we're hearing sounds from the courtroom, I guess. Oh, her mom. Wow. Just runs like a limp dick. What a limpy. A total limpy. Tripping over himself to get away. Limpy. How could you just run away when the woman you almost married is in need of are they not paramedics? Because like what the fuck is going on? Oh my god. Aren't firemen paramedics? Somebody help me. A first responder just limping away. Woman you almost married, mother of your child. I'm just going to trip over myself and run. Pansy ass. I could see maybe like the first shot and you're thinking, all right, she's coming to get me, right? And he runs into the room back there and hides. But then just darting out of the house when now you clearly know, like at that time, you know someone's in need of medical attention and the cops got the area secure. Oh, jeez. Oh, we should have, yeah, what is the time? I want to to check his 5-minute thing. So just a big fat liar, because now it's 4:18, 5:18. Damn, I should have been paying attention to that. We got to go back later, or somebody go check it out. When he runs his ass into the back room, the time on the camera at that point till like this point, and when the guy supposedly says she shot at me.
That's it.
Is that the conclusion? Okay. And, all right, so we've ended Exhibit 73. The Commonwealth has no further questions on direct at this time? Okay. All right, so cross-examination.
Thank you. I'm sorry? Photographs. Going to
Photographs, thank you.
Lieutenant Daley, good afternoon or good.
All right, that's all right. I just need to be able to see Mr. Bradl.
Mm-hmm.
All right, all set, Mr. Bradl.
Sorry, did something just happen? Sorry, I was hoping to just.
Oh, you're going to replay it. I'm sorry. That's why.
I'm going to use it. I'm sorry. Yeah.
No, that's okay. All right. So
And that was
I'm
actually
sorry,
working pretty well.
Mr. Wayne, then I shouldn't have moved.
Sorry.
No.
So do what you need to do.
Okay, you ready?
All right, may I inquire, Your Honor? Thank you.
Yes.
Good afternoon, sir.
Good afternoon.
So we've never spoken before, correct?
Correct.
And you did not write a report in this case?
I did.
And where is it? Who did you write it to?
Where did I write a report?
Right. When did you write it?
Afterwards,
And was it submitted in discovery?
How would he know?
I don't know. I wasn't involved in that.
Well, this is an issue. Your Honor,
Now, as far as preparing for trial, did you meet with the Commonwealth to do so?
I did
And how many times did you do that?
once,
And when was that?
last Friday.
Last Friday. Okay. And so it's been obviously since June 30th since this happened, correct?
Correct.
And you've been on the job with Officer Houston?
I'm just pausing for a second to say it sounds like Bradl doesn't have this guy's report. So I don't know if he's going to ask him a couple more questions and tell the judge, Your Honor, we need his report until we finish. Because that's a fucking problem for the Commonwealth if Bradl doesn't have this guy's written report.
Correct.
You've been on the job with Officer Noonan?
Yes.
Now, in terms of this incident, isn't it true that you spoke with Justin Aylaian at the police department before going to Kelsey's house on June 30th?
Yes.
And was that in person?
Yeah, in the lobby.
And how many times did you speak with him altogether?
In the lobby? Or
Anywhere
I,
this?
if I had spoken to him at a work, like if he was on some type of a medical event,
I mean about this incident, about the
Oh.
service of the restraining order.
just in the lobby.
So
And
once-
then when I called him on the phone to come over to the house, I've never spoken to him on that.
All right. How did you get a hold of his phone number?
Because he gave it, I asked him for his phone number when we were in the lobby before I left, and I told him to wait in the lobby till I called him to come over.
How did he come to be at the lobby of the police station?
I don't know.
Why
I would
was he-
assume he drove, but I
Well,
don't
you
know.
interacted with him, right?
I did.
Was he there to see you?
I don't know if it was necessarily there to see me. He was there to bring in the restraining order and to work out the logistics of the essentially taking custody of the child.
Okay. So he brought you the restraining order?
He brought a copy of it, and we had a copy of it that had come in electronically.
Did he show you a copy of his affidavit at all?
He did.
And did you bring that to Ms. Fitzsimmons?
No.
So you had it with Mr. Aylaian, but you didn't share it with Ms. Fitzsimmons when you served the order?
I didn't share it with Ms. Fitzsimmons when I saw the order. No.
Now, just so we have this right, Mr. Aylaian went to probate and family court, filed a lawsuit, essentially, a restraining order, getting custody and making all sorts of allegations against Ms. Fitzsimmons, right? That was your understanding?
Yes.
And he was living in Stowe, Massachusetts with his parents at the time, correct?
I don't know where he was living.
Okay. Did you ask?
Did you read the
Did
affidavit,
it matter?
petition?
Where he was living, well, I knew he wasn't living at the residence because if he was living at the residence, it would have changed things as in Ms. Fitzsimmons would have had to vacate the residence.
There you go.
The judge would have checked on that.
So he's not living at Phillips Brooks Road, right?
Or he had somewhere else to stay. I didn't ask him.
And there's no provisions here where, in this order, where he's trying to get her kicked out of her own house, right?
Correct.
So he's an adversary to her. He's gotten an order from a court that says, I'm afraid of her, keep her away from me, right? That's what it says in essence, right?
Correct.
And you summoned him to the house where she was.
To pick up the child, yes.
So have you ever served an order where you brought the person who says they're afraid of the person to the person before?
If there's going to be some type of a custody exchange, yes.
Have you done that before?
We have, yes.
Not we, you.
Yes.
When?
I don't recall, but I know it's happened.
Okay. So how long after you got to the house and you gave Kelsey the order, did you call Justin to come to the house?
Would have been a matter of minutes.
A matter of minutes.
Yep.
So who did you go to the house with?
Officer Noonan.
Not a trick question, obviously. Noonan and Houston, right?
Yes.
Okay. So you have social workers on your staff, don't you?
We do.
No social worker.
No.
So with respect to the situation, you knew this was a 4-month-old child, right?
I did.
Yep.
DCF?
No.
Why not?
So you go to the,
Ask me.
I'll ask a more detailed question.
Right.
So
Flesh it
you
out.
didn't summon anyone from DCF to come and look at the situation or anything like that to, you didn't report to DCF about the situation?
Which situation?
You're taking a
Fact that
baby
you were
from the
going
mom.
to a police officer's house,
Uh-huh.
taking her 4-month-old baby and giving it to a guy.
The father?
Yeah.
No, I didn't call DCF. No.
All right. Aren't you a mandated reporter?
I am.
And you didn't report it?
Report what?
The fact that there was
I
a
don't get that.
dispute over the 4-year-old child and that there was a court order to take the child away?
That's not a mandatory
No, I
report.
didn't report it.
I don't understand what he's getting at. I get what he's trying to get at, but I
Now,
don't get that.
Restraining orders, you're experienced with restraining orders, right?
I am.
Restraining orders have provisions for retrieving property, don't they?
What do you mean by that?
Restraining orders have a provision that says, and the judge can check the box, the judge can write things in it, as they often scrawl things in, right? Paragraph 10 says, you may pick up your personal belongings in the company of police or at a time agreed to by the plaintiff. That's just by the plaintiff, it says that, right?
Yes.
And so there's a provision where the plaintiff can
Where's that one?
allow it by agreeing to it. And this is a situation that's a little bit different, isn't it?
Yes, Bradl. Yes, very different.
The plaintiff is leaving, right? And the defendant is staying at the house.
Yes.
So where's the
So-
box for that?
The judge took no action in that area, did they? About whether or not Justin Aylaian could go into that house.
No.
And so you took that upon yourself to let him in there?
She was informed that we were calling him to come get the baby. She did not object to it.
She didn't object to it.
No.
When was she informed?
When I served her the order, when she was sitting on the couch.
And you said what?
I
We're
don't
gonna
I
let
get.
Justin come over and rummage around your basement?
No, I didn't say that. What I told
did
her
you say?
was that Justin was granted custody of the child by the court or whatever. And that's what I said to her.
And while we're on that topic, she didn't say, I want to pack a bag. You and your colleague officers told her, pack a bag for the baby, correct?
No, we did not. She raised she basically said the baby doesn't have anything.
Well, you're the one planning this. Sorry.
did not hear that last.
She basically said the baby didn't have any of their stuff, is how, what precipitated her going around the house to gather items.
Thank you.
So you're the one planning this out. It's your testimony that you weren't thinking about her needing to pack some things for the baby to take with you or with Justin and Aylaian?
I don't understand the question.
You're saying that you didn't tell her to pack anything for the baby. That wasn't part of your plan, in other words?
No.
The fact is not Noonan, not Houston, you told Kelsey Fitzsimmons, pack a bag for 2 weeks for your baby, didn't you?
No.
And so it's your testimony that you had no plan, no thought process about getting things for the baby. Is that right?
I don't know that I didn't have a plan, but what precipitated her going around the house and grabbing items was her bringing it up to me.
So you're saying that was just sort of a spontaneous thing that she took upon herself?
Yeah.
Okay. So you get in there. Kelsey has the baby. She's doing regular mom things, right? She's coming home. She's got the baby in her hands. She's got sweat clothes on. She's walking around the house.
Yes.
No signs of upset or trauma to the baby until you get there and tell her what's going on, right?
Yes. Well, when I first told, she was calm when we first told her what was going on.
Sure. And then you told her what was going on.
When I told her what was going on, she was still calm. She called her mother on the phone, but she didn't become emotional at that point.
And the baby started to cry.
Yeah.
Because the baby was.
And at that point, you asked her to put the baby in a rocker. Is that right?
No, she put the baby in the rocker before she sat on the couch.
At some point, Kelsey picked the baby back up because the baby was crying.
Correct.
And she was in the middle of feeding the baby, right? When you got there.
Which I don't know that.
Which time are we talking about?
So
There was a bottle. I don't know what she was doing before I got there. Okay. There was a bottle with formula or whatever there. Yes.
and she
Bottle.
told you that she was feeding the baby and that she needed to keep feeding the baby, right?
Actually, yes. Yes.
Okay. And then she hands the baby to who?
Officer Noonan.
Okay. She handed the baby to Officer Noonan,
Correct.
right? And she gave the bottle to Officer Noonan, and Officer Noonan fed her baby, correct?
I believe so, yes.
So her state of mind towards Officer Noonan, 5 minutes before the shooting, or 10 minutes, or whatever it is that you're someone that can feed my baby. You're someone that can take my baby, right?
Somewhat argumentative, overruled.
She did that, right?
She did what?
What I just said.
Can you ask the question again?
She gave Noonan her baby.
Oh,
And
yes.
she gave him the bottle and he fed her. Right?
Yes.
And nobody forced her to do that. She made a decision to do that on her own, right?
Yes.
Now, you said that Kelsey had started in 2025. That's what I have in my notes. That's not
no,
right,
it was
is it?
before. I believe it was 24.
Okay, well, it's 23.
Okay.
Is it not?
I'm not positive of the date. It's been a few years.
All right. It's fair to say that you hired her, right?
I did.
You trained her for 6 months you were her DI for 6 months, right? Drill
Correct.
instructor?
Yes.
She was the treasurer of the police academy when she was there, right?
She was.
She came on the job and she worked under you on many shifts, right?
During field training and I believe briefly afterwards, yes.
All right. So she's an officer from 23 that you know well, and she's been there a while, right up until going out on maternity leave and then coming back, just about to come back June 30th, right?
Correct.
And as of June 30th, she was slated to go back on the schedule for July 4th, right?
To go back on patrol, yes.
Yes. So at some point in this incident, Mr. Aylaian asked you if you could go in the basement and get some things, right?
Yes,
And you let him do that unsupervised, correct?
correct.
Isn't it required that an officer accompany the person with the consent of the homeowner?
I'm not sure.
Now, at some point, Kelsey's mother comes in, correct?
Correct.
Where were you and where was Kelsey when that happened?
When Kelsey's mother came in, I believe we were in the living room.
And Kelsey was nowhere near that, correct?
Kelsey was nowhere near where?
Her mother.
I don't understand the question.
When Kelsey's mother arrived,
Yeah.
Kelsey was upstairs with Noonan and Houston, wasn't she?
No, when Kelsey's mother arrived, no, I believe at that point, Officer Houston had the baby.
Yeah, we just saw that.
Officer Houston had the baby.
And Officer Houston gave Kelsey's mother the baby, correct?
Correct.
And then Officer Houston went upstairs?
I'm not positive at that
So
point.
at some point, you're downstairs, Houston and Noonan are upstairs with Kelsey, correct?
Correct, yes.
All right. Where was mom at that time? The
She was
mother.
in the living room
With who?
with the baby
And where were you?
in the living room.
So you're with her.
Yes.
Okay. At some point, you hear 2 gunshots.
Yes.
And at that time, Houston is downstairs with you. He's joined you downstairs.
When the gunshots happened, he's downstairs. He did not join with me.
He's
He's around in like the kitchen right at the top of the staircase,
so he's
according to him.
Houston
didn't
is
see him.
downstairs and not upstairs with Noonan and Kelsey, correct?
Correct.
You hear 2 gunshots. Is it fair to say these gunshots were in quick succession?
Yes.
What did you do?
I was running up the stairs when the shots were fired.
Did you see the shots?
No, I heard 2 loud bangs as I was running up the stairs.
Where was Noonan, if you know?
Noonan was right outside of the frame of the bedroom door, in like the, if you want to call it a hallway, the upstairs hallway.
Like
in
maybe
between-
like a landing, like the top
Sure.
landing of the
in
steps?
between both bedrooms.
All right, so Noonan is at the door frame, correct?
Yes,
And it's fair to say there's no door to the bedroom, right?
correct.
When you get up the stairs and look into the room, what's the first thing you see?
Her feet
Where were they?
over on the other, the far end of the bedroom by the bed.
Kelsey's feet.
Correct.
And she was on her back.
Yes,
She had a gunshot wound to the lower chest.
yes.
And at some point, you went over there to render first aid, right?
Yeah, it was pretty much immediately.
And Noonan is covering the scene with his firearm, correct?
Correct.
Now, when you went up to Kelsey, what was the first thing you did? Was it in terms of first aid or in terms of securing the firearm?
Secure the firearm.
And where was the firearm?
The firearm was by her left leg.
All right. Isn't it true that when you were interviewed by the CIC representatives, you said that the weapon was under her leg?
I didn't hear that. Under what?
Yes, you said it was under her leg when you were
Yeah, it was
interviewed.
by her left leg. Like
Well, under is different than by.
when I was able to see the firearm when I got up to her. I could
There's no
not see
question
it.
before you, sir. I'll ask you a question.
What?
So today you're saying that it was by her leg, correct?
Yes,
And we agree that when you were interviewed by the CIC months and months ago, you said that the firearm was under her leg, correct?
I'd have to look at the exact statement, but
Sure. May I approach her?
Right. This is the very CIC. So this is a portion of this witness's statements in the CIC 80-page report. But what Bradl said he doesn't have is the actual statement, either the recording or the transcript of it or anything from it. He only has the portions that they put in there. Oh, is that a big goal, Spitfire? I don't know. I just created one. We can do it. I've got full faith in us.
Approach, can you just make a record of what it is that you're showing him?
Sure, Judge. For the record, I'm
Hey, look at that. First one.
CIC report that was commissioned by the North Neighborhood PD.
Okay, you want him to look at it?
Yes, please.
Thank you.
Lieutenant Daley, do me a favor, look. You can look anywhere you want on the page, but I want to invite your attention to right here. You can look up and down. Just take a look and familiarize yourself when you're comfortable.
Thanks, Ashen.
Okay.
Get
I'm gonna
us
read something,
started.
And I'm going to ask you if I read it correctly. So she's laying on her back, head towards the window, feet closest to us, and the firearm was underneath her left leg. Did I read that correctly?
you did.
And that was your testimony, right?
Yes.
Thank you.
Thanks, Tony. Good morning, fam. Been here a long time. Been a long time since I've been here with y'all. Well, welcome. Glad to be here with you. Justice for Kelsey. Yes, thank you. I didn't realize I'm hitting like an unrealistic goal here. We can do it.
Why did you roll her over?
To see if there was an exit wound.
And did you tend to that?
Yes,
And at some point, Kelsey said, "I'm sorry, I want to die," correct?
correct.
And when was that?
During that time.
All right, that clears up the 1-2
Was
didn't want
Noonan
to.
anywhere near her?
Yeah,
What was he doing?
I don't know. I mean, he was right by me, but I was wrapping gauze around her, trying to at that point. He was there. He might have been grabbing stuff, more additional things out of the medical bag.
Thanks, Lindsay.
At that point, Kelsey looked at him and said, "Why?" Didn't she?
Not that I recall.
Did Noonan say anything to her?
I think, yeah, and so did I. He basically said, like, calm down and keep breathing.
Is that it?
That I can recall, yes.
And what about you? What did you say?
No objection. So
Same thing.
Amber, thank you. Super $10 super.
Now, you were asked if you had your gun checked as a result of this incident. What? I don't mean to put you on the spot. And you can go find it. But do you know your gun serial number?
No, I don't.
Thanks, Mary. Love watching the trial with you guys.
What were the circumstances of you getting your gun checked?
You mean why they did it?
No,
What do you mean?
what happened? Just physically, did you give it to someone or what?
Yeah, one of the Mass State troopers from ballistics took it and emptied, I believe, counted all the rounds in the firearm, etc. It may have done something else. I don't know.
You don't know?
No,
Do you know who it was that took it?
I don't.
You gave your gun to somebody and you don't know who you gave it to?
Correct.
Thanks, Julia
Who
Miller.
else had their gun checked?
I believe all three guns ended up getting checked. Maybe not there,
I don't want you to speculate. So
but so I wasn't present when anyone else had the gun checked.
I appreciate you trying to help. My question is, what's your personal knowledge of who got their gun checked? Let me ask it a better way.
At that time,
What did you see? Who
Oh.
got their gun checked?
I didn't.
Okay, so
What?
you don't have any personal knowledge of anyone else getting their gun checked?
At that time, no.
Okay. Did you witness someone else giving up their gun and getting their gun checked at another time period?
No.
So the whole state of your knowledge about guns being checked is that your gun was given to someone, you don't know who it was, but they took out the bullets and the cartridges and inventoried it. Is that it?
Well, I didn't give it. I gave it to a Mass State trooper from the ballistics team. I believe there were three of them over by the truck. I don't know which one I handed it to. I didn't ask him his name. But yeah, that's what happened.
Did they do the things you said in front of you about inventorying the cartridges and all that?
I saw him unload and make the gun safe and empty the magazine. And at that point, I walked away.
Did you sign a receipt or anything, or a chain of custody or anything at all?
No, because I got the firearm back once they did whatever they did.
And when did you get the firearm back?
Same day.
At some point after that same evening.
That same evening?
Correct.
Julia says, for the goal. Thank you, Julia.
And sorry if I asked you this. You don't have any personal knowledge of the circumstances of anybody else's guns being given up and checked?
No.
I never witnessed any of the other people's guns getting checked. I know that Tim Houston had already left, and they were trying to he had already left the scene at that point. So they were trying to make
Contact.
you know, logistically plan out someone going over to pick up the gun from his firearm.
Okay.
So I knew that it got checked. I just don't know exactly when.
You assume it got checked based on the circumstances. How about that? You
Fair
can
enough.
do that?
Amanda's live mom. Thank you. She says, let's hit 50 people. I'll leave out the LOL because it ain't no joke.
Now, you spoke with Justin Aylaian at the lobby of the police station before you went to the scene, right?
Yes.
We talked about that. Now, up until that conversation, did you have any information any further information from Justin Aylaian about the circumstances of Kelsey's state of mind that day, or anything that was going on with Kelsey that day?
Prior to seeing him in the lobby?
When you were speaking with Justin Aylaian in the lobby,
Yeah.
had you already had any information about Kelsey's whereabouts or actions that day?
From Justin?
From
Anyone.
Oh, yes.
Okay. Were you aware that she was waiting for him at the park in town?
No, I wasn't aware that till Kelsey told me that when we went to the house.
Isn't it true that at the police station, Justin Aylaian said to you, I wouldn't be surprised if she shot the baby right in front of you, right?
Yes.
Oh my
And
God.
that added to your mindset
What a
about
sicko.
going to see Kelsey, didn't it?
Yes.
I don't know. I don't
That
understand.
was
the
part of the
question.
quantum of
Information.
evidence or thoughts or presumptions that you had in your head, right?
I think it raised my awareness.
And that was communicated to Noonan, wasn't it?
Both Noonan and Houston, yes.
All right.
And so that
Yep.
statement from Justin Aylaian, it's fair to say, contributes to an increased level of vigilance towards Kelsey when you got there, right?
Yes. You have to say yes.
No.
Oh,
would think-
bullshit.
It's your testimony that that's not a factor in your mind?
No,
Is
it's
that
a
correct?
fact. It's a factor in my mind, but I think from a tactical perspective, I think everyone was actually, yes.
There you go.
Did you-
Everybody was probably more on point than normal.
Did you consider Justin Aylaian's motive for saying such a thing, or credibility or lack of credibility of him saying such a thing?
No, that's fair game.
Just yes or no?
Did I consider, I'm sorry, can you?
Did
ask
you
me?
consider the source? How about that?
No.
Hmm.
He was a plaintiff in a domestic situation seeking to get custody of his baby and her baby through an ex parte restraining order, right? He was adverse to Kelsey Fitzsimmons, wasn't he?
Yes.
I'll strike it.
Did you have a conversation with your fellow officers about the credibility of such an assertion about your own officer that you hired,
Trained and worked
had on
with.
the job?
So you're referring to Ms. Fitzsimmons.
Yes.
Overruled.
Right. There you go. I was like, what is the problem here?
I'm sorry, can you?
Yeah, did you think about what he's saying? How did that affect your state of mind?
Wait,
Kelsey.
go back.
I don't know that, I didn't take everything that you said as 100% factual. However, there was a court order in place where we had to go serve the documentation. Regardless, I don't know.
You
That
asked a
was
better
my
question a
statement.
second ago.
Did you consult with Justin at all relative to this restraining order before you met him in the lobby?
No.
Well, you talked to him on the phone, right?
Before I met him in the lobby, no.
Oh, you didn't? Okay.
I talked to him on the phone when I called him to come to the house. That's the only time I've ever spoken to him on the phone.
Hey, one moment, please, Your Honor.
Sharon Log, member for 1 month. Love you guys. Thank you, Sharon. Ain't so plain Jane. Thank you. GA Cat Mom gifted a membership. Well, thank you. And I think that puts you on the wheel as well. Y'all are on the wheel. Tracy, is that right? Gifting membership gets you on the wheel? Are you helping me with this wheel, Trace? 'Cause I don't know how to do it. But I'm sure I could figure it out. But maybe we can work together. Casually Kiki. Thank you. You're on the wheel.
After the shooting and a crime scene's established, it's fair to say that you had some other officers come to the scene, correct?
Yes.
And some of those officers were trained mental health officers, correct?
No.
Everybody's a trained mental health officer in some capacity.
Well, there's Officer Seaway,
Yes.
and he has some special training with mental health
Yes.
issues, correct? And
Seaway?
Seawade, SEWADE.
He was there?
And he came to the scene after the fact, right?
Oh.
Yes.
He didn't come for Kelsey. He came for Noonan, right?
Yes.
Nothing further.
Wow.
When you provide when you're serving a restraining order, you serve the order itself, correct?
Yes.
You don't serve an affidavit.
Never.
It's just the court order is being given to the defendant in that order. So they're on notice as to what the judge has decided, correct?
That's correct.
Now, you talked about your gun being checked. How many rounds do you typically carry in your gun?
17 in the magazine and 1 on the chamber. So 18 total rounds.
Thank you.
Any recross?
Just one or two questions, Your Honor. So counsel asked you, you don't serve the restraining order. I'm sorry, affidavit. You don't serve the affidavit, right?
Correct. I never have.
So is there some rule that says you can't?
Not that I'm aware of.
So you had the affidavit in this particular circumstance, right?
Yes.
And you didn't give it to him,
That's correct.
and you could have.
I don't know. My understanding, we've never, I think as a general rule or practice within our PD, I'm not familiar with anyone ever serving a restraining order, including the affidavit.
That's my
When
experience
someone
as
walks
well.
into the police station with the order and the affidavit and shows it to you and uses it, it's not a big deal to make a copy and hand it to the defendant.
Get this line of
Well,
questioning.
the document I served was a document I printed that was sent to me directly from the court, not what he gave me. I just made a copy of that and remained in the OIC office.
It's fair to say that in the circumstances where you don't give an affidavit, it's when you've gotten something from the court via the system, the OIC email, and they don't give you the affidavit. So you just serve what you get, right?
Right, which is what I served.
Right. And this situation is different because you had the affidavit.
But
in
not
hand
through the system,
right
Bradl.
there, and you could have brought it. Couldn't. And you know of no rule that says you shouldn't.
Not that I'm aware of.
All set?
I don't know how effective that
You're not
part
getting
of it was.
involved in the matter.
Hold on,
The court
hold on.
decides,
Are we going on to redirect?
Right? Thank you. No.
A couple questions.
You're not getting involved in the matter that the court decided, like a probate matter, correct?
Correct.
You're simply going and serving the restraining order for what the judge found, right?
That's correct.
Do you have any
No, you're.
Okay, no, I just want to point out, do you guys all remember, well, anyone who watched the Karen Reed trial with us knows how fucking insane I was about, and I can't remember if it was only Brennan or if it was also Lally. I feel like it was Brennan, but I can't say for sure. Just kept doing the redirect. And I'm like, your fucking time is done. It's like that's it. And then like every single time, and the judge didn't even ask, like, do you want to get like, and then didn't give the defendant that last minute. See exactly what happened here. The judge is like, whoa, how do we get back to your turn? You're going on to a redirect. And then, as he should, at the end, he says, and do you want to recross? And he says no. And that's it. We're over. But I mean, it was running rampant in Karen Reed's trial.
Let me just see if I have.
Oh, this is telling with the judge's questions. All right. This is very telling.
I do not. Okay,
Oh,
you may step
does
down.
not. Damn it.
And I'm wondering, why don't we, should we break at this point for a lunch break and then we can come back at 10:02?
10:02.
Okay, we'll stand at recess.
Oh, I forgot to update the banner, y'all. Was that still Sean Daley the whole time? Oh, it was. Okay. So until what I just said? 10:02. Let's see. Lunch break until 1:50 Eastern time. Okay. So before we go to lunch, we'll have to figure out what we're gonna do because I kind of want to get something to eat, but let's keep going through your guys' stickers. Where was I though? Okay, so Chicago Zen, thank you. Said it's towards Allie's goal. And Lana C says, love you guys. Thank you, Lana. Oh, look at that. New member, Lindsay Clark. Welcome. Family hug. Welcome to the fam. Welcome to the fam. We can do it. Tommy. Akasha. Thank you, Akasha. Sharon's back. Love you guys for the goal. Got a super sticker from Christy. I think it's got to be 5 for the goal, but hey, you know what? Tracy, are you helping me with this? I forget. Because I'm saying Christy's on the wheel. Lily B, thank you, towards the goal. All right, Tracy says, I will get the names for the wheel. I'm picking up the dog at the vet and then something else. Oh, and Judge Carroll is still here. I don't know. Are you going to join us, Judge Carroll? Bob teased me with getting your expertise on with me today at some point. Is that going to happen? And then we got Hootis, who says, let's go Allie to 50 for bragging rights over Bob. I'm so glad that I don't know. I thought Bob always said I made the goal the highest. Hey, we can do this. We got this shit. Thank you, Hootis. Thank you. And for Charm Free likes the bloop bloop. I love the bloop bloop. Thanks, Charm Free. And for those of you who haven't been with us before and were startled by me calling Justin a Limpy, I've just explained my position on the issue. People like to use the P word to explain someone who's like a pathetic little baby scaredy cat. But, women's organs are strong and powerful and make babies. What is more pathetic, worthless, can do nothing for you than a limp dick? Nothing. So we're changing the vernacular over here, and he's a big, giant limpy. And that's the first responder just running and tripping over himself to get out. Megan, not the stallion, says free Kelsey to 50. Yes, thank you. To 50. Sorry. Bob would have been like, come on, Allie. Donnie, not Wahlberg, says thank you for covering this. Free Kelsey Fitzsimmons. And thank you. Okie Angle says all about the goals. Thanks, Allie, for the stream. Thank you guys. You guys have been amazing. Yeah, I'm getting bragging rights over Bob. Faux show. Absolutely. All right. Oh, we got Tiff Knox, and you're on the wheel. Thank you. And Dottie, thank you. You're on the wheel. All right, I'm trying to think if I had some other things I was thinking about. About like his testimony or you guys, when we get judges' questions, that's just like, that's like your little window right then and there, into everything. I can't wait till that happens. Sorry, but I was reading Brittany's comment here, and with all the drug use, he is probably a Limpy for real. I mean, it's hard when you're doing them drugs. I mean, we've really only heard about pot. I don't know if that's affecting the goods. But all that drinking, all that alcoholism, that'll do it. That'll do it. Trial lover, thank you to help you beat Bob. Thanks for all you do. Yes. Yes. So the goal is, and I just want to comment, DB is still allowed to come on, as is come on, Allison. Come on. The username is right there in my head. Somebody remind me who initially donated it to DB because she wasn't available. But you're both on. You can come on this trial as well, and then we'll spin the wheel. Yellow Jackets. Was that it? Was it Yellow Jackets? It was Yellow Jackets. Okay. Thanks, Brianne. So yeah, Yellow Jackets. You guys are still absolutely all right. Let's rewatch the Justin tripping over himself. Or we watched Limpy time. Let's just see. Here we go. We're gonna start here from when the baby's bouncing. So that's Houston. Houston, we have a problem. And he's sweet. He's bouncing the baby. That's nice. Grandma takes the baby. And then I heard that noise there, and it's from the courtroom. And I was thinking that I was hearing a noise from the recording. And I was like, oh, you can hear stuff. Because then I'll hear I heard something rattle. And I was like, oh, that's the keys. But it's not. All right, so it's 5:04 and 20 seconds. And here comes the alien invasion. Whoever said that, it was great. I can't remember. Justin, and I mean, if that's his stepmother, I need whatever routine she's got because she looks like she's 12. Oh, and she's got the baby. Little sweet baby. Justin's already coming out. He's getting all the stuff, all the goods, all the stuff. It's 4:06. I mean, 5:06. I know what I'm saying. 5:06. 5:07. Justin's coming back. And I think you guys told me it was 5:08 by the time he's ducking into that back room. I need to get into the basement and root around. Is that okay? All right, thanks. All right, so 5:07, 45 seconds. He's coming into the basement. He's got a flashlight. He came prepared, this guy. It's like, oh no, that's his phone, probably. Okay, take it back. All right, 5:08. We hit the 5:08 minute mark. He's got himself suitcase. He goes back and grabs something else. I'm not exactly sure. It looked like an article of clothing or something. 50818. $508.32, and he's getting ready to head up. He's walking up. Here's the shots. 508.38. Ducks into a room. Now this one, it's okay. I think you're thinking, oh my God, she's coming to unalive me. So you're hiding, right? And then I thought it was strange when the light came on. I was like, wait a minute, isn't he supposed to be hiding back there? But all right, now he's not hiding anymore. He just puts the light on. That was 508.55. Now we had this guy testify that within oh boy. Hold up. Oh boy. That's our favorite part. You're gonna watch it one more time. And here comes Limpy. Oh boy. Right over his feet, right over his legs. Oh, another angle of it. Or was it twice? I don't know. There. Oh. She's like, where in the hell is this guy running? She's like, what is he doing? I don't know what mom's thinking at that time. Like, maybe she's calling, like, come help. What are you doing? Come help. Oh, I feel like the mom, I can't. Honestly, I can't. Okay, so then this guy, maybe he's going to flag down EMS. You know, I'm not exactly sure why he's running out. Maybe he's going to tell Justin, come and help us. You're a fucking first responder. I know when my son was doing the whole fireman thing, he first went to paramedic school and became a full-fledged paramedic. And it's my understanding that they're all supposed to be paramedics. So I don't know. But I know a lot of what my son does is go to places and help people that are injured. All right. So this guy's coming back. Oh, he was getting his like pack out of the car. Some kind of pack. 5:10. So 2 minutes have passed. Or maybe this one, which guy is this? Oh, this is their mental health guy, maybe. Because this is a new guy on the scene. So, and he talks to mom. Let me mute myself. All right, paramedics, 5:13. 5 minutes is up, Detective or Lieutenant Daley. Your 5 minutes is up, and they haven't even entered the house. So what are we talking about that 5 minutes? I would have pointed that out, Bradl, just to show that he's not real concerned about being honest, having shit right. It's 5:18. They're just leaving. They're just leaving. And this is just another angle of them leaving again. But, Bradl makes a great point. You have your, mental health officer come after there's been an officer-involved shooting, whichever way you want to put it. But you think you have an officer in the midst of a mental health crisis who you're about to go take her kid away, and you don't think to bring him then? Now, look, at the end of the day, it doesn't change what happened in that room. And that's the kind of argument that would have had a little bit more effect on a juror. The judge, that means those are like words he's not even hearing for this.
That's it. Is that the conclusion? Okay. And
but for our
So
purposes of just like what the hell happened that day, yeah, it's fucking relevant. It's relevant. Like, why in the hell did it happen like that? You guys could have done something, Oh, let me see. We got some more supers. I don't remember if we did Okie Angel, but if we didn't, we're doing it again. All About Goals. Thanks, Allie, for the stream. Thank you. Tiff. Oh, yeah, we did. Tiff Knox. Thanks. Dottie. Thanks. And we got Trial Level Lovers. Thanks. All right. So Lindsay says, Allie, only pot? What about Adderall, mushrooms, acid, lorazepam, etc.? It wasn't just pot. Okay. Yeah, no. Fair. True. There was a lot of other things. I forgot about all that stuff. And let's not forget the alcoholism. I mean, that is like, I'm not going to say worse than, well, it's probably not worse than mushrooms. It could be worse than acid, and Adderall depends how badly he's abusing it, because lack of sleep with firemen and then combining that without Adderall and then combining that with alcoholism is huge. And lorazepam, I don't know how often he's taking that, but I can't imagine that's a good thing to mix with the Adderall and the alcoholism and the lack of sleep or the weird sleep. But yes, your point is well taken. You got Adderall, mushrooms, acid, lorazepam, and alcohol. And cooking wine. Miss Rattle, thank you for your generosity. Violet says, justice for Kelsey. Ginger says, Limpy. Gold, Allie. Yes. All right. So Colorado Mama says, Allie, what would you have asked on when the judge asked Bradl if he was sure he had no questions? I mean, at that point, there was nothing more to ask. The prosecution's points weren't even well taken. I just, like the not serving the affidavit, to me, it was a non-issue. And would have been even a non-issue, maybe could have gotten some points with a jury, but I don't know why. But with a judge, it's a non-issue. And I can tell you for sure, I have never, ever seen anyone get served with the affidavit when they get served a restraining order. I mean, I've had issues where I can't even get my hands on the affidavit because sometimes, certain types here in Illinois of like no stalking orders, they're under seal. So even when I am logged in as the lawyer, I can't access it. And then I've got to, go to court in the first appearance and say, Your Honor, well, we don't even have the affidavit yet, so I can't do anything. But like the points about the things they could have done different is kind of probably something he could have adjusted this in his trial strategy, since we're dealing with a bench trial. And I can tell you that none of what they coulda, shoulda, and would have done is going to change anything for this judge, because all he gives a shit is what happened in that room. And then all the facts leading up to what happened in that room to lay the credibility for who's telling the truth. Everything that happened that day in there is definitely of import, because the defense is trying to show she was like trying to get rid of the cops so that she could hurt herself before they left and took all of her guns. And Tony says, for the goal, thank you. And again, Tony, for the goal. And Psychosaurus Rex says, got my But I Digress DD t-shirt over the weekend. Yay. Great quality printing. We'll be wearing it to Pilates tonight. Wow, nice. Thank you, Psychosaurus Rex. I don't know, guys. We need to maybe get something to eat during this lunch. Blessed Texas Lolly says, let's get that goal. Yes, people, let's do it. Let's do it. I'm really, really going to be keeping an eye, like what obviously we all need to pay attention to here is those judges' questions. Again, more than the objections, how he rules on them, what he lets in, is going to be those questions. And judges can do the same thing. Sometimes judges going to ask a question that helps strengthen where he's already leaning. So, I mean, depending on the question, it might be hard to judge as well. But just know, and I kind of said this before, although I don't think as of yet this judge has made up his mind. I honestly don't. But 99% of the lawyers you ask, if a judge is ruling overly on your side in something, it can when it's a judge based on a judge decision, not like a bench trial or whatever, it could be because he's about to rule against you. I'm going to let everything in. I'm going to err on the side of let all this shit in because I'm about to rule against them. I'm not suggesting that's what happened with that first ruling. And again, like I said at the time, I did think that the judge's rationale for that really showed the way his legal mind works and that he was the right judge to get on this, with my asterisk of if a bench trial was the right way to go at all. And there's really no way to know until the end. This is just one of those cases that it's really, really hard to decide. And Bradl's in the best position to decide it. I'm sitting here on the sidelines, not knowing the judges and just assuming that the whole community feels the corruption issues that are just running rampant and just in the forefront of everyone's mind there. But that's because I'm kind of stuck in this little bubble. I have to remind myself there's a whole ton of people in Massachusetts who don't know a thing about any of the stuff that's been going on. They're still your normal jurors who are inclined to believe police. And although we have 2 police here, you worry about what I'm sure Bradl was worried about, that they think, well, only one of them was having a mental health crisis, and that's the one I'm not going to believe. And he has to hope that a judge will still say, even with that discrepancy, I cannot say to a moral certainty beyond a reasonable doubt that everything Noonan said is 100% fact to me. There is motivation to lie, and I have to balance that potential motivation to lie in my reasonable certainty. And despite how maybe certain I might be, this case is the epitome of reasonable doubt. And that is the hope. That is the hope that Bradl went into their decision. And again, as much as I think the whole community in Massachusetts is on high alert that their government is corrupt, that their cops and their prosecutors, there's been corruption, there are so many people that don't pay attention to true crime, that know nothing about it, and don't think that way. And when you're talking about any other, normal, typical jury whose community hasn't been just slammed with corruption issues, and it in their face about potentially lying police or lying police and snaky prosecutors and false evidence, like that they're going to bite you in the ass every time. So in any other community, I would be saying, oh yeah, you got to go a bench trial because a jury is just going to screw you. And I've kind of been thinking, wow, but the Massachusetts people, this is a thing for them. But got to remind myself, there's probably way more of the community that doesn't know any of that than does. And it's hard when you're living in a bubble and, thinking everybody out there knows this stuff. Thanks, blessed Texas Lolly. Get that goal. You're on the wheel. And Christine, you're on the wheel. Thank you. Bluebell, thank you. You're on the wheel. I think it was a mistake to have a bench trial. Bluebell, we're not going to know to the end, but it's a very strong possibility. It's a risk. We just have to hope that the judge will ignore the effects of his ruling as far as among other judges, among the cops, among whomever, and say, that it's reasonable doubt. All the things that I just said, because I think this comment came in shortly before I went on that little rant, but I have to trust that Bradl is in the best position to make this decision, right or wrong. He weighed it and he made it, and it was right at the time that he did it. If it pans out, that's a whole different question. But in any other jurisdiction, I would say you gotta go bench because, you know, jurors always, it's already an uphill battle with a jury, trying to get a jury to understand that what the prosecution says is not gold. You know, it's not everything. They don't decide what's right and wrong and present you with the right thing all of the time. Did I do the wrong time? Yeah, 1:50 Eastern time. That is correct, right? That's what I put down there in the banner. Let me turn it off scrolling so that it's more obvious. My husband just texted me, Did we do the wheel? I'm behind on the thing." Well, I guess he'll just have to see how amazing our wheel goal is going. So, haha. And then Whammy Burgers for All says, "Towards the goal on behalf of all the poor bastard zoo animals." I mean, it's legit. Poor trapped bison. The bison just sitting there. You know, get your tigers and your lions just sitting there sad as they. The polar bear looks like it's having so much fun. That was the sweetest, but the damn thing, no, not having fun. Having, like, relative to what's happening with the tiger and the lion, maybe, because at least he's getting to swim around in the water, but he's still just circling. I mean, if it wasn't for the people's faces, I think the poor thing would just, I don't know what. It's, yeah, sad, poor bastard zoo animals. But the kids love it. The little ones, they got to have it. It's so sweet. Got to hold back your just total disgust for the whole thing and enjoy their joy, as I did this weekend. Nanny Doo, thank you. I believe his sister and mama are the driving force behind his motives. I mean, I think they definitely egged him on, but this guy just seems like a real piece of work on his own, you know? I mean, you just go look, like, I hope that meme is just out there, everybody, with the tripping over his feet, like, just out there, just slammed on social media over and over. Just clip that little thing of him. What you doing, doggy? Yeah, my dog's been so good. All right. I'm going to leave it like this live streaming blue thing and go what I do with my banner. What? There we go. And go, I guess, get some more cheese. I don't know. We've got 30 minutes. So I'll be back. Y'all behave. Gina says we need a Limpy emoji. All right, but we can't use one that's like gonna get us banned from YouTube. Think about it. Is it like a thick, wet, noodly thing? What could it be? A soggy cucumber. I don't know. Yes, there's bison in our zoo. There is bison in our zoo. Is that like there's not a lot of the virtual juror says you cannot live on dairy alone. I mean, I think I can somehow. But I'm sure it's going to come back and bite me in the ass. I don't drink any milk, so that gives me room for the cheese. And it's a lot of mozzarella cheese. So usually fresh. I had the stick down here earlier because it's easy to eat. But I probably give my dog too much cheese too because he shares cheese with me a lot. He loves mozzarella cheese. He loves all kind of cheese. All right, you guys are all promising to behave. Cigarette says, all righty, let's talk politics. Right. Rule numero uno, no politics talk. Wait, this is a joke, right? Indy Cindy, there are bison in my yard. Do you have bison? They're probably a lot happier than those ones in the zoo. Like, they got some room to roam. What? In Arkansas, you guys have bison? Just roaming? Like back in the days of the indigenous people and the bison getting to just roam our countryside? I mean, they sell bison meat in the market, for God's sakes. It's kind of crazy. Um, all right, good. Nanny Doo gives me hope. She lives off cheese, is 60 and still. I mean, 60 is not old enough to say and still alive. Sorry, you can tell me that at like 80. I'd be like, I live off cheese. I'm 80 and I'm still alive. 60, that's the new 40. As I'm getting older, 60 is the new 40. So, all right. I mean, I'm going to get something to eat. I'm going to go play with my dog so he gives me a break when I come back. See you guys in a bit. I don't even want to admit what I made for lunch. But before we get to that, I did rewatch the video again, like the house video of Justin tripping. And now I realize that he, like, when it got really bright in that room, was him opening some sort of exit to from the basement. Which I guess I just didn't understand. I don't know why. That obviously shouldn't have been clear. So yeah, he he exits out the back, and that's when he's tripping over himself. But you know, he there was enough time at whatever point to realize there's not a risk anymore, and I'm trained to save people's lives, so I should go back. So him like going out the garage door or whatever the hell it was. But Lindsay says that's what I said. He opened the bulkhead door to get out. Yeah. Yeah. See, I forget that they have those on the East Coast because it didn't look like the kind of basement that would have a walkout like we're used to out here. But yeah. But then he's seeing within like a second, he should have been back then to be like, oh wait, how can I help? How can I help? All right, I'm just gonna tell you guys. And nobody's allowed to laugh. But I was like, yeah, I'm not gonna have just some fresh mozzarella cheese for lunch here. But I knew we had no sauce. So a lot of like Bob and I have been for way too long, and it doesn't work for women for too long. So don't take this as a suggestion, but been doing like a carb-free, type of thing. And so like meatballs is where it's at. And that does have some breadcrumbs in it. So it's like, all right, that's like my cheat. But at least, it's mostly meat. But we had no sauce. So I'm like, what the hell am I going to do? So I found a jar of Campbell's tomato soup. And I opened that up and I like put in some adobe seasoning. And then I like just dumped a whole ton of minced onion, like just showered it in Italian seasoning. And then cooked the meatballs in that. But then when I took it out, like the meatballs just came like out of it. But it's, yeah. And then like we also haven't had a microwave in like, I don't think our younger kids ever saw a microwave. So we're talking like 19, 20 years at least without a microwave. But Bob Sr.'s here. Like, all right, we need to get a microwave. We're like, it's poison. It's cancer. Who needs a microwave? You can, kids almost never eat leftovers anyway. Popcorn was an issue. We had to get a popcorn maker and heating up like coffee, which I just would pour in a pot. So in any event, I'm like, well, I don't have a lot of time here to like do this on the stove. I'm going to put it in the microwave. So then I had to put the soup and the meatballs. I don't know. It was a thing. It was a thing. So now Nanook, and there's probably a whole bunch of you out there like, I can't believe you share this much food with your dog, but my dog is close by because he knows I got some meat, and usually like I'll take a bite, then I'll give him like a little piece. So he likes his tomato soup meatballs. Oh, and a little olive oil, Oh, and a ton of red pepper. The red pepper was probably even more red pepper than there was the Italian seasoning and the onion. It's like, gotta have the red pepper to give it that arrabbiata taste. But we do that too. Ditch. When I make the meatballs, these are not, I didn't make them. They're the Costco meatballs, which are pretty delicious. But when I make them, and I make Bob's grandmother's Italian meatball recipe, we used crushed pork rinds as well instead of breadcrumbs. So it's not quite as good. Like when I make them for like family functions, people are like, these are good, but something's different, but yeah, we do the same thing. It's a great substitute for breadcrumbs, for sure. Thanks, Ditch Pickle Huntress. Um, I'm trying to see where we were on the and, I guess I should apologize. I should have probably just said limp D instead of saying it outright. I know I got a lot of people here. My language probably scares them, but, uh, I is who I is. I am's what I am's. I'm not sure if we said this, but yeah, Georgia Cat Mom, if I didn't already, says, "Show Bob how it's done, Allie. Get that goal." Yes. Wow, Pammy MC. Pammy MC OG, member for 26 months. Dang. We need a 2-year loyalty badge. Yes. Is that like a thing? How do we get that? I want that, and I want y'all to have that. I need to learn the things and know the stuff. You don't even have all right, people. We have the one, the only Judge Carol Erskine. Wait, did I say that right?
You said it right. Thanks.
Okay.
Thanks for having me.
Thanks for joining us.
Oh, I've been listening to you. Of course, I was on my way back from New Hampshire. I wasn't driving, of course, but I was listening. So, I thought you did a great job with the analysis of some really tricky issues. Like hearsay is very tricky to people anyway, but it gets trickier when you're talking about state of mind, which you explained well, or spontaneous utterance. So yeah, those are tricky things, but some surprises during this, right?
Yeah. Tell us what surprises you saw.
Well, first of all, I didn't understand. I mean, they called it a Rule 17 thing on custody and control. It's actually a Rule 14 thing,
Okay.
where the prosecution has to turn over everything in its custody and control. But under the rule, it means if the police have it too. So
That's what I thought. And I was like, because the judge even said under our law. So I'm like, all right. I thought I was familiar with the US Constitution, but yeah, tell us more about that, because he seemed to make it seem like because it's not in the custody control of the prosecutor, even though he recognizes it's in the control of the police, that he was saying that's a no.
Yeah, I'd have to go back and look at case law, but in cases where, people were asking me for information from the police, like on a rape case or something, and the police had it, or there was an evaluation, it was always my understanding, unless Rule 14 has changed, that if it's in the custody and control of the prosecutor, then it's in the custody and control of the police, who are effectively part of the prosecution team in a sense. That comes in. The thing I didn't understand is why so late, because the judge is basically telling him, well, you can subpoena it, or summons, the report from the police, and yeah, they can do that. But the first thing the police will do, and the judge alluded to this, is they're going to file a motion to quash, and then the judge is going to have to follow. So why are we doing this in the middle of a trial? I really just didn't understand that at all. On
that one, if this had happened in your courtroom and the defense was like, they need to turn it over and we don't have it. Now I know it's like, why did you wait so long? But would you have said, all right, we're going to move forward. In the meantime, I want the prosecutor to tell the police they have to request it and turn it over as quickly as possible? Or what would you have done?
Yeah, it might be that, you don't want to delay the trial and it comes late. And so that's the problem. But to me, the balance always falls in favor of the defendant, because she's the only person in that room with a Sixth Amendment right to a fair trial. And I think, her lawyer was, trying to make that argument. Hey, look, she's the one on trial. She's the one facing a loss of liberty. She's the one facing a felony conviction. So on balance, are you going to say, no, it was in custody of control of the police? Because I think that's the way the judge was thinking. But on the other hand, he was sort of giving them an out. He's like, hey, why don't you, issue a subpoena to the police to turn it over. And once they turn it over, you'll have it. And then you would have to wait and see whether the police were going to file a motion to quash. And then the judge is going to have to decide that. I mean, I think all things considered, even if the judge's interpretation of Rule 14, that if it's in custody and control of the police, but the prosecutors are dealing with the police. I mean, you heard the last witness testify. Did you meet with the police? Yes, I met with the police. They're working with the police. I mean, to me, that's custody and control. You know, I think case law, you know, when I was on the bench, I always supported that. I've only been off the bench for 3 years, but you know, I mean, he's a Superior Court judge. He seems, you know, pretty bright on the law, and that might be his view, and he's entitled to, I guess, that view and to make the decision. But on balance, for me, you know, it's always about the defendant and the Sixth Amendment rights, you know, which is what I frequently wrote and only wrote about during the Karen Reed trial. Right. Was this a violation of our Sixth Amendment rights? So that was one thing. I think one of the things that, and the testimony is not over, but I think one of the things that's really concerning to me is this whole notion that Justin was allowed to be at that home. I mean, one thing they have established, you know, for the future, you know, if they were going to charge him with breaking and entering, I mean, the police officer on the stand, right? Didn't he just establish that he wasn't living there? Yep. So no matter, you know, so if there were charges later on for the break and enter into that home, you actually have the police now saying he didn't live there. That wasn't his home, even though I think he tried to make it seem that way. And so that's a separate issue. What is surprising to me is that you have the North Andover Police Department. They know that this is sort of an escalated situation. They know they actually have an order, right? Taking the baby away. And, you know, just like most police departments, the North Andover Police Department has a community service social worker who can step in. So why aren't they using the social worker? Instead, they're telling him to go to the house in a case where he's the one telling them how escalated the situation is and that she might harm the baby. And he's telling the police, she might harm you. You know, I'll talk about that, you know, when we have a chance, and because, you know, the police are entering this, you know, with very heightened concerns, and that stuff never turns out right. You know, then you're really talking about the potential for lethality, and that almost happened here. She was almost killed. But you know, you have to look at the fact that the police are entering with information from Justin, believing that they're at risk, that they could be shot, and then all of a sudden a gun comes out. So I think when you look at it from that perspective, a lot of what was propelling, you know, the heightened danger in this case was the information that was provided by her fiance. I don't know how you feel about that, but that's
no, I absolutely agree. And it's a point that, like, the chat's made out, and other, like, when I did a panel on Friday that other lawyers or creators pointed out as well. It's just like, and the defense did bring it out. He hemmed and hawed for a second when he was going to try to say, well, that had you hyper vigilant. I think that, I mean, I would hope that it is something that the judge considers as far as their mindset at the time. Now, I don't want to lose you before I ask you about, so, you know, the jury versus bench in this case, I say it's like the struggle is more than your usual case, because in my mind, the Massachusetts community in this same, like, general area is sort of primed and well aware of the corruption issues that have been going on with the police, with the prosecution. And I said, but maybe that's because I'm living in a bubble, and maybe there's so many people who don't have that perspective, and you'd get just your regular old jury. But it was because of that, you know, the Massachusetts community, that I thought it's such a struggle, because isn't it harder for a judge to say, I've got two cops, one who was not in the midst of a mental health crisis, and the other who was so far in the midst of a mental health crisis that even at her own account, she was about to unalive herself.
Mm-hmm.
And could is it still a he said, she said at that point, or could it technically, under the law, he could say, I credit Noonan in that situation.
Well, I mean, I think, you know, he has to decide strictly on the elements under Massachusetts law. I mean, the elements are very clear. You know, was there a dangerous weapon? Yes. And then there's a description of intent. Under the assault, a dangerous weapon law, they kind of separated into two things, like an imminent battery was about to take place, or there's another aspect of, was there imminent fear or a threat that, you know, that a battery could take place. And so the jury instructions are a little bit different. So I'm not quite sure, you know, where this is going, but really what it boils down to is intent. And I think, you know, the lawyers for Kelsey thought that this could be, you know, kind of, you know, the confusing element for the jury, where the judge is going to understand exactly what that legal intent is. And I think they believed that the judge would find in favor of her based on how intent is described in the jury instructions. And there are additional descriptions. So I think that their feeling was, this judge understands that every single one of those 3 or 4 elements has to be proved beyond a reasonable doubt. And sometimes, you know, jurors are given instructions and they're told, you know, every element has to be proved beyond a reasonable doubt. But when they go into the jury room, it's like, was there reasonable doubt, you know, where they're talking about it in general. Whereas a judge, you know, and when I did bench trials, I would look at every single element and then I would say, is this met? Yes. Is this met? Yes. Is this met? No. So this particular element wasn't met. That's a not guilty. So I think that there's a sense, you know, that's how he would look at it. I also think, you know, people judge a lot in Massachusetts by the Karen Reed trial, and there have been some other trials that, especially in this one prior, which I've talked a lot about, and how unfairly that sua sponte creation of a revocation hearing was created. I mean,
Right.
I have talked extensively about that. So anyway, so that's my view. You know, I think there's a lot to say, and I know you're streaming it, so we can watch it and I'll stay. But the one thing I think is important for people to understand is, what is the standard by which a police officer could be charged or not charged when they fire a weapon or use excessive force. And that's a constitutional standard under a 35-year-old case, Graham versus Connor, and the very new Supreme Court case from a few months back called Barnes v. Felix, where the Supreme Court makes it very clear that the decision, you know, regarding whether there was excessive force is really based on the perception of the officer. And it's called a reasonably objective standard, meaning how would other police officers view it? Not how you would view it, not how I would view it in hindsight, not how folks in the chat may look back and view it. That's not the constitutional standard. Was his perception objectively reasonable? And in the recent case says, and it's not only for the immediate threat that was perceived, it's for everything that led up to it. And in this case, what led up to it were statements by the fiance that this is a dangerous situation. So that is part of the consideration. And that's why the police officer was exonerated, you know, because under the objective reasonableness standard and the fact that you can't have hindsight, and that you have to look at all of the facts that led up to what happened that day, including phone calls and, you know, the police bringing Justin in and the things that he was saying. Those are all fair consideration under the law. So,
Oh, though, that's good to know. We're so glad to have you. We're so lucky to have a Massachusetts judge, only retired 3 years. So she knows her shit, and she's going to be giving it to us. So
are they back yet, or?
yeah, they're back.
Oh,
They just
okay.
came back. They just came back.
Oh, okay. Because I don't see the other lawyers there, do we?
Any objection? Okay, maybe admitted as an next exhibit.
Exhibit 74, Omar.
And Courtney, Aylaian, please.
Good afternoon.
That the testimony you're about to give in this cause now hearing shall be the truth, the whole truth, and nothing but the
All right, we
truth.
got
Help you God.
sister.
Thank you.
You may have a seat, thank you. All set, thank you.
Thank you. Good afternoon.
Good afternoon.
In a nice loud voice, if you could please state your name and spell your first and last name for the record.
Courtney Aylaian, Courtney
And did you pronounce your last name Aylaian?
Yes,
How old are you?
I'm 28 years old.
In what city do you live?
I live in Stowe, Massachusetts.
Where did you grow up?
Stowe, Massachusetts.
And did you go to school in Stowe?
Yes, I went to all of my childhood schooling in Stowe. Well, I went to high school in Bolton, Massachusetts at a regional high school.
What do you do for work?
I work in software sales.
And do you have siblings?
I do. I'm the youngest of 4.
And if you could please state your siblings' names and their ages from oldest to you.
Sure. Brendan Aylaian is 34. Justin Aylaian is 32. Ashley Aylaian is 30.
And you are?
I am 28.
Thank you. I'd like to focus on your brother, Justin.
Yes.
What's your relationship like with him?
Justin has been one of my best friends for as long as I can remember. He's been an incredible older brother. He's been very, I would say the first word that comes to mind is kind. Justin is probably the kindest person I know. He is loyal to the people he loves.
The next question, please.
Sure. Are you aware that he was engaged to be married at some point?
Yes.
And around when did he become engaged, if you know?
Sometime after August of 2024.
Okay. And do you know who he was engaged to?
Kelsey Fitzsimmons.
And have you had the opportunity to spend time with Justin and Kelsey Fitzsimmons?
Yes, I have.
And do you see her in the courtroom here today?
I do.
If you can please point her out and describe an article of clothing she's wearing.
She's right here in front of me. She's wearing a pink, some sort of blazer.
Your Honor, may the record reflect the witness that identified the defendant.
It may.
Do you know when the wedding was supposed to be?
The wedding was supposed to be in October of this past year.
October 2025?
Yes.
And was it ultimately canceled?
Yes, it was.
I'd like to direct your attention to the weekend of June 28th and June 29th, 2025.
Objection.
Round.
Relevance, 403.
Okay, so let's take a question at a time, okay? All right, next question.
Did you go somewhere that weekend?
Yes, we went to Bethel, Maine.
And who is we?
Myself, the groom's party and the bridesmaid party. So Kelsey, Justin, myself, my sister, Katrina, Michelle, Deandra, Cassie, Maddie, Kelsey's sister. I don't think if I'm missing anyone for females. On the groom side, it was both my brothers, Brendan and Justin, his friends Aiden, Dave, her brother Will, Hunter. That might be everyone from the parties.
And was it kind of what's known as a Jack and Jill bachelor party?
It was a Jack and Jill bachelor party, yes.
And did the weekend end early?
Yes, it did.
And did you go home?
Yes, I fled the house.
For just exploring this, judge, is,
Okay.
you know, they're not allowed to open this door. This is an assault involving an officer and my client.
Okay, so let's do this. Let's just argue this at side. Let me hear you at sidebar, only so that we don't have to have the witness leave. I'll see everyone at sidebar.
So can you tell us why they're doing sidebar when there is no jury?
Because sometimes they don't want the witnesses to hear what the objections are.
Okay, that actually tracks.
Yeah.
But you know, I guess depending on how
There we go. Right. I mean, they're objecting to her testimony, so the judge does not want her to hear what they're saying about her. So you won't see as many in a bench trial, of course, but you will see them.
Right. Yeah. No, that makes sense. I wasn't even thinking. I was just so worked up about sidebars and because in Karen Reed, even if the jury was out of the room, they would go to a sidebar.
Right.
Like, what's happening here?
Yeah. That was a bit much.
Is it true? May I, Your Honor?
Yes, please.
Is it true that you drove home to Stowe on Sunday of that weekend?
Yes, if that is the, sorry, I'm trying to think of the days, yes. I stayed at a hotel the night before.
And then ultimately on Sunday, you went to your house in Stowe?
Correct.
And did you have without telling me what the conversation was about, did you have a conversation with Justin on that Sunday?
Yes.
And then did you again have a conversation with Justin the next day, which was Monday, June 30th?
Yes.
And as a result of that conversation, did you go somewhere?
Absolutely.
Where did you go?
We drove to his friend Hunter's house.
And who is Hunter?
Hunter is Justin's friend who he knew through the fire academy.
And where does Hunter live?
Hunter is in, I believe it is still in North Andover where he lives.
And is that where you drove on June 30th?
Correct.
And who did you drive with?
I drove my car alone. I met Justin there after he called me.
And did you, was anybody else at Hunter's house that day?
Yes, it was Hunter, myself, and two of Kelsey's friends, Michelle and Katrina, who were very concerned.
Okay, without talking about what was said, did you and Justin at some point go somewhere alone?
Yes.
Where did you go?
We went to, I'm not sure which courthouse it was. We went to a courthouse.
And what was the purpose of you and him going to the courthouse?
To file, so he could file for an emergency restraining order in custody.
And get custody of?
Caden.
And who's Caden?
Caden is Justin's son.
And how old was he at the time?
He was right around 4 months, I believe, at the time.
Did you have any familiarity with restraining orders?
No.
What did you do when you got to court?
When we got to court, Justin went to the desk and told them the situation, said he believed his son was.
Next question.
Did you help Justin fill out a form?
Per the clerk's advice, yes. Justin was shaking.
And where did you go from there?
From there, we drove to the North Andover Police Department.
And what did you do at the police department?
We both walked in and I spoke with a couple of her lieutenants, Daley. I'm not sure who it exactly was I was speaking to. And I told them that I thought she would.
And without telling me what you said, did you give the police something? Did you give the police a copy of the restraining order?
It was faxed to them, yes.
And did the police?
Overruled.
And
is that not typical? They seem to say there was some sort of email delivery system for these.
There is an email. There's an email delivery system and a fax system. When the judge issues a restraining order, when I would issue a restraining order, which we didn't do in the juvenile court generally, but on judicial response, when I covered on weekends and holidays, I'd issue a restraining order. And well, the police in that case generally would have had it. But if it comes from the court during the day, it gets faxed over to the police, to the appropriate police department. Interesting to note that when they asked about the son, she said, that's Justin's son, not Justin and Kelsey's son.
Right.
Justin's son. That tells me a lot.
Yeah. And, just because we've got to talk about it now, so be it. Is it usual that in Massachusetts, where a child's going to be taken from the home and there's not either a social worker or a DCFS worker, like that the cops just go in and take the kid?
Well, what's concerning to me about this is, and this happened a lot of times, that people, he's a firefighter, he probably has some background of the law, or maybe his sister does. So in a lot of cases there would be a race to the courthouse to go over to the probate and family court and get a restraining order. And on that restraining order, a temporary custody order, which was to only last 10 days, except for, of course, obviously, she was then in the hospital. So there are times when DCF says, yeah, we're not going to get involved because some judge gave them custody, so there's no reason for us to step in. And in my mind, and I think you asked this question earlier, or someone on the chat did, or they asked the officer that was on the stand, did you bring DCF into it? Did you file a 51A? No. Well, it's a restraining order, and there are allegations of anger, and they already know going in, they're saying she could kill someone. She could kill this baby, and they don't call DCF before they deliver it. They didn't file a 51A. Hey, we're just letting you know, we have this restraining order. I mean, they're mandated reporters, but what you have is Justin, who's someone that they know, right? Because don't they know him? He's a firefighter there for the police.
Yeah,
Because phone calls with them, they're calling him by his first name, and it's like, "Hi, Justin, how you doing?" I don't know. I think that's what I heard in some of
yeah, and it sounds like the mom had a relationship with at least either a lieutenant or somebody over there.
So I can say this, in 21 years on the bench, I've never seen a situation, even though whether I issued it or not, because I had many DCF cases involving domestic violence, I never really have seen or heard of a situation where the police call to the father who has the order and say, "Hey, come to the house. We're getting the baby." And one of the things I want to point out is that North Andover, like most departments in Massachusetts, they have a consultant. They list it on their website, their community, social worker consultant. So they take 3 officers over there and don't bring their social worker or their community person to sit in a car outside. Who do they bring? They bring him over. At least that's the testimony, right?
Right.
So I just don't, I'm like perplexed at how that all went down. It's like, why don't you come? You're getting a restraining order. You're taking her baby away from her, right from the parent. You're taking custody of this baby. She can't go within 100 yards of you. And we want you to come to the house. I mean, I don't know. Maybe people see it differently. I don't.
No, no, I don't think, no, I think all the rational people see it your way. Because that's why I'm like, why didn't they bring some sort of mental health professional? At least I'm thinking with DCFS, there's some kind of social worker there that's deals with children a lot. So I was kind of thinking of it from that sense. But yeah, going to the fact that they've got this consultant on staff, and it sounds like they had somebody who was specially mentally health trained come after the shooting.
Right.
Like
nobody comes for the delivery of the restraining order. And I understand when it comes to mental health workers that they have and social workers, they can't put them at risk. But that doesn't mean they can't say, we want you to, park outside or be ready to take this baby, as opposed to we're going to put them in Justin's hands at that moment. I mean, how could they think things wouldn't escalate, even if the gunshot hadn't been fired, and they're turning him over to Justin in front of her? How could they think that this wouldn't be an escalated situation and that there wouldn't be a heightened risk to the officers, to the baby, to Kelsey, to everyone? So this is my frustration with this case, that they didn't plan it well, and it did escalate out of control. But even if the gunshot hadn't happened, what would have happened? The moment they took that baby from her arms and handed that baby to Justin, how was that going to go down? How could they not plan better? And, I think they had an obligation to just sort of avoid, a situation that could escalate. So, they're serving a lawful order. I get that. There was nothing wrong with that. But, and they had a right to serve the lawful order. I just don't understand, how the situation wasn't planned differently. So.
Agreed. Thank you. All right, let's go.
Did you stay at the police station for a period of time?
Yes.
And what happened next?
We were at the police station praying, and we got a call from one of the lieutenants saying that kitten was safe and to come to the house.
So she said we were at the police department praying?
I can't believe they didn't move to strike that.
I mean, it's just so.
If I were the judge in that case, I might have even cautioned that, I might have done a sidebar and just said, "Hey, look, this, knock it off. This, adding these things into it, we were at the police station praying."
And she said the word. She started to
tell you that didn't. If she thinks that went over with the judge, well, I'm going to tell you it did not.
Yeah. And she almost said the words that she wanted to get out was, and I told them I thought she would unalive the baby, which I don't think helps the prosecution at all. It goes to exactly what you said and what people have in the chat have also said, that it went to the mental state of the cops, thinking that this was thinking this was very dangerous.
Yep. Which it goes back to the perception of Officer Noonan under Graham v. Connor, which is why he was exonerated, and actually rightfully so under the constitutional standard. That's different, though, when you're talking about the charges here, what her intent was,
Right.
that the judge is going to look at her intent. He could be right in terms of how the Constitution looks at it. His perception could have been reasonable, but that doesn't mean she can't be found not guilty. They're two different
Right, two completely different. Right. I'm glad you explained that to everybody because it is very different, but I can see why it was relevant to his mental state for those purposes and different to a different part of his mental state for these purposes.
Yeah, very important for people to understand that. They're two different things.
Yep. All right.
Get him.
And what house were you going to?
I'm going
When
back 10
He was
seconds.
safe and to come to the house and get him.
And what house were you going to?
125 Phillips Brooks Road.
Had you been to that house before?
I have.
How did you get there?
We had driven separately, so we both drove our cars to the house.
So you drove your car and Justin drove his car?
Correct.
And did you, approximately how long were you waiting at the police station before you got that call?
It was much quicker than we thought, probably 20 minutes maybe. I could be a little off, but 20 minutes.
And about how long did it take you to get from the police station to 125 Phillips Brooks Road?
Not long, like less than 10 minutes.
And what happened once you got there?
We got there. We were welcomed in the door by an officer. He said, Kelsey's upstairs getting some clothes for Caden.
Okay, without telling me what the officer
All
said.
right, hold on, there's an objection. Overruled. Next question.
You said you were let inside by a police officer. Is that correct?
Yes.
And then what happened when you went inside?
Lauren, Kelsey's mom, was holding Caden. She was angry. She said to Justin, Kelsey is fine. Justin.
Right.
Sustained. And you don't, no one expects you to know these legal rules, but unless you're specifically asked, you can't repeat what people told you. Okay? All right, thanks very much.
And we do expect that at this point, since she's been objected to and told numerous times not to repeat what people said, that she just keeps doing it anyway. This judge is very gracious, though.
He is.
So you go inside, you and Justin go inside?
Yes.
And then you saw, who did you see?
Lauren Page was holding Caden.
And who's Lauren Page?
Kelsey's mother.
Okay, and you and her had a conversation?
Justin and her did.
Okay, and then what happened? And she was holding the baby?
Yep.
And then what happened next?
She handed Caden to Justin. Justin then handed Caden to me. And I said, why don't I take a step outside? I wanted to avoid a confrontation. So he took the carrier, the baby car seat. We walked outside.
And so you took Caden in your arms?
In my arms.
And you walked outside?
Yes.
And did Justin walk out with you?
Yes.
And did Justin take anything with him?
He took the carrier, the car seat.
Okay. And at that point, did you make a phone call?
I did.
Who did you call?
I called my mother.
Okay. And this is while you were outside?
Yes.
And then what happened next?
There were gunshots that went off.
And how do you know that they were gunshots?
It was, I've been shooting before. I know what a gun sounds like. There were several gunshots and an explosion sound because they, I believe, had hit the air conditioner. There was a lot of smoke coming out of the window.
Objection, Your Honor, there's no personal knowledge of any of this.
Is this what you saw or?
I saw the smoke.
Overruled.
And where were you standing when you heard the gunshots?
I was near the side where the school parking lot is. I was next to our cars in the yard.
And
on the property.
Approximately how many you said gunshots, plural, how many did you hear?
There were at least 2.
And then after you looked back at the house and you saw the smoke?
I was right in front of the house, yes.
And what did you do next?
I knew I needed to run. I started to back up and I was scanning the house, just praying to see Justin come out. Sorry, I'm trying to say what I'm not supposed to, I guess, say here, but I feared he was not coming out of that house.
So
and
where did you go?
Objection.
I backed up.
Sustained, I'll strike it.
I object to the further line of questioning.
The witness can't follow the rules. I ask you to strike the entire testimony.
Okay, overruled. All right, I know you're nervous. Everyone gets nervous. Just listen to the question and just answer just the question.
Okay,
Go ahead.
apologies, Your Honor.
Where did you go after you heard the gunshots?
I ran, I put my arms around Caden and I ran through the school parking lot and was looking for somewhere to hide. And I cut into a neighborhood and looked back and didn't see anyone. So I cut behind a house and hid behind trees and I waited.
And sometime shortly thereafter, did Justin come and pick you up?
Yes.
May I have a moment, Your Honor?
Yeah.
So they're wrapping up that.
No further.
Ma'am, you said you were let into the property?
Yes,
Who let you in?
one of the officers.
And how did that go?
In what sense?
Did you ring the bell? Did Justin ring the bell? Did you knock on the door? Did he break the door in? What happened?
He did not break the door in. The officer opened the door for us. I don't recall if we called him or if he saw us pull in, but we did tell him we were on our way, so he was expecting us.
Which officer opened the door for you?
I don't remember. I think it was Daley, but I do not remember.
Have you seen any video of how you went into the house?
I have not, no.
Judge, I'm going to ask that we play a clip that's in our exhibit, our thumb drive, if I may.
All right, is it within Exhibit 74?
Yes.
Sure. Here, this format that is on the screen is on exhibit that.
What's depicted on the screen, ma'am?
What is on 74, let's just
We'll
mark
make
it
sure
and get
that
it
it
into
gets in,
evidence.
and you have a thumb drive of it. Thank you, Ron. So, do you see what's depicted on the screen, ma'am?
I do,
Do you recognize it?
I do.
And this is the porch area of 125 Phillips Brooks Road, correct?
It is.
Okay. Can you play?
So who let you in? Although it's not that important of a point,
So
but
where's the officer that let you in?
He was right behind that door. I do not recall the exact scenario. He was right at that door.
So you walked in without anyone letting you in her house, didn't you?
I don't know that I could say that because the officer was right
Did you see
behind it.
anybody on there letting you in?
I can't see the other side of the door.
So you're already in the house by that time. You walked in the house all by yourself, didn't you? With your
So
brother?
when I've gone to their house before, I typically go in that doorway and then knock at that door there.
You walked right in, didn't you?
I don't know.
so as a judge, how are you taking what's happening right now?
Yeah, I mean, this is a very typical thing, you know, that I wish I could warn everyone who ever testifies in a court, don't try to help the prosecution's case or don't try to help the defendant's case. When you don't answer honestly, because it couldn't be more clear, it's right in front of your eyes. So answer the question. Did you walk in without police help? Yes. Instead, so well, when I would visit the house, that's where I would go. The officer was behind the door. That's not the answer to the question. And it does, and when a witness does that and they're not answering and they're trying to get around, how do you trust the rest of their testimony? How credible is she when she can't even answer a yes or no question that's literally right in front of her eyes? That's how I would view it. I would not find this witness sympathetic. Doesn't mean I would discard everything she says. But I raise this again, and I don't know if I'm missing something, but why is she there?
Right.
Who brought the sister? Why is she there? I mean, it's just shocking to me. It's like, hey, Justin, you and your sister go, and they're downstairs and they're walking in while there's the potential for lethality in a restraining order where she and Justin have made clear this is a really dangerous situation, but I'm going to walk into that house. I mean, this is where I think your thought about the jury comes in, because How much weight a judge will give it, I'm not sure. But I think if a jury heard it, they would have the same reaction a lot of the people in the chat are having. It's like, do I need to trust this person? And why was she there? Will the judge look at that? I don't know. But would a jury look at it? I think that's what you were trying to point out, that, the jurors are going to see some things, that would call it into question, where I think the judge is going to say, okay, what's credible from her and what's not credible, where a jury might say, I'm not going to believe anything she says. So, yeah.
Great point. Great point. We're so lucky to have you here. All right.
Very happy to be here.
Thanks.
There's an officer right behind it.
I'm going to go back right
Or
here.
I typically go in that doorway and then knock at that door there.
You walked right in, didn't you?
I don't know. There was an officer
Well,
right
you saw it.
behind
What did
it.
you see in the video?
I walked in. I'm not sure if an officer was right behind it opening that too. Because I know he was at the door.
But I'll offer that. It's not in, but I believe it's in the thumb drive.
I'm sorry, I'm confused. Say that again?
I believe that clip is in the thumb drive, but if we find out it's not, I would offer it to them.
It is.
Okay, all right, thank you. Is there any redirect?
No, thank you.
Okay, all right, thank you very much. You may step down. Okay.
Would you raise your right hand?
Here he is. I
You
can't
solemnly
believe they
swear
called him.
That the testimony you're about to
I
give
thought
in
maybe
this
they were gonna
cause now
change
hearing
their
shall be
mind.
the truth, the whole truth, and nothing but the truth, so help you God.
Yeah. I don't think they had a choice. Had to call him.
All right.
Sir, in a loud, clear voice, can you please introduce yourself? Spell your first name and your last name.
My name is Justin Aylaian, Justin, last name Aylaian.
And how old are you, sir?
I'm 32,
And what town do you live in?
still Massachusetts.
Did you grow up there?
I did, yes.
Okay. And what schools did you go to there?
I went to Neshoba Regional for high school. That's a tri-town, so it's still Bolton and Lancaster. That's where I attended for grades 9 through 12.
What did you do after high school?
After high school, I immediately went to the University of New Hampshire, where I obtained a bachelor's in business management.
After you graduated from UNH, what did you do?
After UNH, I did a cross-country road trip where I traveled Southwest U.S., and I got a job as a wilderness instructor at a therapy camp in southern Utah.
And what do you mean by a therapy camp?
I worked as a lead counselor for some youth between the ages of roughly 15 to 18, and there were some early adults as well that were above 18. And they came to this camp for a variety of different problems, whether it was drug issues, whether it was anger issues, whether they had problems at home. They would come to this camp and we would help build confidence. We'd give them coping mechanisms. We would do that in a wilderness setting. We would teach them primitive living skills. And we would assist them in their transition, going back to their families or whatever they had after.
At some point, did you make your way back east?
I did, yes. I was out there for roughly 8 months, and I shortly came back after.
Okay. What did you do when you came back?
When I came back, I shortly thereafter, in the fall of 2017, I enlisted in the United States Army.
Okay. Did you go to boot camp?
I did, yes. I attended boot camp. In Fort Benning, Georgia. I enlisted as an infantry. So I attended boot camp in Fort Benning, Georgia. Immediately after boot camp and advanced infantry training, I went to airborne school, which was also at Fort Benning. Right after I graduated from airborne school, I was moved to Fort Bragg, North Carolina, and that's where I spent the rest of my tenure in the Army.
Okay. How long was that?
Altogether, I attempted to try to become a Green Beret, where I went to try to go for Special Forces. I went to, it's called SOTC, which is Special Operations Prep Course, prior to selection. And during that training, I was severely injured. I ended up hurting some ligaments and tendons and needed reconstructive surgery on my tendons. So I ended up shortly getting out of the military after that with an honorable discharge in the, I believe, winter of 2019.
So then did you come back up here?
I did, yes. I returned back to Massachusetts shortly thereafter. After that, I worked several different jobs. I ended up at Fidelity for a while. I worked in their 401k department. And then shortly thereafter, I started going through civil service and applying to jobs to become a firefighter.
Okay. Did you eventually get one?
I did, yes. I got on at North Andover Fire Department in August of 2021. It was at that point I also went back to my fire science degree at Anna Maria College, which was obtained roughly a year and a half ago. I got my bachelor's degree in fire science.
So what is your role in the North Andover Fire Department?
I'm a firefighter EMT with the North Andover Fire Department. My job is to protect life and property.
When you say an EMT, do you work as a firefighter full-time or an EMT? Or how does it work?
Protect life, you say. We saw you run.
With the rotation that we have, the newest 24 members on the fire department, they're in charge of running the ambulance. So on my shift, what we do is we work 2 weeks on the ambulance, and then that third week rotating off, we either go on the engine or the ladder truck.
Do you know a person by the name of Kelsey Fitzsimmons?
I do, yes.
How and when did you first meet her?
It was September of 2023. She had reached out to me on Facebook. She had seen a picture of me posted on the North Andover Fire Department page. And she was recently going to be getting hired as a North Andover police officer, and she reached out to me on Facebook.
Fair to say you developed a relationship with her?
We did very quickly, yes.
Okay. At some point, did it become more than casual?
Yep, it became more than casual very quickly. Both of us developed feelings very quickly, and that developed into a relationship very quickly as well. And it was about roughly 6 months after that we had initially met that that Kelsey and I had moved in together.
And where did you move in?
She had owned a home at 125 Phillips Brooks in North Andover. My lease had ended that May of 2024. And at that point, we decided that we were going to live together, and I wasn't going to renew my current lease that I had.
And I'm sorry, remind me, were you on the fire department? You were on the fire department.
I was, yes.
So were you living in North Andover at the time?
I was living in North Andover, yes.
At some point, you guys were living together. You had a baby?
That is correct.
Okay. And when was a boy or girl?
Boy.
Okay. How old now?
He is 13 months old.
Okay. And what's his date of birth?
2/16/2025.
So he was born while you were living together at 125 Phillips Brook?
Yes.
At some point, and I'm going to turn your attention to the weekend of July 28th, 29th, going into Monday the 30th, okay?
Okay.
Did your relationship become strained in any way? Just yes or no?
Yes.
Okay. And as a result of that, did you decide to do something on June 30th, that Monday?
Yes, I ended up obtaining a restraining order.
Okay. Now I'm going to just step back for a second, and we're going to talk about that day in particular, okay? At some point, were you communicating with the defendant at all?
Yes.
How so?
It started in the morning. It was both text and phone calls that we were going back and forth with each other. I had requested to see my son. I wanted to make sure that he was okay. She had sent many disturbing messages back and forth to me.
Where were you on the 30th, on that Monday? Were you living at 125 Phillips Brook?
That was my permanent legal residence, but I was at my parents' house that day.
Okay. Had you gone, when was the last time you had been there?
It would have been June 27th, I believe, the day before our planned bachelor.
Okay. At any point, did you go back there to retrieve some items, the guns or anything like that?
Yes, the day prior, I had gone to obtain, I knew that I needed to pick up my firearms. I had feared for my son, and I thought that his life was in danger and grave risk.
Give me a break. How does that come in?
So there's your, this is why we couldn't go to a jury, because these sons of bees would be sneaking in everything they couldn't get in.
Yeah, and the judge knows to ignore it, just like I would know to ignore it. But in real life, when that comes in and they move to strike and the judge says it's stricken from the record, it's the very old expression, once you put a skunk in the jury box, you can't remove the stink. And that's like the old expression, like once it's out there, can a jury really disregard it? It's very hard on a motion to strike. That's one of the good reasons for having a judge in this case, because he's just not going to fall into that trap. And again, here you have a witness who's trying to make his case from the witness stand, by being non-responsive, and then you're getting the standard objection, non-responsive, move to strike, and then it's out. So he doesn't benefit by it because the judge isn't buying it, and just like I wouldn't buy it. And not only would I not buy it, I at some point, if he continued to do it, I'd be calling them up to sidebar. I'd say, I'm going to take a 10-minute break. I'm going to step this back, talk to the witness and make clear, because it's a judge trial, you can do that. Yeah. And again, if he thinks he's coming off with, very important information that's going to make the case, what he's doing is having the opposite effect, at least for me as a judge hearing it. And I heard a lot of bench trials. So that's my thought.
No, then that's why we're so glad to have you. All right. And that's my dog up there moaning and screaming. So,
Oh, it's so cute though.
Oh, thanks.
On loyalty grounds and on relevance grounds to whether Ms. Fitzsimmons assaulted a policeman in the bedroom where it was just the two.
Okay. I'm just going to take the.
And what did you do?
I don't know how.
at the
See,
police
that's
station.
that thing it does
Well,
sometimes.
Said that it was-
Give them any. You got there, did you have a
Wait.
conversation?
Look at it jumped to current.
I'm just going to take the objections one at a time.
There you go.
That objection sustained, I will strike.
You own firearms.
And it's gone.
How many?
I will
roughly 9.
strike. It's all gone.
And where were they kept in the home?
Which, like you were saying, a judge can disregard, but that stench would still be in the jury's mind. I love that so much better than you can unring a bell. I'm going to start using the whole skunk thing.
They were kept upstairs in the closet. There was a large rifle safe. Several of them were kept in there. And then I had one firearm that I would keep in our bedroom that was in a green chest directly. If you were to walk into the bedroom, it was on the left side in the green chest, directly next to the door frame, locked up in my green safe.
Okay, so if you walk into your house, into your home through the door,
Yes,
the front door, the stairs to upstairs, fair to say, almost right in front of you?
correct.
Okay. Now, as you walk up the stairs, there are 2 rooms at the top. And
Yes.
There's a landing and 2 rooms at the top, correct?
Yes.
The safe that you had described, the green safe, which way would you go to get to the green safe?
You would take a right into the bedroom, and then the first foot that you would step into the bedroom, it was directly on your left, on the ground.
That was a bad question. What color is the safe, the rifle safe?
The rifle safe was black.
Black. Okay. I want to talk about that first. I apologize. Now, where was that?
If you were to go up the stairs and you were on the landing, you would take a left. You would go into that room right there, and then it was in that closet directly on the left side of the room.
Okay. And it's a rifle safe, meaning it has a lock?
Yes.
What kind of lock?
I believe it was a keypad lock.
Do you know if the defendant had any firearms?
Yes.
How many?
I couldn't be exact. She just got her license to carry returned to her. I don't know the exact number of firearms that were returned to her.
Okay. What kind were they?
Several handguns.
Handguns? Okay. When you went on the 29th to retrieve your handguns, where did you go?
I went directly upstairs and I went into that gun safe, the rifle safe that was on the left side of the landing, and I retrieved my firearms from there first.
Okay. And then you talked about a green safe.
Yes.
We're going to talk about that. You walk up the stairs, the landing is there, you go to the right, which is the bedroom, correct?
Correct.
The other room, is that the one with the crib in it?
Correct.
Okay. Now, if you go right to your left, you had described on the floor, correct?
Yes.
Okay. You had one gun in there?
Yes.
Did you see any other guns in there when you opened that?
No, I did not.
So are we not talking about the green safe?
Yes.
Okay,
Have a second.
sure.
first, okay?
Okay.
You see that screen?
I do,
You
yes.
recognize what that is?
Yes.
So describe where the photo taker, the picture taker would be standing in that home.
They'd be standing on the landing as immediately as you go up to the stairs to the second floor in between the two rooms.
Okay, and that's the one on the left that we had been describing,
Yes.
correct? I'm going to show you what's been previously marked.
The one on the left, reading the room on the left?
Yes. Okay. I'm going to show you what's been marked as exhibit number 45. Can you see that?
Yes.
Do you recognize what that is?
I do, yes.
What is it?
That is the nursery. That's the closet with my clothes in it. And behind my clothes is the black rifle safe.
Okay. And that is, when you're standing on the landing, that is the room to the left. And the closet in that room is where the rifle safe is?
Correct.
And I'm sorry if I asked this already. Did you see any of the defendant's guns in that rifle safe?
Yes.
How many do you remember?
I don't remember exactly. I believe there was two, but I don't remember the exact amount.
Now, bear with me. I'm going to take it step by step. I'm going to show you exhibit number 49. Do you recognize what that is?
Yes, that is taken from the landing going up to the second floor on the right side. That's facing our bedroom with my green safe on the floor.
Okay, so the picture taker is on the landing, correct?
Correct.
The stairs are pretty much behind them.
Directly behind.
And I'm going to show you what's been marked as exhibit number 51. Do you recognize that room, first of all?
Yes, I recognize the room.
And that's the same room we were just talking about?
Yes.
The green safe is the box on the left corner of the picture?
Yes, and on the ground, that the large chest, the box, yes.
Okay, so this is the safe you were talking about?
Yes, sir.
Okay. Do you know what that box is?
I do not know.
Have you seen that box before?
I may have, but I don't remember seeing it.
When you went on the 29th and retrieved your gun out of that safe, and you didn't see any of the defendant's guns in that safe, correct?
I don't believe so, sir.
Do you remember that box being on top?
That box was not there, sir.
I wonder what they're getting.
Now I'm going to
at
turn your
that box.
attention, now that we're on the 29th, I'm going to turn your attention to the 30th.
Wow.
You had stated that you had been calling and texting the defendant throughout that day, correct?
Yes.
Were there any plans attempted to be made by anyone?
She had made several attempts to try to get me to meet her at the Common via text message. She had reached out and said, can we meet the Common at 2 p.m.? My initial response back to that was, for what? She then, again, tried to get me to reason with me, to meet me at the Common again. At that point, I said I had no gas. There was no way for me to get there. And she tried to meet up at several points. And I told her that was not comfortable. I did not feel comfortable being alone with you. I wanted to make sure my son was okay. And I feared that his life was in danger.
That's not what he said.
Where were you when the texting back and forth was happening?
Outrageous.
You're pointing out that that's not what he said in the texts.
Right. He never said, I think my son's life is in danger. Basically, I mean, the way I read the text, it was two people who were angry with each other. And he was whining about, I have no money. I can't get to the Common. But I do believe later he went out or went somewhere and seemed to find money for gas. But, again, here, his attempts to characterize this and get information in front of the judge, it might work with the jury. It's not working with the judge. Like when they showed him the room, he goes, oh, it's next to the closet with my clothes. In other words, he's making sure that he gets information out so that they don't charge him with a B&E. See, my clothes were there.
Right.
But that was long before he went back and went into the house where people are saying was a break-in. And then the other thing he said was, oh, I don't know how many guns she had because she just, she had just was allowed to receive her license back. Okay. And the implication is I'm telling the judge that she lost her license. So the judge can think, what's the reason she might not have had her license? Again, a lot of these, negative implications and attempts, to make his story sound like it's the most plausible thing, and that he did nothing to basically heighten the risk in this case, and his continued referral. I want to make sure my son was okay, which is interesting. And the reason it's interesting is because there's not, as we would say in the law, not a scintilla of evidence that she was abusing that child, harmed that child, or had ever put that child in danger. And that's, what I think is the real frustration. It's just like, I was afraid for my son. I thought she was gonna kill my son. All that, based on what?
Right,
Based
exactly. And if this was a bench trial and the two of them had tried to sneak that in, what do you
Yep.
think would have happened?
Right. And so then, it's.
I mean, if it was a jury trial, sorry.
Right. You're right. Because then jury would be like, oh, she didn't have a license. I wonder what that's all about. And oh yeah, so his clothes were there. Well, that's he's just laying the foundation for a case later if he gets charged, which is interesting. He hasn't been charged. It happened in North Andover, right? So there's a whole other thing about whether should there be an independent special prosecutor on that one, based on his connections to the alleged connections to the police department. But, this whole thing, it's like I'm listening to it as a judge. And if I was sitting there and he said she had just gotten her license back, I'm telling you, it would not go over well with me. These things would not go. I don't know how this judge is thinking, but I would, what I would be saying is he's trying to make a case that might not be there. He's got his own reasons, but that's just me. It's hard to know, but I do think in front of a jury, it would have been damaging for Kelsey.
And if we were in front of a jury and the judge didn't want to grant a mistrial on something like that, but it would now open the door to, especially because we know from the allegations in his affidavit supporting that petition, like you said, there's not a scintilla of evidence that would have given anyone any pause to say she might hurt this child. And now you would want to get all of that in. Like that he literally has no basis. That's why I think Bradl kept saying, well, it's supposed to be an open and shut trial. But if they open the door and if, and between their two civilian witnesses or non-police witnesses, this would have been a complete and total shit show.
Yeah. Yeah. I mean, it would have taken on a whole different tone because it would have to, then you're going down that rabbit hole of the door is open.
Right.
And that's where it leads. But, of course, the judge is, smart enough to sort of understand what he's trying to do. And he's going to ignore that because he's laser focused on taking evidence about those elements. That's what he's laser focused on. Right. And so him saying things like that, doesn't really go to any intent that she had. But he's trying to make the case that, well, he got this restraining order and whatever he put in the affidavit made it seem dangerous so that wanting the judge to think, oh, well, then she developed the intent to harm this because she was already dangerous. Judge isn't going to think that, but a jury would. I mean, based on what I'm hearing so far, whatever the judge decides, I think they made the right decision for a bench trial. And I think these are the reasons. I think they knew, he was going to sort of go off the rails. He was going to say these things and they're jumping up and having sidebars and telling the jury, disregard that. Now, all of that isn't there. And that's a good thing, because as a judge, I wouldn't be considering any of that stuff.
Right. And like you pointed out, if this was a jury, that skunk stink would still be in there, no matter what action the judge took to take it out.
We always called it, skunk in the jury box. It's sort of a famous expression. Once it's there, you get it. The smell is there. Can you ever get it out? Can't get it out. So
right.
I believe I was at my parents' house in Stowe.
Okay. At some point, did you make your way to North Andover?
I did, yes.
Why?
I felt that my son's life was in grave danger and that imminent harm may come to him in the hands of Kelsey.
Okay. So as a result of that.
Overruled just as the state of mind, not the truth.
So where did you go?
Accepting it for the truth.
I went to my friend Hunter Hassam's house.
Right. I mean, at this point, he said it multiple times. I've heard it multiple times. I'll let it in for the his state of mind, even though that wasn't what they were asking. They asked, why did you go over there? And the answer was, they told me to come get the kid. We weren't talking about whether you like, that part was done and over with. The police were there. But
and as you know, in a jury trial, when a judge says, I'm going to allow it for the state of mind, and then they're going to give an instruction about it, a curative instruction saying, the evidence that you heard from this witness, it would be right after this. The evidence that you heard from this witness, you cannot consider for the truth thereof, only that's what he was thinking, that was his state of mind. So they'd have to give a curative instruction. But, again, you always wonder how these curative instructions work. Like on a rape case, I would have I would have to give, it wasn't a curative instruction, but a special instruction about the first complaint witness, as they call it in Massachusetts. And so you're stopping the testimony about the rape and you're saying to the jury, okay, now I need you to listen to this special instruction. So, curative instructions, I mean, it's the word curative, but you wonder how much it cures.
It actually cures, right? Yeah. All right.
He was renting.
So where did you go?
I went to my friend Hunter Hassam's house. He was renting an apartment in North Andover at the time.
Did you call anybody to meet you there?
I don't know if I had made the calls or they had called me, but I had called my sister Courtney. I told her that I was going to North Andover. I had feared for my son and that I didn't know what was going to happen, but I had called her and I was in contact with Kelsey's maid of honor, Katrina, and her bridesmaid, Michelle.
Just nicely setting the foundation.
So Katrina, Michelle, Courtney, Hunter, and you?
Yes, sir.
All right.
Right, exactly. I mean, like you said, this goes to show that they could, well, even whatever happens with this judge, they would have had no chance with a jury, with them just literally throwing in all this shit every single chance they get, and maybe everybody would have been more aware and heightened after Courtney to stop this in front of a jury. And there's not as much risk with the judge. So who knows, but yeah.
Right. Yeah, absolutely.
Are you all in Hunter's house right now?
Yes, sir.
Okay. Without saying what was said between was there anybody else there? Because I have 5.
I believe Hunter's girlfriend at the time, she was there as well. I believe she was present.
Okay. Now, were you communicating when you were there with the defendant at all?
Yes.
Can you tell us about that?
Here come the texts.
There were text messages that were being exchanged just over Caden, our son, and just general messages back and forth.
Okay. Did you ever agree to go meet her at the park?
No, sir.
Okay. At some point, did you learn through the text messages anyway that she knew you were at Hunter's?
Yes, sir.
Can you tell us about that, please?
All of us were at Hunter's. We were all discussing the events that had occurred and what we could do to ensure Caden's safety, which is our son, but also Kelsey and everyone else around. At one point, Kelsey had messaged my phone.
I'm sorry. To the extent, Judge, that questions are open-ended, producing narrative answer, I object.
Absolutely right.
There's been all sorts of objections sustained about his answer. So I would ask the court to maybe direct the Commonwealth to make more specific questions so that it doesn't produce an answer that's half okay and half non-responsive and objectionable.
So the objection is overruled. If you could just try to just answer the question to the best.
Well, I wanted to make sure you had a chance to speak on that.
Well, I don't know why he overruled it, because I would have sustained that objection, because you have the prosecutor asking open-ended questions. And you have to ask direct questions, but they can't be so open-ended that it results in what's called
narrative.
Right, as you know. So once someone starts in a narrative, and that's what he wants to do, and that's what witnesses want to do, that's not allowed under Massachusetts law and in most states. And you people hear it all the time. It's like they just go on and on. And, he's objecting, he's saying it's a narrative, and he's saying, ask the prosecutor, to tell this witness, to answer the questions and not go off on a narrative. So he overrules the objection because he knows he's not considering it. But on the other hand, he is making it clear to the witness, answer the questions.
Right. And, I'm not in a position right now to say that this judge has already made up his mind, but I don't know if you heard earlier, I was making the point that as a lawyer, whenever we're in front of like either on a hearing or a bench trial, that sometimes when the judge rules in your favor for everything, you fear, I'm about to get my ass handed to me, because is that a fair assessment that sometimes when you know that you're going to rule for the other side, you let the side you're going to rule against get more in?
Well, I never, as far as I'm concerned, I made my decision was like, I'm going to listen to everything and I'm going to rule on the objections as they come. Some people have this opinion that when you rule for one side, it means that you're shutting down any potential appeal. So you say, okay, the objection is, your objection sustained, like in this case where your objection is sustained, are you, or overruled, and you allow it to come in. When you allow things to come in, then the objection is lost. In other words, you can't appeal that because you allow. So if I said overruled, I'll let the witness answer. Although I just said overruled, I didn't do this thing where people say I'll allow it, because that's not how you're supposed to do it as a judge, and that's just the way it is. But I just listened on both sides and ruled on it based my understanding of evidence in the law, which is something that was really important to me. But, I know people say that, but I will say anytime you overrule something and allow it to come in, you wipe that out in terms of, like in the recent Brian Walsh case. I mean, Judge Frenier let a lot of things in that maybe other judges wouldn't under the 403 or 404 rules of bad acts. But, once she allowed it in, it took away any potential appeal that Walsh has on the murder case. So that's how it works. You overrule it, you let it come in, the appeal's gone.
Right.
Well, if it's the defense in a criminal case and you overrule the prosecutor's objection and you let what the defense wants in, every time you do that, they lose that piece for an appeal. So,
right. And that's why I'm always saying when that starts to happen to me, I start to think, oh no, this judge is about to rule against me. So he's doing everything to err in my favor. But you never know. You never know.
Yeah, you don't know.
Right. All right. Let's back it up 10 here.
Okay, and have non-responsive and objection.
So the objection is overruled. If you could just try to just answer the question to the best of your ability, right?
Yes, Your Honor.
All right, next question.
Thank you. Did she, meaning the defendant, say something to you to indicate that she knew you were at Hunter's?
She
Yes,
had,
yes or no?
yes.
Okay, what did she say?
I don't remember the exact verbiage, but it was, what are you doing? Something along the lines of, what are you doing at Hunter's? What is happening? Why are you with my friends? Something along those lines.
Okay. Now, without getting into the conversation that you had with your friends and with your sister, was a decision made for you to go somewhere to do something?
Yes.
Okay. And what was that?
To go to Lawrence to obtain a restraining order attached with temporary custody of Caitlin.
Okay. And did you do that?
Yes.
Where did you go? Do you remember?
I don't remember the exact, it was family probate court, I believe it was, but I'm not 100% sure.
And who did you go with?
I went with my sister, Courtney.
Okay. Now, did you fill out paperwork while you were there?
I did, yes.
Did anyone assist you in filling that out?
Yes. My sister helped me, and then there was also someone with the court system. I don't know who the name was, but they assisted as well.
Fair to say you went in front of a judge, an order was issued, and then you left the building, correct?
Yes.
Okay. Where did you go when you left the building?
I immediately went to the North Andover Police Department.
Okay. When you got there, did you have a conversation, without saying what was said, with some of the police personnel there?
Yes.
Did you give them anything?
I believe I handed them the restraining order, and they said that it was already faxed to them.
Okay. At some point, did they leave?
They did, yes.
And what did you do?
I waited at the police station while they went to the Kelsey Fitzsimmons home.
Okay. And at some point, did you get a call?
I did, yes.
From who?
I believe it was from Officer Daley. He had called to inform me to come to the residence and get custody of my son.
So did you go?
I did, yes.
Did you go with anybody else?
My sister and I, we both went to the house. We took 2 separate cars.
Did you get there at the same time?
Yes.
What happened when you got there?
At that point, we both walked into the house. Officer Daley was downstairs. 2 officers were upstairs. And Kelsey's mother was holding the baby in the living room. At that point, I obtained Caden from her mother. And then we initially started to put him in a car seat. And then once he started crying, we figured it might be best, my sister and I, to get him ready for transport, to bring him back to Stowe outside.
Okay, so who carried Caden out?
My sister, Courtney, did.
And what did you do?
I asked if I could obtain some clothes while I was there. I just needed something so I could live day to day, as I had no clothes or any of my son's.
Was this the first time you went out, or did you go back in the house a second time, if you remember?
This was the first. I went out the first time, and then I came back in.
Okay, so the first time you went out, Courtney went out with Caden.
Yes.
What did you take, if you remember?
I believe I had a car seat in my hand.
Okay. At some point, you came back?
Yes.
And you asked permission to do something?
Yes, I asked permission to get some clothes and a few clothes for Caden and some of his bottles and formula.
Okay, so where did you go?
I went down to the basement that was under construction at the time. There was no lights on, so I believe I had my camera, my phone out with the light on it, and I was searching for a suitcase that I had down there just to throw some clothes in.
At some point, was your attention drawn to something?
Yes.
What happened?
I immediately heard an officer's commands. I heard an officer scream out, "Stop, don't do it." At that point, I believe I had heard several gunshots ring out, and I heard Kelsey's mother screaming.
What did you do then?
At that point, I immediately ran through the garage, which was connected just to the basement. There was no wall there. Again, we're putting up a wall, so I ran straight through there. I fumbled with the lock for a second to get it open, as there was no light down there. As I got it open, I threw the door open, and I ran around the side of the house, screaming for my sister to run.
And so where did you go? Did you see your sister?
I believe I saw her briefly. I did see her running down past the school that was adjacent to our property.
With Caden?
Correct, yes.
So what did you do?
At that point, as I saw my sister run, I knew that we needed a vehicle for transportation to get out of there, to get out of the area as fast as possible, fearing for my son's life, for my sister's life.
Sustain, just what you did.
I got into my vehicle. I believe I had made eye contact very briefly with Officer Houston, who was grabbing his medical bag out of his patrol vehicle. I got into my truck, and I immediately pulled a U-turn and drove where I.
All right, so he knew everything was safe at that point. He knew it was safe, that if he could help in any way, shape, or form the woman that he once loved, the mother of his child, that he should run back inside, let his sister know via text it's safe to come back. They have the scene under control.
It's unbelievable, right?
Yeah.
He says, "I feared for my life." And you know, I mean, he keeps getting that in, and as you heard, the judge sustained it. You know, it's like, I think the judge had enough of him, you know, saying that the baby was in danger. Here's what you didn't hear. Oh, did you go to probate and family court? Yes, I did. Did you get a restraining order? Yes, I did. Here's the question that wasn't asked. What did you say in the affidavit that, you know, that caused the judge to give you custody? What did you say about in the affidavit about how Kelsey was abusing the child? What evidence did you provide? None of those questions were asked. I thought that was interesting. Right. And I will say this again. because it's really a stunning situation that he and his sister are allowed to approach a home where a restraining order is being served on someone, which is the highest level of lethality in domestic cases or restraining orders. Because I spend one of my jobs as I teach for the Massachusetts Police Institute, and right now 6 times a year with a partner, I teach advanced domestic violence training. And one of the things we talk about with police is, what are the signs that that there could be a lethal situation? And there are a list of factors. And so some of the things you might consider would be, the removal of a child, or there's a child there. It increases the danger. And what do the police do in a situation where there's an escalated chance of danger, where there's been a restraining order and a grant of custody on a restraining order, which doesn't happen very often? They're like, hey, yeah, come on down, Justin, and bring your sister. I mean, it's actually stunning, because in my view, the decisions there put civilians at risk when they should be nowhere near that home. So it's just amazing. And, I think it sort of reeks as a relationship was existing between the police and Justin. You kind of heard that in phone calls when he was calling about wanting to get his clothes and wanting to go in and wanting them to approve it so that it didn't look like a break-in. When he made those calls, which won't maybe come up in this trial, he's like, well, I'd like to talk to the OIC. Like, he knows all the language,
Right.
the officer in charge and all of that. But I don't know. I think what, maybe, the public doesn't see, and what the jury wouldn't consider is just sort of the stunning nature of the fact that they had him there and that they had the sister there, because it sort of reeks of some kind of pre-plan,
Yep.
Where I'm going to run to the probate and family court to keep DCF out of this. And then I'm going to go to the house with the police, and really, I think someone should be called to account for the decisions that were made, allowing civilians to be there. I don't think you'll find anywhere in the police protocols of the North End Department that you can have a civilian there when you're serving a restraining order with custody. You bring your social worker or your mental health advocate or DCF, and they bring the child back to the police department, and then you turn the child over. This is just really, really stunning in that aspect. How it goes to the overall case, I don't know. We'll see what
Right.
the judge thinks. I just have to say it, because
Right.
I'm just telling people that it's a rare circumstance. I've never seen it in 20 years, that civilians were like, invited basically by the police or allowed by the police to be present at the service of a restraining order and a custody removal. Shocking.
Yes. All right. Keep going.
Saw my sister running from. Once I got to the other end of the school, I had stopped my vehicle. And at that point, I didn't see which direction my sister had gone. So I had stood outside my car yelling her name repeatedly. I wasn't sure where she was or if she was okay. And then
At some point, did she appear?
she did appear. She came running out behind another house across the way, and she came running over towards me.
And what happened when she got to you?
She got in the vehicle, and then we quickly drove down the road to get away towards Mass Ave in North Andover.
And where did you eventually go?
We eventually made our way back to Stowe, Massachusetts, my parents' residence.
Thank you. I'll get just that 1 second.
Yes.
Defendants had, were the guns, that you and the defendant had, were they ever kept in the basement?
No,
Is there a gun safe in the basement?
there was never a gun safe in the basement.
Did you have a way of remotely accessing the surveillance cameras?
I could look at them.
Did you before you went over?
Remotely accessing them, I was able to view them, yes.
Okay, when you did you see the defendant's car in the driveway?
No.
Okay. Is that where she usually parked?
Yes, always.
Okay, and when I asked you that question, what time frame are we talking about?
During the day, what time?
Yeah.
It must have been roughly 5 o'clock, 5 p.m.
Thank you. I have nothing.
Okay, cross-examination?
Good afternoon, sir.
Good afternoon.
So a lot of talk about gun safes. The safe that you mentioned with your rifles in it, that was in the baby's room, correct?
Correct, yes.
And that's the room as you go up the stairs to the left, you hit the landing, you go make a left, you're in the baby's room, correct?
Correct.
And then you visited the house on the 29th to retrieve your guns, right?
Yes.
And it's fair to say that you spent about 60 seconds with the baby.
I would say that's not true.
Kelsey had to tell you, do you want to see your baby? Do you want to hold your baby? And you held your baby for about a minute. Isn't that right?
I was at the property for roughly 30 minutes.
Answer my question.
Okay.
Is that true?
Yes.
So with respect to the gun safe in the bedroom to the right, up until then, that was your and Kelsey's bedroom, correct?
Correct, yes.
And there was a green safe in that bedroom, right?
Yes, sir.
And on the 29th, you went to that bedroom and you retrieved some of your firearms from that green safe, correct?
Yes, sir.
In fact, that was your grandfather's safe, wasn't it?
Yes, sir.
And you wanted to take that with you, didn't you?
I did, yes, sir.
And you took Kelsey's guns out of that safe and you put them on the bed so that you could take only your guns and your grandfather's safe. Isn't that correct?
I did not take the gun safe, sir.
Isn't that what your intention was until Kelsey asked you not to?
I did leave the gun safe, yes, sir.
You left it because Kelsey asked you to leave it because she needed a place to safely keep her guns, right?
I don't know if that was her intention, sir.
So let's just go back a minute. You said that you went into that safe, you didn't see any other guns, you took your guns and you left. Isn't it true that you took Kelsey's guns, which you did see in the safe, you put them on the bed, and you tried to take the safe?
I do not remember if I took any of her guns out of the safe, sir. I don't remember seeing any of her firearms in that green safe. I only remember seeing them in the black safe.
So, I mean, you were very interested in getting your stuff out of that house on a couple occasions. This was your chance to get your grandfather's gun safe out of there, and it's your testimony that you just decided to leave it?
The only priority was removing my firearms. That was secondary because it was holding my safe, and it meant a safe transport way to move that firearm out of the house in a secure manner.
And when you left Kelsey with her firearms, and you took yours and you went back to Stowe with your father, correct?
Yes, sir, I took my firearms.
Now, you said you were, just want to get it right. You said that you work at the North Andover Fire Department, is that right?
Yes, sir.
Do you work there presently?
Yes, sir.
Are you on the schedule?
No, sir.
Why not? He opened the door.
I'm sorry, objection? Relevancy? Yeah, I'll hear you at sidebar.
Here we go. The big fight over whether or not they're going to get in the fact that he's been suspended from the North Andover Police Department. So that's what this is all about, because they're saying that they opened the door when they said, "Where do you work?" He said, "The North Andover Police Department." You open the door, you don't work there.
Right. Right. All right, I guess we'll see what the judge ruled.
Sir, you're not on the schedule and you're not presently
There you go. Exactly right.
able to work for that department, isn't that right?
Yes, sir.
And the reason you were placed on suspension or administrative leave, whatever you call it, is because you have been caught on video many, many times using drugs that are in violation of your department and the town policy, correct?
Allegations were placed against me, and the town has a responsibility to do their due diligence and investigate that matter.
So that's a yes?
Yes, sir.
There you go.
When
Trust
did
me.
that go into place?
I don't have the exact date, but roughly a week or two ago.
Do you know the duration of this suspension or whatever you want to call it?
Sustained.
How, oh, sorry.
Let's move on, Mr. Bradl.
Sure. Nothing further, thank you.
Redirect?
No, thank you.
Okay. All right, thank you very much, sir.
Thank
may
you, Your Honor.
step down. And,
I think he could have done a little more on that with the whole.
I agree. I'm surprised that there's no cross about, him being it, but it already came in that
Right.
he was there. So,
But he could have said in your affidavit to support
Yeah.
the
Yeah.
thing, like you said earlier, there were
Yeah.
no allegations of harm to the child. There were no,
Right.
at least to touch on that.
right.
But
I don't know how they're going to bring that in. They may be bringing it in through another witness.
That's
They may bring, it may very well be that they're going to bring in the records from the probate and family court, have someone certify that those are the records, and then get the affidavit in, to say that, there's no allegations of abuse. It's hard to get it to come in through him. And I think, they made their point. It's like, you've been suspended, you use drugs. And that's what's really interesting about that is, I guess the question I would have asked if I were, cross-examining, I would have said, did you say anything in your affidavit to the probate and family court about prior drug use? I think I would have gotten that in. He just wasn't going to admit. He tried to get around it, of course, but.
right. Yeah. All right. Let's see who we got now.
Could you raise your right hand? Do you solemnly swear that the testimony you're about to give in this cause now hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. You may have a seat and put yourself right up to the mic. How are you doing this afternoon?
I'm doing all right. How about yourself?
Excellent. Thank you. You may proceed.
Sir, in a loud, clear voice, can you please introduce yourself? Spell your first name and your last name.
Patrick Noonan, PatrickNoonan.
And how old are you, sir?
50,
And what town do you live in?
North Andover.
Where were you born?
Rochester, New York,
How long did you stay there?
until I was about 4 years old.
And where did you move to?
North Andover.
Who did you move with?
My sister, mom and dad.
And what are their names?
My mom is passed, but my dad is Timothy Noonan.
And what was her name? Your mom?
Patricia.
And your sister?
Mary.
Does your sister live in the area?
She lives in Lynn.
Where did you go to school?
For high school?
Grade school, high school?
The North Andover Public School Systems. And then for high school, I went to St. John's Prep.
And did you play any sports there?
Hockey and lacrosse.
Did you graduate?
I did.
Once you graduated, did you further your education in any way initially?
Initially, yeah, I went to Siena College for about a year, and then that wasn't working out. I got my degree later on down the road.
What'd you get your degree in?
Criminal justice.
From where?
UMass Law.
Now, after you left Siena, did you work?
Yes, I did.
What'd you do?
I worked at Macy's Security.
And at some point, how long did you work there?
Couple of years. It wasn't too long.
Did you meet anybody significant in your life while you worked at Macy's?
My wife,
Who's that?
Angie.
And was she working there also?
She was.
Did you get married at some point?
We did.
Okay. I'm gonna ask you a dangerous question. What's your anniversary?
It is December 22nd,
Okay.
1999.
1999. Okay.
Yep.
Thank you. Do you have any kids?
I do.
How many?
Just one.
Boy or girl?
Boy, Joseph.
And what does Joseph do?
He is currently at UMass Lowell as well, studying environmental engineering.
Have you lived in North Andover ever since you've been 4 years old?
No,
Did you move around?
I did when I was in the military.
Okay, we'll get to that.
Oh.
I'm sorry about that. At some point, you talked about you were in the military. What area of the military did you join?
Air Force.
Okay. And when was that?
That was in 99.
And where is boot camp for the Air Force?
Lackland Air Force Base in San Antonio.
Okay. And can you tell us a little bit about boot camp? Some of the training, some of the things that you were subjected to, I guess?
Yeah, I mean, it's you know, some sleep deprivation. You also have, you know, you have to learn how to march. They basically strip your identity and try to build you up as a team.
Okay.
Firearms training, things along that.
At some point, did you make it through boot camp?
I did.
Did you, I guess, enlist or volunteer to any special area of the Air Force?
Security forces.
And what is security forces?
They're basically the defenders of the force. So when I went in, I went through my tech school, which is almost like a police academy. We learned various different things in there, land nav, different weapons systems, things of that nature. And then once you graduate, you get your orders cut.
And what were your orders originally?
Cheyenne, Wyoming.
Okay. And what was your role when you were in Cheyenne, Wyoming?
I originally, when I was waiting for my security clearance, I was originally working on the ground. So ingress, egress from the gates, a cruiser, enforce the laws of the Uniform Code of Military Justice.
When you're going through that type of training, are you trained in the use of firearms?
Yes.
Any different, all different types?
Yes.
Any other types of weapons?
Yes.
Such as?
The 60, which is a fully automatic machine gun. The SAW, which is pretty much the same, only it's a little lighter. The 203, which is an M16 with a grenade launcher attached to it. M16 and also your sidearm.
Eventually, did you get your security clearance?
I did.
Okay, and was your assignment different when you got that?
Yes, they moved me over to like a camper team. So whenever a facility goes down, you go with a 4-man team to protect the site.
Okay. What kind of sites are we talking about?
Missile sites.
Okay. Nuclear missile sites?
Yes.
And are they in one state, more than one state?
Tri-state.
And what tri-state area was that?
That would be Wyoming, Nebraska, and Wyoming, Nebraska, Colorado.
And was that your range or?
Yes.
And at some point, well, can you tell us a little bit about the training you got? Was there any specific training for that job?
It was basically like on-job training.
Okay.
We're already trained up, so you get your orders, you get your assignment, and you link up with your 4-man team.
Okay. At some point, did you move on from what you had described as a camper team?
Yes.
To where?
Fire team.
And what is a fire team?
Fire team consists of 4 people. Each person carries a different weapon, from the machine guns to the 203, so on and so forth. Our primary responsibilities were if any alarms were tripped on any of the missile sites, we respond.
Okay. And so you're heavily armed.
Mm-hmm.
Is when you say you respond, is that on the ground?
Yes, it's on a Humvee. Yeah.
Okay. Did you at some point move from a camper team to something else?
Yeah, to the fire team, and then from the fire team, I went to the 37th helicopter unit.
Okay, so the helicopter unit.
Helicopter unit.
So how was your role different in the helicopter unit than it was on the camper team or the fire team?
We're still a 4-man fire team, but our primary mission there was to have overwatch whenever we're transporting nukes to or from base. And we basically radio down to the U.S. Marshal if we see a potential threat up ahead.
When did you leave the service?
2003.
And when you left the service, did you go to work anywhere else?
Seabrook Nuclear Power Plant.
In what capacity?
as an armed guard.
And any specific training of that, or did you rely on your military training for that?
There was also additional training for that. I think it was like 22 weeks or 12 weeks.
And what kind of trainings were that?
Just basic knowledge about nuclear energy, where to go in the plant, where not to go, different hazards to look out for, firearms training, and general knowledge of the whole plant itself.
At some point, did you decide to move on from Seabrook?
I did.
And what was your plan at that point?
The North Andover Police Department, I got on as a full-time reserve.
Okay. And how long were you a full-time reserve?
For 1 year.
And then did you become a full-time police officer?
I did. Went to the academy in 2006.
At some point during your tenure at the North Andover Police Department, did you have additional responsibilities?
Yes.
What were those?
Areas of responsibility, different sectors you're assigned to, respond to calls of service, 911, medical, effect arrest when necessary, enforce motor vehicle law.
Okay. What is RRT?
That's the regional response team.
And what is that?
They're a part of NEMLEC, and the RRT team primarily they deal with big crowds, riots, crowd control when it comes to let's say big games. If we win championships, just extra security, and also kind of like a search and rescue. If people go missing somewhere, they'll deploy the RRT to try to find them.
Were you part of that team?
I was.
For how long?
I would say about a year.
And NEMLEC, that's NEMLEC, correct?
Yes.
Northeast Massachusetts Law Enforcement Council?
That's correct.
Okay. Did you apply for a different role with NEMLEC at some point? And what was that?
SWAT team.
And what's the difference between the RTT, the Regional Response Team, and the SWAT team?
The SWAT team primarily is special weapons and tactics. So we get trained up on different weapons, different uses of less lethal. We execute warrants, knock and no knock, for drugs and guns. If there is a hostage situation, I mean the whole gamut. Anything dangerous is what SWAT usually goes in for.
And so, was this a team you had to apply for?
Tryout.
Tryout.
Mm-hmm.
Okay. And what did that consist of?
8 days. It was like a 3-mile boot run in the morning, and then you had to do push-ups in a certain amount of time, sit-ups, squat thrusts, squat benders. Then you had to run 1.5 miles after that and make a specific time. After that, it was a 3-mile obstacle course you had to complete in a certain amount of time. And then after that, it was all firearms.
Okay. What's stress shooting?
When you shoot under stress, so typically how we induce stress when we want to stress shoot is we'll do sprints.
I put him at 1.25 for all this background.
Here's an expert.
Yeah, I'm not sure it's necessary.
I'm sorry?
Giving expert testimony about what you should and shouldn't do under stress.
Well, he was asked how he practiced stress shooting. That's the way I understood it.
So the assumption that sort of rolled in there, Judge, is that he knows about stress shooting, he knows what he's doing with respect to stress shooting.
Well, he does, because he's been trained in it, and he's telling me that about the training, so.
Well, I don't object to his training, we're hearing a lot of it, but I do object to any sort of imprimatur as if he's an expert in giving his opinions about the area.
Okay, so I'm gonna take, as I said, I'll take it as it comes. I haven't heard any opinion testimony. If there's an opinion, please by all means object, but overruled.
Did continue.
So to induce stress, when we go up to the range, we'll do a series of sprints, burpees, push-ups, sit-ups, and then we go right in line. That's for the intent of raising your heartbeat to a very high level and being able to shoot on target.
And when you say online, what do you mean?
Right in front of your targets.
Okay.
That's what I mean.
Right. What's SWAT school?
That consisted of a full week, and I went to Worcester, and it was put on, hosted by LAPD SWAT.
Okay. What did that consist of?
Room entry, hallway clearing, room clearing, building searches, building clearing, the use of flashbangs, firearms, less lethal weapons.
How do you think all of this stress training and is going to play when the judge hears he missed his target?
Yeah, I mean, he did miss his target. I think, he does have a lot of training, around stress, and he's in one of the most stressful situations. I don't think any of it, really relates to the three elements, the 3 or 4, depending on which assault dangerous weapon. I don't think much of it relates to, any relevance with what the judge has to decide. It might be impactful for a jury, I think, to think this guy really knows a lot, but that's not what the judge is going to look at.
Right. Okay.
Operating a Bearcat, shield work, the use of a Halligan, the use of a ram, things of that nature.
What's a shoot, don't shoot scenario?
As far as
is that a thing? Shoot, don't shoot?
Oh yeah, we have shoot but don't shoot scenarios.
Okay, and did you participate in those?
We did.
What are those?
They would put up targets when we were clearing a house, and some of them, the pictures were depicted of either someone having a gun to someone's head as like a hostage, or someone would just be holding up a purse. So that was shoot, don't shoot.
Okay. How often, when you were with SWAT, were you required to train with them?
2 times a month, and then a 40-hour block in a year.
Every year?
During the year, yeah.
Okay. And so how long were you with the SWAT? You were with it twice, correct?
Yeah, I was on 2 different teams.
Okay. The first time, how long were you with SWAT?
From 07 to, I believe, 13, shortly after the marathon bombings.
Okay. Did you, at some point, did you switch departments?
I did.
And you were in North Andover at the beginning, and where did you go?
I went to Lawrence.
Why?
I wanted a little faster pace.
Did you get it?
I definitely did.
Okay. Now, while you were with Lawrence, did you continue with your SWAT?
Yes, I tried out for the Lawrence SWAT team.
Okay. Can you tell us your trajectory while you were in Lawrence? Were you always on patrol?
No.
Okay. Can you tell us about that, please?
Became a field training officer, and then I wound up in detectives for several years, and then I went back to patrol to field train the new guys, SWAT, and that's pretty much it.
Now, you said you tried out for the Lawrence SWAT team, correct?
Yes.
And how long did you do that?
That was another 8-hour day.
Okay. I'm sorry. No, was that, I don't mean, that was a bad question.
Oh.
How long did you make it, right? You made
Yes.
it. And how long did you participate in this Lawrence SWAT team?
I believe 2019 to by the time I departed and went back to North Andover.
Okay. And so,
2024, Your Honor.
why did you come back to North Andover?
I just wanted to bring my training and experience back to where it all started. I have 10 years left, so yeah, that's about it. And I'm getting older, so the slower pace is kind of needed.
Okay. So I'm going to turn your attention back to June 30th of 2025.
All right, I'll slow it down now.
Were you patrol on that day?
Yes.
Okay. What was your shift, if you remember?
I did a swap, so I was working for another officer. So that shift was 4 to 12.
At some point, did you get a call from someone in particular?
Yes, Officer Houston.
At some point, did you learn why he called you?
Yes.
And why was that?
Apparently, the defendant's ex-fiancé took a restraining order out.
You had to serve it?
Yes, we had to serve it.
Did you know that person? Did you know a person by the name of Justin Aylaian?
Didn't know him, but I met him on one occasion.
Did you know the defendant, Kelsey Fitzsimmons?
Knew her, but not well. She was.
Why did I think everyone was saying that they were former partners at some point?
Yeah, I thought I had read that, they said that they were friends, or maybe, maybe she had said, that they were friendly. It doesn't seem to be coming off that way.
No, and I kind of figured that even from the questioning of the first witness, I was like, I think they would have mentioned by now if these guys were former partners, but all right.
On maternity most of the time that when I first transferred over. So
All right, so you got a call from Houston.
I did.
Where did you go?
We met behind the Atkinson School. It's called the CCC, and he explained the situation to me.
Was he, anybody else arrived at that point?
Not yet.
At some point, did someone?
Yes.
Who was that?
Lieutenant Daley.
Did you talk about any plan as to how this was going to occur?
Yeah, Lieutenant Daley said that he'd do the talking, and based on the restraining order, Justin was supposed to get custody. Oh, sorry.
Well, I'm sorry. Well, I'll jump in. So you knew that there was potentially a child there,
yes,
and that the child would be transferred from the defendant to the fiance, correct?
That's correct.
Okay. So where did you go?
So from there, I pointed out to Officer Houston and Lieutenant Daley the positioning of where the defendant had parked her car, which was at least 150 yards away from her house. And we all thought that that was very odd.
So where did you go?
We pulled up right before the house.
I've been wondering why they're making such a big deal out of this. How odd was it?
Right. I know. I'm not sure where that's going.
I don't know.
What is the relevance that she parked the car? They've asked that now several times. I mean, I don't know. Maybe she was expecting, her mother was there. So maybe
Plus,
she was
if she was going to meet at the park. She could have driven to the park, taken the kid out, had the baby out, and then thought, and if it's walking distance, thought, well, I might as well just stroll her back. I don't know. Was she?
I haven't heard one bit of relevance about it. And when he says we all thought that was odd, I mean, again, if I were the judge hearing that, I'd just be saying,
why?
Why is this relevant?
Right. And maybe it ends up working in the defendant's favor because their whole mental state about what to expect from her seems a little out of whack.
Yeah, good point.
The foliage was pretty overgrown, so we left our cars there, got out, and walked up to the front door.
Okay. At some point, did you come into contact with the defendant?
Yes, we did.
How did that happen?
Lieutenant Daley knocked on the door or rang the doorbell, and she came out.
Okay. Was she with anybody?
Her baby.
Where did you go?
We went into the family room. She went straight to a couch that's off to the left, and I kind of went straight. There was another couch, and I believe Houston was to the left of me.
Did you see and hear Lieutenant Daley interacting with the defendant?
Yes.
Can you tell us what you saw?
He explained the situation that Justin had taken the restraining order out, that we were going to have to remove firearms from the house, and that the baby, their son, he was going to be in Justin's custody for, I think it was 14 days until the next court hearing.
When Lieutenant Daley mentioned that the guns were going to be removed, did the defendant say anything about that?
Yeah, she said that they were located downstairs in the basement.
What happened after that?
I noticed her duty belt on the couch, so I went and checked that. There was no firearm in there, and I observed like a gun case on a mantle. I opened that up, and there was no gun.
There was no gun. Did she say anything in response to that?
Yeah, she reiterated the guns were downstairs in the basement.
What happened next?
She went to gather some belongings for their son, and she came up and handed me the baby. He was screaming. I was trying to calm him down. I believe she gave me his bottle, and I was trying to feed him, but I thinking it can't be too comfortable. I wear an outer carrier vest, and I have all my equipment in the front, so it was kind of hard to cradle him.
Did you eventually hand the baby off to someone else?
I did. I believe Lieutenant Daley.
Now, if do you typically wear gloves when you're on duty?
I do.
Were you wearing gloves that day?
Yes, briefly for maybe like 10 minutes.
Okay. Did you take them off once you were in the house?
I did.
Now, did Miss Fitzsimmons leave the room at all?
While I was with the baby, yes. Lieutenant Daley and Officer Houston escorted her around. I think it may have been a kitchen area. I never went back there, so I just basically stayed in the family room with their son.
Okay. Did on a typical restraining order service, would you let a person who is the subject of the restraining order walk around the house unattended?
No.
At some point, did they come back?
Yes.
Okay. What happened after that?
I handed the baby off. I was standing in front of her stairs, and she had stated that she had clothes upstairs for the baby, so I handed the baby off.
And so did someone go upstairs?
Myself and Officer Houston.
Where did you go?
We, right at the top of the stairs, it's like it's a very small hallway. Right to the left is the baby's room. Right to the right is the main bedroom.
Okay. And so where did she go first?
To the left, to the baby's room.
And what did you observe?
I observed a crib. The back wall had bookshelves of sort, and there were just clothes on the ground.
Did you enter the room or did you stay on the outside?
I entered the room there.
Okay. What did you see the defendant doing, if anything?
She was wrapping up baby clothes, and she put him in a car seat. And then while she was doing that, I heard an older lady come in and start to yell at Lieutenant Daley.
Okay. Did that create any reaction from the defendant at all?
No. I asked her who that was downstairs, and she looked up and said she had no idea.
What happened next?
She handed me the baby seat and asked me to take it downstairs. And I told her no.
Okay. What did you do with it?
I put it on the ground. I said, we'll deal with that later.
What happened next?
She started packing a lot of books, and it's almost like this round basket with two handles. And I explained to her that her son's 4 months old. No need for all the books. You know, you're going to see him in 2 weeks. So.
What did she do with the books?
She handed me the basket and asked me to go downstairs, bring it downstairs.
And what did you do?
I mean, all of that goes squarely with what the defense is saying, that she was just like trying to get him to leave the room so she could be alone and hurt herself.
Yeah.
And I'm sorry, but I read 4-month-old babies' books.
Yeah. I mean, I think, so many people, have their little books, and I agree, people read their 4-month-old babies' books and start very young. And, your perspective, I think, is good. It's like it's clear she's saying, go downstairs. That goes to her intent. And like I said earlier, once a gun comes out, then it's a different story, in terms of, whether he's going to be held responsible, that, as I said, follows Graham v. Connor. But, he's been absolved of responsibility, which was under the constitutional law standard. That was the right decision, but that doesn't mean she wasn't suicidal. I mean, under the constitutional law, even if he was wrong in his reasoning, in other words, that she was going to commit suicide, that still doesn't change the dynamic under the constitutional law standard. An officer can be wrong in terms of their perception, but if the perception was reasonable based on the circumstances, then the officer is not going to be held responsible. So, I don't think, people should think of this as all or nothing. Either he's wrong and she's right, or he's right and she's wrong. They're two different things. He can be right and she can be right. He can be right and she can be not guilty, because you're looking at a criminal law standard as opposed to the reasonableness standard under which police officers are judged.
All right.
I told her we would deal with it later, and I put it down on the ground.
And you told her she'd see her son in 2 weeks?
Yeah, roughly. I said your next court date is on the 14th.
What happened after you put had that conversation with her and put the book carrier down?
At that point, Officer Houston had gone downstairs because of the commotion. So she said that she had to get more clothes out of her room. So I followed her into the room, but I never went in the room. I stayed on I guess the top landing, right before the door frame.
Where people, he's
And
about to
that's
describe the
into the
shooting,
bedroom.
if you haven't been
Yes.
paying
So
attention.
if you walk up the stairs, you had been in the room on the left, correct?
Yes,
Now she went across to the room on the right?
yes,
Okay. You said you didn't go into the room yourself.
no.
Were you able to see her?
Yeah, she was 3 feet in front of me.
Okay. And what was she doing?
She was wrapping up clothes, and she had paused, and she said something to the effect that these are dirty. And I said, listen, wherever the baby's going, I'm sure there's a washer and dryer.
Overruled.
I said, wherever the baby's going, most likely has a washer and dryer, so don't be concerned. And then I could tell she was getting upset. She started to shake, and I said, listen, court date is in 2 weeks. It'll be over before you know it.
Did something happen next?
Yes, she was on one knee when she was wrapping up the clothes, and she pushed off with her left foot and lunged behind the door frame. So to my left, to her right.
Okay. Could you see what was there from where you were?
Not from my perspective, no.
What happened after she went behind the door frame?
She reappeared with a gun and pointed it right at me and pulled the trigger.
Can you describe or show us how she did that?
Yep. So when she came around the frame here, she came up and clicked.
Okay. Where was it pointed?
My face.
After it clicked, what happened?
I screamed her name. I was completely shocked. She had the drop on me. She began to drop, which means she had the tactical advantage over me. I drew my weapon. She was already backpedaling, and she was doing what we call a tap rack. Basically, when you do a tap rack, that's when your gun malfunctions. So when you tap the magazine, you want to make sure it's properly seated in the magazine well, and then you rack the upper receiver or the slide.
Okay, I think the judge was writing. I'd like him to see this, if I could. If you could just, because you made some.
I'm trying to understand the lingo too. Is it a tap, wrap, like a?
Rack.
Rack.
Yes.
May he stand up so you can see what he's doing, Judge?
Yes.
So a tap, and a rack.
Okay. So tap on the bottom of the magazine?
Yes.
And a rack. Did she do that once or more than once?
She did it twice. So the first time she did it, it was slow motion. I could see her hand slide off the top of the receiver. She started moving her way around the bed, and she began tap racking again. And I was yelling at her, "Don't do it! Don't do it!"
And then what happened?
After she successfully got around in the chamber, her right arm started to come up, and I shot twice in rapid succession.
At her?
Yes.
Can you hold on one second, please? Yeah, all set, thank you.
What did you observe after you fired the second shot?
I saw her flinch. The gun went down, so I stopped shooting. She stopped her action, and then she went to the ground.
Where was she at this point?
On the opposite side of the bed, in between the wall and the bed.
What did you do next?
I covered down on her.
And what does that mean?
Right.
I kept my gun on her or in the area where she was because I couldn't really see all of her at that point.
What part of her could you see?
I think her legs, maybe. I don't really remember.
Okay. Did someone else appear at that time?
Lieutenant Daley.
Okay. And what did you see him do, if anything?
He came up, said, "Where's the gun?" I said, "She still has it. I'll cover you."
And so what happened?
We walked around the bed. I stayed lethal force on her. He rolled her and saw the gun.
Okay. Did you see the gun?
I did too.
What happened with the gun?
He put it on the bed and she was still conscious of where moving. I grabbed the gun. I moved it to the other side of the room.
What did you do next?
We immediately started first aid.
How so?
Putting pressure on the wound. We wanted to see if there was an exit wound, which there was. So we were trying to stop the bleeding. Officer Houston came running upstairs with a med kit. Lieutenant Daley started to wrap the wounds in gauze. And then Officer Karp came into the room and I ordered him to secure the weapon.
And did you see him do that?
I did.
Did you hear the defendant saying anything after she was on the ground?
It hurts. And I said, just keep breathing. You have a baby to live for.
What happened next?
The medics showed up, fire department, and we all got out of their way so they could start working Kelsey.
Did they transport her out?
Yes, they did.
Did you look for anything after she was removed from the house?
So before she was removed from the house, I walked out of the bedroom just to give them space. It was a very small room. There was a lot of stuff everywhere. Right to the right, there was some sort of, I don't know, end table where she lunged, and it looked like a wooden box of some sort, and the lid was open on that.
Did you look for any damage out in the hallway at all, or the other room?
When I got out into the hallway, the baby's room had a door with little glass panes. And we noticed, Officer Karp noticed it first. He said, this is damage. Did she get a round off on you? And I said, geez, maybe she did.
Okay, hold on. Sustained.
Did you notice the broken glass?
Yes, I did, but there was nothing on the floor. So
at some point, did you?
Excuse me 1 second. Broken glass, where was it?
So on the baby's room, there's a door. I believe it was on the baby's room, and it had little glass panes.
Right.
One of them was damaged, but there was no glass on the floor, Your Honor, so I chalked it up as old.
Why did you shoot twice?
She wouldn't stop.
Do you know if you hit her with the first one or the second one?
I didn't know. The second one, I could visibly see her flinch. The first one, no, she was still getting ready to raise her arm.
He has her getting ready to raise her arm on the second shot, but the arm was coming up on the first shot. And I think this is different. I thought the other officer said he pulled the gun, put it on the bed. So there's a couple little differences.
Yeah, there are some inconsistencies, but I do think I think he did say that the lieutenant came in and got the gun. I don't think he did say that he got the gun, but I'm not sure of that. I mean, there might be some minor inconsistencies, but I think generally his testimony is pretty credible until you hear cross-examination. And I also think if Kelsey testifies, you might hear something very different. But as I've said, he can be perfectly credible, and it still doesn't mean that her intent was different and that there will be evidence regarding her intent. He can be right, and there can still be a not guilty. But but his testimony, I mean, if I were the judge listening to it, he's a credible guy. Has had a long history, in criminal justice. He's done and served in a number of different capacities. He's been involved in SWAT, so he's been in urgent situations. And, he's in a situation here during a restraining order where they're removing the child, which is one of the highest known situations for potential lethality. So I think his testimony is pretty credible. I know people in the chat were like, well, I don't like him, and I think this is different and that different. I mean, that might be with a jury discussion, might be talking about those things, but this judge is purely looking at it as to whether or not the prosecution has made its case for assault, dangerous weapon.
But if the judge believes him that she was pointing it right in the barrel of his face and pulled the trigger, and she's going to get on the phone and stand and testify, like they said in opening, that she was holding that thing to her temple.
Yep.
The only answer is one of the two of you is lying. So how can you have they both right? But
I mean, I think, you're going to have to hear, I don't know what the forensic information showed. For example, they're talking about whether she initially triggered the gun, whether they can find that out, because that would not be in her favor if there was an initial attempt to shoot. If they can tell that there was more than one attempt other than, her on the second attempt bringing the gun to her head. I mean, I think you're right. It's going to be very hard to distinguish that. That's why I say he's a very credible witness, but you know what? She could be equally credible.
Right.
And again, the judge is going to have to look at the circumstances surrounding this, including the fact that she was already diagnosed with a mental health issue, had already been suffering from postpartum depression, and that this wouldn't be sort of an unusual kind of thing. When you look at other cases in Massachusetts, the nurse who worked at, I think, Mass General or the Brigham, and killed her 3 children during severe postpartum depression and then jumped out a window. She lived and she's completely paralyzed, and they're still going to charge her. But it's a statement about postpartum depression and what it can bring you to. So I don't think we've heard that evidence yet. I'm just saying, as far as the witnesses go, he didn't, it wasn't like the testimony of Justin, where he wanted to get things in,
Right.
I mean, he was honest. He's like, well, yeah, the glass was broken, but I didn't see any glass on the ground, so I didn't view it as she got a shot off.
Is it possible they might be done? This is their last witness?
I don't know if there's any kind of forensic or whatever, but it is possible they could be done very soon after cross-examination. This case could end very quickly. They've got a lot of witnesses today.
All right. So, and like the judge is saying, you can't really judge someone's credibility until you get through cross. They're supposed to come off pretty damn credible on direct.
Yeah, he did. He didn't exaggerate it. Whether he said those things, I don't know, but what he's saying, okay, it's only 14 days, and there will be evidence that that she put a basket together and that he put it on the floor because it will be so I don't know. I think you'll hear more evidence about what was. I don't think we've seen any evidence about what the scene was like after the shooting, so I think that piece is missing.
Okay.
Sir, I'm going to show you a number of pictures.
Sure.
I'll show you what's been marked as exhibit number 6. Do you recognize that?
I do.
Okay, what is that?
That's the front of the defendant's house and the door that we entered.
Show me exhibit number 10. Do you recognize what that is? Is that the front door?
Oh, yes, that's the front door. The stairs are right to the right, yeah.
Sure. Do you recognize what that is?
The stairs leading up, upstairs. So right to the right would be the master, and if you took a quick little left, the baby's room.
I'm going to show you, it's been marked as exhibit number 39. Is that the baby's room that you were talking about?
Yes.
Number 38. Recognize what that is?
The baby's room.
Is that the container, I guess you will, the books that you were talking about earlier at the bottom?
Oh, yes. Right there.
I'm going to show you what's been marked as exhibit number 49. Do you recognize what that is?
That would be the entrance going into the master.
Okay, into the bedroom?
Yes.
Let me show you what's been marked as exhibit number 51. Do you recognize what's in that photo?
That would be the box that was open to the left of the door frame.
Number 50. Do you recognize what that is?
Yes.
Where were you in relation to this picture? Where were you when you first observed Miss Fitzsimmons pull out the gun and aim it at your face?
Right before the door frame.
Okay, so you're backed up a little?
Yep. Okay. Probably right, whoever took that picture, probably right there.
And where were you in relation to the door frame when you shot your weapon?
I used part of the door frame as some sort of cover, and I was leaning up against it with both my hands. So my gun and my wrists would have been in the room.
Let me show you what's been marked as exhibit number.
Also, thank you.
Let me show you what's been marked as exhibit number 53. Do you recognize that?
I do.
Can you tell us, and Judge, if I may ask him to get down to point it out to you.
Okay.
Can you tell us where Miss Fitzsimmons was? If you may
point
to show the judge where Miss Fitzsimmons was when she first tap-racked it, if you can.
Right about here. And then she started sidestepping, and I was telling her not to do it. And I shot approximately right here when she finished.
So makes sense to stop for the day at this point. And we'll pick up at 9 a.m. tomorrow morning. And witnesses, the folks that are on the witness list should continue to follow my order and rule. And that is not to watch any of the other folks' testimony. And we will pick up tomorrow morning.
All right.
So let me ask you, because somebody asked in one of the supers about if you, as a judge, would you consider his demeanor? They were asking about Justin's, but I find it strange because the judge can't really see. I mean, I guess he can see the demeanor. I guess maybe he couldn't see his hands, but so, like he was barely blinking, or do you consider those kind of things?
Are you talking about Justin?
Yes.
Yeah. Well, demeanor and the way someone testifies in their tone, in their look, jurors, that's fair game in any trial. And, people talk a lot about that, like just in the Corey Richards trial, that, she never changed her expression. Should she have cried? Should there be tears? That's always a big issue. And yes, you can definitely consider, when, when I was doing bench trials, I'm looking straight at the defendant, so, and all kinds of things happen. When I was in a juvenile court, you could have a 17-year-old rolling his eyes, or, you might have, a girl who's 15 crying, or you have some people that don't change at all. You can consider it, but ultimately, I think you're basing it on what the person is saying and what you're hearing. With Justin's testimony, what would have been bothersome to me is the fact that he attempted to make the prosecution's case by saying things, that she was a danger and I wanted to protect my child, all of those things where he's trying to get a message to the judge. And to me, that I have to tell you, that's a message that would not go over. I would not be getting the message that he wanted to get to the judge. The message I would be getting is he has, he wants to say something. He had a plan here, and he wants to get the message out that he knew all along there was a danger. And then it's like, well, look, this gun, it wasn't in the basement and she had a gun. And so, his sort of, it comes across as, see, I was right all along, as opposed to, looking at it a different way. And was it you, Justin, who planted this image of her, saying she was a danger and that she couldn't have her child, and sort of implying that she was abusing the child and couldn't be anywhere near the child, and telling police that she was a risk, that she might hurt them, that she might kill the baby, that she might kill, that's the flip side of this. Did it escalate? Did it escalate because of Justin? And I don't think his testimony helped him in any way to sort of take away from that possibility, because there was a lot of testimony, by, earlier in the day that, I think someone testified, well, Justin told us, you could go in there, she could kill the baby, you're at risk. I mean, all that coming in, unfortunately, set the stage for a lethal encounter, because when Officer Noonan was in that room, he was in that room knowing what? He was in the room knowing Justin had said, we got a restraining order. He's in the room maybe knowing what's in the affidavit and what Justin said that nobody was able to counter because it was ex parte. He's in the room knowing that, Justin says, she might harm you, she might kill you, she might kill the baby. He was in the room already knowing that. So, the question becomes about his testimony, whether he was trying to sort of repair, the earlier testimony that he was sort of, playing this card, the card of violence. So, I mean, for me, I wasn't buying it. I thought he was just he knew what he wanted to say, and he was going to get it out one way or the other, whether it was stricken or not. Right. And that's how I viewed it.
Yeah, no. Any other takeaways from today?
I think one of the questions that was asked was to him was, would you normally let a person who you're serving a restraining order walk around the house, meaning they let Kelsey sort of walk here and go there? I thought that was an interesting question, because on cross, I hope the question is, would you normally let a civilian, who has already informed you that there's a high risk and that there's a danger, and just cross-examination, as you know, so they don't have to do it that way. What they have to say is, the truth is there any part, the way I would be asking that question if I was a lawyer, and, I don't know, people, people used to say I was kind of like a rabid lawyer, when it came to cross-examination, but I
can see it.
I think, the question would be, as is it within the department's policy to allow a civilian to come to the scene, where you are going to be removing a baby and where there's a restraining order? Is that in the policy? If it is, can you show me? Can you tell me where in the policy it is? Because you and I both know it's not in the policy.
Right.
So the question is, but the fact of the matter is you considered this a risk situation because you already knew that, because Justin told you that. But at the same time, you allowed 2 civilians to be there. So I think those are fair questions. And the reason I think those are fair questions is because you wonder whether or not they went into this sort of thinking she's the bad guy in all this and Justin's the good guy and we're going to do him right. And, and again, does it change my opinion about whether the officer had an objectively reasonable perception when the gun came out that he could use excessive force? I think that's why, as I've said many times, that's why he wasn't charged, and that's why it was deemed, to be an appropriate use of force. But that being said, there's just a lot of other elements here that are so bothersome, and I hope that the judge is bothered by them as well. That they sort of had this planned notion of, let's run to the probate court, let's get an order, let's put whatever we want in the affidavit because she can't challenge it, and let's hype everybody up saying she's dangerous, and look, this judge agrees with us, and hype everybody up, and at the same time bring civilians in, and then all of a sudden, the whole thing explodes. How much it helps, Kelsey, we'll see on cross-examination. But I find it disturbing, in many respects, the way this was handled, the way that there seemed to be violations of police policy about having a civilian. I mean, you probably know that in cases where they're responding to a domestic, and there might be, and there's concerns because there are guns, they oftentimes in Massachusetts will call the paramedics ahead of time and they say, you need to stage on Elm Street. We're going to be on Oak Street. We need you to stage on Elm Street. The whole purpose behind staging is to prevent civilians or other first responders from being at risk. And so how this will all play out in terms of the judge's mind, I'm just saying from a policy standpoint, I support the notion, that they didn't file charges against the officer based on the constitutional standard and his perception when the gun came out. But I have real questions about the accountability of the police department allowing civilians in, because we both know there's no policy and they go to great lengths to make sure paramedics and other people stage far away from the scene. In the meantime, you have Justin and his sister like downstairs. And the other thing, I don't know if you noticed this, but he said, well, I heard the guns. I heard him say, don't do it, meaning, where Justin's trying to get across, don't shoot or whatever. But does he know that because he already knows, what has been said publicly in the police reports, or did he hear it down in
from the basement? Right.
Yeah.
While he's already running and, whatever he was doing,
Yes.
and I just want to take the opportunity, like Maid of Question says, how did Justin get a hearing in family court within minutes of asking if it's really as backed up as everyone says? I've been wondering that. Well, first off, Maid of Questions, when you have an emergency hearing, which is what they did initially, you get in front of a judge right away. But I wanted to ask you, Judge Erskine, when there was a day in court last week, because I find it just appalling. I understand she was in jail for a while, so there's that period of time that doesn't count, but she's been out since the end of December. And how a mother isn't getting, at least I don't even know how the trial judge, even if even if we want to say everything else she did was right, which I'm assuming neither of us do think, but where was at least supervised visitation so that mother and baby have some form of contact? And how does it go this long? Because Bradl made a joke like, well, you know how family court, we could end up there in August. And then the judge retorts with, yeah, what year? August of what year?
Yeah.
So is it really that backed up?
Yeah, I mean, the thing is, in my court, like people would, that we had a number of judges, and judges would be assigned. So, we would say like Judge X would be in courtroom 3 in hearing motions, or they'd say Judge Erskine's in courtroom 4, and she would be hearing, maybe emergency petitions. So lots of times, the clerk magistrate would come to me and say, hey, look, we have an urgent situation, based on the affidavit. And this is an ex parte motion. I mean, in my case, in the thousands of child abuse cases I heard, and I did lots of family court cases as a lawyer, but people would say, Judge, a DCF worker's here, there's a child at risk. And they would say what the risk is. They'd come in with an ex parte motion saying, we have a child that has a fractured skull. The child's on the way to the hospital. We believe that it might have been. That case is going to come in first, even though there were some days I would hear 40 or 50 cases in a day, of like sort of triage kind of thing. So it becomes a kind of a triage, is it? And so, and let's say I was in a trial, the clerk magistrate, would say to the other judge, Erskine's in a trial. Can we have Judge X hear this emergency motion? So you can get an ex parte motion in pretty quickly. You have to say the right things to have that happen. Right. And so there's a difference actually between almost ex parte and what I would call emergency ex parte, because sometimes lawyers would say, I want an ex parte motion heard, and I want it heard right away. And I would say, well, what's your emergency? Well, something was said, the CASA worker went into the house and she has concerns. I'm like, that's not an emergency, and I'm not hearing an ex parte. Give everybody notice, and I'm not going to hear that unless you're telling me there's an emergency. That's how we got it in.
Right. It's kind of crazy.
Yeah, but I mean, it's rare. So in juvenile court, we did harassment orders. We objected to doing 209As or restraining orders because when I left in 2023, I was the first justice in my court. So I was the administrative justice. So I assigned judges to different courtrooms, but just not even counting our criminal cases and our runaways and sexually exploited children. When I left, there were 1,330 open child abuse and neglect cases. And there were only 3 or 4 other judges hearing them. And so, it's there's the kind of things that you have to hear. You have to be really careful about what you're going to hear in terms of what's an emergency ex parte thing, because you're putting all these other things aside. But but on every judge in Massachusetts, when the courts close at 4:30, there's lots of domestics. And there's the need for search warrants. And so when the court closes at 4:00, there are 8 judges on call, and they're assigned to different sectors of Massachusetts. It's divided into 8 sectors. So like every 7 or 8 months, they would send me this phone, this judicial response phone. And every night, from 4:30 until like 8 the next morning, I would have to take calls from police for people seeking a restraining order. Because if they go to a 209A or if they get a domestic violence call, they have to ask the victim, do you want a restraining order? And then on weekends, so it's like Friday night, the court's closed, and then the restraining order's in effect until Monday morning. So I did hundreds and hundreds of ex parte orders. And so basically, you're just hearing what's being said on the other end of the line. You're talking to an officer, and they were always, great about explaining it. And you're talking at times to the person who's filing it and asking questions, and then having to make the split-second decision at 3:00 in the morning if you're going to issue an ex parte order. But rarely, and that's only for a few days, someone would have to tell me something that would put a child at risk. For me to say, okay, and at the same time, I'm going to order custody of the children and no contact. Because I will say there were times when you had someone who was going to be having a visitation on Friday, and all of a sudden a restraining order would come in, even though the probate and family court had ordered visitation. And then someone saying, oh, there's this domestic violence case, I want you to stop the visitation. That's a hard thing to do when you're a judge. You don't know anything about the case, because there are people who manipulate the system. So I guess I'll answer the question that way. It's a long roundabout way.
And do you think that the judge in the criminal case with the bail should have allowed for, even if she believed everything Justin said and everything Noonan said, and Kelsey did exactly what they said, should have granted her supervised visitation, even if it was for an hour or 2 hours a day?
Yeah, I've spoken out a lot about this, and just recently on another podcast. Whenever a judge says you can't visit, you can't see your child, it effectively becomes a termination of parental rights, which requires clear and convincing evidence to basically sever the rights between a parent and child. I can't think of anything that was more disturbing and upsetting to me about this case when a judge on a bail hearing essentially usurps the authority of the probate and family court, because the restraining order was only in effect for 14 days. And then by then, Kelsey was in the hospital. But Justin got temporary custody. He filed it's called a paternity petition, because they weren't married. So he filed a regular custody petition in the family court. And in that custody petition, he essentially asked the court for temporary custody. And again, they sort of impounded all that information. So you really don't know what was said. But the judge gave him temporary custody, but there's nothing in that order, according to her lawyers, that said there would be no visits. So the no visits were happening as a result of the bail order. Well, I am going to say, if there was any time on a child abuse case where I gave custody to DCF that I was ever asked for a parent to have no contact with the child, in order for me to do that, I couldn't just make that decision. I actually had to find that there was harm to the child, that there was potential for abuse. And I very, very rarely would do that. It had to be extreme circumstances, because to cut off contact, and she was breastfeeding between a mother and child, outrageous in my view for a judge in that superior court. And she wasn't even the judge on this case, not only to revoke her release, which she did sua sponte on her own, because it was there on a motion for modification. And she not only revokes it and locks her up, saying this is a revocation, after testimony by the probation officer who said she's in full compliance, there's no revocation here. The judge gets angry and says, well, I find it anyway. And not only that, she can't see her child. Outrageous. I think it was an extreme violation of her constitutional rights, and to have a judge not allow visits. And, you have a judge on a bail in the probate and family court, in order for them to have done that, which wasn't done on the temporary custody. The judge has to make written findings, basically explaining what abuse was occurring, and that the child was either abused or at risk of abuse. They couldn't do that because there was no abuse. So the probate court did not order no visits. And I would have to write extensive findings that could be appealed on but the criminal court judge
just willy-nilly
just makes a decision and doesn't have to say why. I think the biggest violation of her rights occurred during that sua sponte, meaning on her own, revocation hearing. Not only where she held her, and how she treated the probation officer was unbelievable. She was angry at the probation officer. How dare he not take her side? And she filed a complaint against him, against the assistant chief probation officer.
Wow, that is so shocking, because we saw in the very last hearing where Judge Karp, that's his name, right? Judge Karp?
Yeah.
He allowed her to move out of her mother's home and get her own place. The probation officer said the same words, essentially. that were said in the other one. Well,
Yeah.
that there were like 2 calls where she didn't answer right away, but then she did, and it was fine, and she's 100% compliant. And then the judge is sort of like, yeah, well, sounds like she's 100% compliant. But
Yeah.
those same words were spoken in the other judge, and she's like, no,
Right.
that is a violation, and you don't get to decide what's compliant. I
No.
decide what's compliant.
Right. And they and it was, they filed a motion to recuse, and I talked a great deal about this on another podcast, because the motion to recuse basically said, first of all, she went into that courtroom and did the hearing, but she was assigned to a civil court. So they said she inserted herself into the hearing, and so they had an issue about that, and wanted to know why. And I asked this question. It's like, I assigned judges to different courtrooms. I didn't just walk into someone's courtroom and say, hey, I'm going to hear this criminal case because I want to hear it. It just doesn't work that way. And then, what was really concerning about the recusal, aside from the fact that she did that, were the other allegations they made about this judge, because first of all, it was a motion to modify, and then she turned it into a revocation hearing, and they wanted to put the email from the probation officer in, and the judge like, that's hearsay. Well, under Massachusetts law, that's not hearsay in a revocation hearing, because hearsay is admissible. And then she looks to the prosecutor and says, well, what do you want to say? I think the hope in the prosecutor would believe her, right? But what does he say? He's like, I'm not putting my, my license on the line. So what does he say? He says, well, Judge, the probation officer is right here. And so the probation officer stands up and says, she can't blow into the scram because guess what? She had a bullet in her lungs and she has fractured ribs from this, and she can't blow into it. And the probation officer says, I watched her myself, and she did the best she could, but it's very difficult and it causes her a lot of pain. So he agreed that they should modify it to let her do like urine screens or whatever. Judge was furious. But what they say in their recusal motion is she went to see him the day before to kind of get him to convince him that, Kelsey was violating.
The judge did?
Yes.
I forgot about that.
She's been accused of ex parte conversations with the probation, or extrajudicial conversations with the probation officer. And then when he didn't say what she wanted to, she filed a complaint, which would go to the Commission of Probation, which is
like her trying to force him, and then retribution for not doing what she wants.
And then he had to hire a lawyer. And of course, all of that was going to come out in the recusal motion. And what happened just before all that was going to be heard, the Chief Justice of the entire Superior Court says, oh, she's been assigned to another court, and that was already predetermined, so she's not going to hear it anyway. So the motion
is moot.
Is moot. I mean
that stunk from high holy heaven. And this judge went out of his way also at that last hearing when he granted Kelsey the permission to leave mom's house and get her his own place. He went out of his way to say he agreed with all the prior rulings of the other judge, and he would have made those same rulings.
Yeah.
But today I'm making a different one.
But today everything's okay, and she can visit her child. Again, in my view, and people don't like it when I say this about the courts, because I work for the Massachusetts trial court, just like any Superior Court judge, just in a different court. But people don't like when I say things, where I view that the court was unfair. But, to me, this the very premise of the judiciary is they have to be fair. And I think everybody, I think that they made such a strong case in the motion to recuse that, because the person who assigns judges in the Superior Court is what's called a RAJ, a regional administrative justice. But that's not the person that issued the public statement. It was the Chief Justice of the entire Superior Court for the whole state that says, oh, I in 20 years on the bench, over 20 years, never once did my Chief Justice, who was the Chief Justice for the whole state, say, this is moot, and, I'm going to assign a judge to a different court. That never happened in over 20 years. So it's hard not to think that there's something fishy about this. And of course, that's what the motion to recuse says. Something's not right. So the current judge now, he gets on the bench I think it's naive for anybody to think that there weren't conversations about this at a higher level about how they were going to handle this. I mean, the optics were so incredibly bad that the Chief Justice is stepping in. So, yeah, was I surprised when the judge said, even though I agree, in my head, I'm saying, even though I agreed with the judge that stepped in, reported the probation officer, and wasn't supposed to be in that courtroom, even though I agree with everything she did, including stopping visits without saying why. Now everything seems to be okay. Kelsey seems to have improved a great deal. So now she can be around her child. She's not abusive. And I also think it was interesting. So did you listen to the waiver when she did the waiver?
Yes.
And he asked her questions. What did he say? I find that she's made a knowing, voluntary, and intelligent waiver of her right to a jury trial, and that there is nothing that is really impeding her understanding of that right, not even, mental illness or medication, nothing in the way. So now they declare that she's so competent and that there's no mental illness there. She's so competent that she can knowingly and intelligently waive her right to a trial. Yet, just a short time ago, months
The day
earlier,
before.
yeah, yeah. Just a short time ago, she wasn't incompetent. I mean, I know that's sort of off the trial today, but
Right. No.
those are things that I think are worrisome, and I think it basically really undermines the public's perception in the judiciary. That's what they argued in the motion. They said, the judicial rules of conduct make clear, that this particular issue, it really undermines the public's perception of a judiciary that's fair. And I think that clearly happened. And I think, I think there was never, ever going to be a hearing on that motion to recuse. It was just easier to say, oh, she has been reassigned, and she was reassigned the whole time. And you know what? And the time has passed, and now she's clear. I mean, people can believe that if they want, and maybe it's true. But that's not what the motion to recuse said. And I think they made a very powerful argument. So that's that. It's been a pleasure to be with you, by the way.
We are so grateful to have had you. I was like, I have to get all my questions in case we never see her again.
I'll pop in later in the week if that's okay.
No, that is absolutely okay. We would absolutely love it. I know Bob's dying to get some time with you as well. So we greatly appreciate it, and your insight is invaluable, obviously. I'll let you go, and I'll get to our wheel and all our supers, and we will be happy to see you anytime you're willing to come back.
Yeah, I'll send a message out, when I'm available. I think I've got some things I have to be at in the morning, but I'm definitely going to be listening to the cross exam. So maybe we can, hook up at some point during the day at the break or whatever.
Absolutely.
But really, it's been a pleasure, and thanks for inviting me. Really,
thanks for coming.
I want to thank all your chat people, lovely people. Thank you so much. Many of them mentioned my child advocacy in the Harmony Montgomery case, which I appreciate. I saw, some of those messages, so I thank them for that. But I thought the questions that they asked were, really good, and I enjoyed seeing what I could see in the chat. Seemed like a lot of lovely people. So we'll talk again.
All right. Thank you. See you soon.
Bye-bye.
Wasn't that awesome, guys? That is so awesome. All right, so here's what I have decided to do, because we have the wheel ready. I'm going to do the wheel, and then I'm going to go through the stickers. I also have the people who did Venmos and whatnot. But this is crazy. I don't think I'm in the right kind of wheel. It made two wheels. It made like one really big wheel and one really small wheel. And wait, I don't know what this other wheel is. This wheel's gone. How do I get rid of it? This is like a practice wheel or something. Wheel 2. Oh, remove wheel 2. Okay. All right. So I also want to make sure there's not like a strike. So I'm not going to add any music. We'll leave that kind of thing to Bob. Oh, here we do it like this. Yeah. Share this tab. and then we'll go through it. Because I know a lot of times people leave and then they don't see the wheel and they don't know they've won. So we're going to do it first. That's what I'm going to do. All right. Dun, 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 dun. Oh, there. See, we just got that noise. That's all right. Ah, Kelsey Rankin, you have won yourself 15 minutes on with us. It could be tomorrow's lunch. You can say, I want to come during verdict watch. I want to come whatever day you want to come, whenever you want to come. And also DB and Yellow Jackets as well. So, yeah. So leave that up there in case you come back. And I'm going to get back to you guys' questions if I can remember where we left off. And you guys are all amazing. I think even exceeded 50. So pretty awesome. All right. Bragging rights over Bob. I saw that. Bloop bloop. Let's see. Justice for Kelsey. Limpy gold. All right. I think this is about where we. Okay. So, and I might have done Bluebell. I think I did. That I think it was a mistake to have a bench trial. Well, we just saw, like with the testimony of the sister and Justin, just how squirmy they would have been, just the kind of shit they would have snuck in and contaminated a jury with, that makes you say, all right, now maybe we really did have to do, a judge. And oh yeah, we did do this whammy burgers about all the poor trapped zoo animals. Yeah, and poor zoo guys. We got spoiled scrapper. I'm not sure if I said welcome, but if not, welcome. Family hug. Oh yeah, I definitely got Pammy C because Pammy MC. We do need a badge. Is that like a real thing, guys? Because I don't know. And then Sharon T. I don't know why that says for 6 months, because I don't know, maybe you have only been a member 6 months. It seems like longer. Me too. Haha, 20 months less. That's all right. Thank you for your continued support. Yes, Tiff Knox, you are close to 2 years. Thanks for your continued support. Lily B says, happy to be watching this trial with my DD fam. Love you, Allie and Bob. We love you too. Shannon says, see, what happened was, had one of them sudden guts of gravity. Yeah, right? For sure. What happened was, Pammy, thanks. 13 to go for the goal. This is the only available name. Love it. Runs away with his baby in the house. Gross. I mean, and just to clear that up, the baby had left the house already, but I understand the confusion there. But still, he's tripping over himself to get away. And yes, I put that up twice to make sure that Judge Erskine saw it. Ain't so plain Jane says Judge Erskine is a badass. Laura said, I love this judge. Buttercup, new member. Welcome. Family hug. All right. Bob Ross says, behind. Why law enforcement surprised at incident reporting officer alleges she hurt the baby. Law enforcement's explanation with Kelsey Fitzsimmons didn't support reporting officers. Kelsey Fitzsimmons' state of mind, a mess because RO is BS. Well, yeah. And is RO reporting officer in this RO or? Yeah. I mean, it's got to be. Okay. At Fort Dread says they're letting these people fabricate a story that's irrelevant to what happened. But how was he too injured to be discharged from the army, but he's able to body enough to save lives in the fire department? Yeah. What the hell was that? Like, which is it, buddy? Which is it? Boris says, I got to that one. Thank you, Boris. Girl Ryan says, I really don't have anything profound to contribute. I figured I'd help out the goal, but listening to him is about watching paint dry. Thanks, ladies. So that's, oh, wait, I gotta, so I have Bob sent me screenshots from the Venmos and the Zells that they were added to the wheel. Wait, babe. But was it an email? Where is it? I saw the screenshots, but then I think I can actually access it. Oh, got Mark Cunningham. Allie setting the bar high. LFG. Pam. I don't know if I'm supposed to say your guys' last name, though. Said road trip snacks. It's $20. Okay, here we go. We've got, I'm just going to say first names because I'm not sure. Costanza. Fitzsimmons trial. Thank you. Gave $10. Thank you. Leslie gave us $20 because you guys are the best. Free Kelsey. LMC. Oh, this is from LMC Cali Girl. Thank you. Thank you. Kim M. I saw your wheel on the name, your name on the wheel twice. You're so close, I think, to getting picked. I think you're like right there behind Kelsey. Said, happy Monday, Allie. Thank you. Have a great weekend. And then Kelsey, who is our winner, said, donation for beating Bob. Thanks for all you do. Love you both. We love you too. That's the same one. And then we got Catherine L. Great job, guys. Oh, big $75 donation. Thank you. Thank you. And I think that is it. But if there are more that came in after we did this, we'll get you tomorrow. We'll figure it out. We'll thank you. I thank you guys so much for being here, making it easy for me to do this on my own without Bob, because those of you who know, I kind of hate it. Kind of hate having to do it alone. Definitely hate my giant face on the screen. So we're going to have to end this now anyway. But thank you all. Thank you, mods. I'm so glad that we had such a big crowd today. And I hope you guys are finding it good in our chat, since it's smaller than some of the other big chats, that at least you're getting heard, you're getting seen, you can get your voice in there. And, nowhere else are you going to get this, at least I hope nowhere else. Massachusetts judge to give us an opinion along the way and chime in and give us all the Massachusetts inside scoop. But I appreciate all of you. Hopefully I didn't miss anybody's. I think I got everybody. And again, thanks mods, thanks Tracy, and thanks all of you. And we will see you tomorrow. Oh, before I forget, Afro Man Live. We've got our Afro Man. We've got the Afro Man's lawyer. We've got a juror. I think we might have more than one juror, but we at least have one juror. That is tomorrow after the Fitzsimmons. So don't miss it. Don't miss it. Don't miss it. All right. Thanks. Bye, guys.